Check, check. people who feel they need.
Good morning, everyone. We're going to bring to order today's public hearing. We have a robust agenda about, what do we got? We have 50 people signed up to testify before us today, a number of hot topic issues that have been before this committee for a few years. We've got the first hour reserved for public officials. After that, we'll alternate between members of the general public. We'll try to move quickly today. The public hearing, again, for the public, to weigh in on a lot of issues before the General Assembly for the upcoming year. So with that, any opening remarks from my co-chair?
No. Looking forward to the hearing.
Representative Tiglath?
I would like to ensure everyone that all of us have read all the written testimony, and we're really aware of most of your positions. So if you want to combine who's testifying, it would be greatly appreciated.
Yes, thank you very much. It's a great point. People often underestimate the importance of written testimony. Avails the committee an opportunity to revisit these issues over the next few months. So folks who care passionately about an issue, you can't make it up here to Hartford, or it takes too much out of your day, just submit written testimony. It works just as well as in person. With that, we're going to start off today with Commissioner O'Keefe. I don't see him.
I'm here, Chairman Lamar. Can you hear me?
Terrific. Thank you so much, Commissioner. Good to see you today.
Great. Sorry to not be there in person. To say I'm out of state right now doesn't quite do it justice. I'm dialing in from India. But I appreciate the opportunity to submit testimony. I did submit testimony in writing. And given I did testify in front of this committee just last week on this topic, I'm going to try to be brief here. But I do want to say thank you to Chairs Maroney and Lamar, Ranking Members Ciccarella and Rutigliano, and members of the General Law Committee. As mentioned, my name is Dan O'Keefe. I serve as Commissioner of the Department of Economic and Community Development and also as the state's Chief Innovation Officer. So I appreciate the opportunity to submit this testimony on Senate Bill 2, an act concerning artificial intelligence. While I did testify on this last week and around the governor's artificial intelligence bill, I do believe that artificial intelligence represents one of the largest, if not the largest, this is not hyperbole, opportunities for our economy. So all of this bears repeating. I do believe we are in the early innings of a technology revolution, a truly broad economic transformation that will prove even more consequential than the Industrial Revolution. So effectively managing that kind of technology transition requires balancing safeguards and strategic investments to ensure that our populace can take advantage of the opportunities that emerge. I believe it is possible to ensure Connecticut's continued competitive advantage while also simultaneously strengthening our existing guardrails without creating a new class of regulation that ultimately runs the risk of suppressing innovation rather than enabling it. The economic development components of this bill I broadly support. I applaud Senator Maroney for his early leadership here. And I will commit, and the DECD will commit to partnering on those economic development elements, as long as clearly they're paired with requisite resources. My issue, however, is with the bill's regulatory components. Sections 1 through 10 of Senate Bill 2 create a new and complex statutory requirements governing the use of AI systems. We appreciate the intent to protect consumers, but being early in regulating a rapidly evolving emerging category with significant economic potential presents its own risks. Rather than being a state that welcomes and supports innovation, we become the only state in the region that resists it. Connecticut's existing non-discrimination laws have been carefully crafted over the course of multiple decades and the work of multiple consecutive legislatures to prevent discrimination. A new regulation cannot replicate or adequately replace the existing corpus of Connecticut non-discrimination statutes. AI does not make the illegal legal. The governor has introduced a bill to clarify this very point. The governor's proposed AI legislation, Senate Bill 1249, seeks to address these concerns by amending the Connecticut Unfair Trade Practices Act to state clearly that the use of AI is not a defense or omission to a claim of discrimination. The bill also proposes making state data available in a privacy-controlled manner to properly train AI to reduce the risk of algorithmic discrimination. Lastly, I do believe that the regulatory components of this bill, if enacted, would create a chilling effect. Compliance with the new regulations proposed by this bill would cost innovative companies substantial amounts of time and resources and would constitute an especially prohibitive barrier for those considering establishing operations in Connecticut. We should avoid a state-by-state approach to regulation. Federal action would be preferred, but based on recent remarks by the Vice President, I think we all agree that is unlikely. So given that, a regional approach should be our goal, working to ensure a common standard to create a uniform, predictable playing field for fair competition and innovation. Senator Maroney said in the earlier press conference that in the absence of federal action, it's incumbent on states to work together, and I agree. My issue is with a state-by-state patchwork of regulations. So in closing, AI represents a new wave of innovation that has the potential to dramatically increase human productivity and accelerate economic growth. It will revolutionize many of Connecticut's most important industries. It is vitally important that we get the balance right between enabling its development while simultaneously training our workforce to take advantage of that potential. In that spirit, I would request your support for the governor's proposed AI legislation, Senate Bill 1249, and to remove the regulatory elements proposed here, sections 1 through 10, while supporting its economic development components. Thank you for the time and the consideration, and I would welcome any questions that you might have.
Thank you, Commissioner, for your testimony here today and for helping spearhead the governor's thoughts on AI regulation here in Connecticut. I do appreciate the time and effort that you've put into this issue over the last few months and years. And I know the state benefits from the engagement among my Senate co-chair, Senator Maroney, the governor's office, and so many folks who recognize the opportunity that AI provides for both economic development and advancement of technology and healthcare options and in so many other fields. You referenced this being the biggest potential economic development transformation since Industrial Revolution. I think that's a widely held feeling about the moment that we're in and the opportunities that are inherent in this field. And so I think it's an important area that this committee has led on for a couple of years. I'm benefited greatly by having the person sitting to my left in this room, Senator Maroney, be considered one of the national leaders and experts on this issue. So with that, I'm going to turn it over to him. Senator Maroney.
Hi, Commissioner O'Keefe. Thank you for coming to testify before us today. I think I had already asked you this, but you want to rely on the Unfair Trade Practices Act. Is that correct?
I think it's one component of clarifying that existing rules and regulations persist and apply regardless of whether AI is used as a tool.
Now, do you think there should be any regulations, I guess, in regards to AI on any area of state industry?
So I'm the way I would describe it broadly is I'm not anti-regulation. I don't think, I think this is an area where we should be thoughtful. I think at times governments can be too early in regulating and not get it right. I'll give you a very practical example. It's in a different industry, but we were very early in regulating the environmental remediation requirements for property transfers. We were one of the first, perhaps even the first state to put in place the Transfer Act. But after that, every other state in the country, other than one other, went towards a more modern approach, a release-based standard. We have been working, I believe it's now for 5 years, to try to move from the Transfer Act to a release-based approach. And that's a bill up for consideration for this session as well. My point here is, when you start too early, and I'm proud of leadership, but at times too early means you actually got it wrong, and you build up a massive regulatory body and an industry effectively that is supported by that early regulatory approach, and then it makes it very hard to evolve. I think we're too early here. We're a state that represents 1% of the US population. It is super unclear to me why Connecticut should be the only state in the region, the first state in the region, only the second beyond Colorado and some of the other states you've mentioned that have implemented pieces of this. It's just super unclear to me why we want to be that early when my view, and I know you share this because a big portion of the bill is focused on economic development. I think our focus for now should be on the economic development elements of this, the workforce training elements of this. And let's be thoughtful as we understand what the impact is of AI before we attempt to regulate it. My concern is right now, we're attempting to regulate fear of the unknown. And I think what we should do is be patient, watch how this develops. And then if in fact there are developments that aren't already illegal, and we haven't clarified that they are in fact illegal, then we put in place a regional approach to regulation, not a state-by-state patchwork.
Okay. I'd have to just bring up, you're saying we're attempting to regulate fear of the unknown. We're actually looking at regulating known risks, right? I think there have been bills proposed across the country that are the catastrophic risks, that are the large language models, and we're not taking that approach. We're looking at regulating for algorithmic discrimination, algorithmic harms, examples of which go back more than a decade. And actually, some of the pieces of this bill come from a bill that was passed in 1970, the Fair Credit Reporting Act. And so last week, you both said AI was new and not new, right? And so I guess just looking back at what we already regulate AI for state government use. So I'm just wondering why in 2023 it wasn't too early to regulate AI for state government use. We regulate AI in insurance. February of 2024, we passed the NAICS Model Bulletin, which clarifies how CUIPA, the Connecticut Uniform Insurance Practices Act, applies to AI. So I don't know if those were too early, and when in a technological revolution it does become the time to regulate, because I think a
Yeah.
lot of people now look back at social media, and say, we wish we had done something then.
Right. So let me first explain the new and not new, because you're absolutely right. But by the not new, what I'm referring to is I spent the 25 years prior to coming into state service as a technology investor. Machine learning, neural networks, the underpinnings of artificial intelligence have been around for 20 years. That is not new. What is new is generative AI and the consumer awareness of the power of AI. That's the moment at which we started to see consumer awareness, some of the rising of concerns that perhaps there could be an economic dislocation created by artificial intelligence. And that's when we saw the interest in regulatory intent. I will tell you, I think that decision around state government was made before I joined state government, but I do think that was too early. I am not allowed to use AI in my day-to-day work. How do you do that when you use Microsoft products and Google products every day? It's an example of saying, we said, okay, there's a concern here, let's stop and not use it, versus saying, okay, what are the ways this can actually enable us? I take a slightly different approach, I think, in view of the world, which is, I don't think anyone is sitting around wondering how they can leverage AI to discriminate algorithmically or otherwise. I think what folks are trying to do is find ways to use it in ways to make ourselves more productive and to create jobs and ultimately economic growth. And so what I worry about is when we come into something early and saying, okay, we don't quite understand this yet, but rather than wait and see how it develops, we're going to early regulate and say you can't do certain things, and do it in a way that is not creating a uniform, predictable, stable environment for competition, that we end up having that chilling effect. We see a suppression of economic creativity. We see a suppression of innovation. And as a state, we put ourselves in the state of Connecticut as sending a message that says, because we don't understand this yet, you can't innovate here. You can't take risk here. Even though I fundamentally believe people are trying to take risk for good, not for harm. And so that's all I'm saying is I think you can be too early in these things. I think we're too early here. I'm not anti-regulation. I just think we need to be thoughtful about how we approach the effort.
So just so you're aware, because it happened before you were in state government, we actually passed our first task force to look at automated decision-making in 2022, prior to the launch of ChatGPT. So while it is new to a lot of people, it's not new to this committee, and
Yeah,
not
I'm aware.
to Connecticut state government. So we have been working on this for a while. Have you, in terms of relying on CUPPA, have you reviewed the Oregon Attorney General or the New Jersey Attorney General or the Massachusetts Attorney General's opinions on how the Uniform Trade Practices Act and the laws against discrimination apply to AI?
I have not, although I did ask the Attorney General to review and potentially, at his discretion, opine on those same issues.
Okay, and so I'll just let you know what they said. In Oregon, they said there's an affirmative duty to disclose if you're using AI. Oregon has a Data Privacy Act that's based on our Data Privacy Act. Again, we were the fifth for that. Other states that have followed us. So that they said from their Data Privacy Act, you have the right to opt out of profiling. New Jersey has said that in order to stay in compliance with their laws against discrimination, if you are using AI for making important decisions. You need to do testing to make sure it's not biased, and ongoing assessments because of model drift, because things change, which is basically what we're saying in this bill. Now, the big difference is in the proposed bill you referenced before, 1249, where you're relying on CUPPA, you're saying AI is not a defense, which means that, so if you're a user and you're required for, I have two lines of questions here. One, it's saying if you're a user, you can't, and you ended up discriminating because you used an AI product and you didn't know it was discriminatory, you're liable, the developer is not liable. And then it relies on CUTPA, which has a private right of action. So you're allowing for a private right of action against Connecticut small businesses without giving them a defense. So now my question is, if we're saying it's implied, so rather than explicitly telling you what you need to do to comply with the law, we're saying it's implied that you need to do these things or you can be sued. How are they going to get the data or the tools, the information from the developers of the models to do the testing that they would need to comply with the law if the law is not to comply with CUTPA, if there's no law compelling developers to share that information with the small businesses?
Look, first of all, I think there's nuances to be worked out in terms of how this is deployed and executed. Here's what I would say to you. What I think would be a mistake is a regulatory standard which says if you use a certain tool to do something that is illegal, the simple act of it being illegal is not enough. You now have a burden to disclose, to send information, et cetera, et cetera. That to me, you have to understand how fundamental I view the emergence of artificial intelligence in terms of our technology fabric. That to me is like saying, if a decision was made and you used Excel to make it, if a decision was made and you used your cell phone to make it, if a decision was made and you used the internet to make it, you have to disclose all of this information. I'll give you a real world example. There are employers in the state that have been using automated decisioning. That's a broadly defined term, but to make decisions in down selecting candidates, right? So 10,000 people apply for a job based on the profile of what that company is looking for, and based on the information that is supplied, they down select to a certain number of candidates to actually see them in person. If we were to create a regulatory standard that said, in that down selecting process, you now can say, send me the data that you used to make it, tell me exactly how you made it. Imagine if 9,900 people were able to now do that. There would not be a single employer in the state of Connecticut that couldn't simply keep up with that. I'm using that as an extreme example just to show the kind of unintended consequences here if we're not deeply thoughtful, and by the way, frankly, patient, seeing how this space evolves to deploy a regulatory standard that is achievable for our employers and ultimately protects our consumers. I think we're too early to understand those unintended consequences.
Thanks, Steve. And I would just point you to the definition of high-risk artificial intelligence system, where it says
I've read
it's
it.
not an Excel spreadsheet. I know you like to reference that a lot, but it is.
I like to reference it to make a point. I've read the bill. I've read that definition. What I'm saying to you is the types of tools that this is so foundational that simply trying to list types of things that don't apply is actually impossible, because it's the types of things that are in everyday life every time we make these decisions. It is that ubiquitous.
So I have questions. You mentioned that you spent decades as a tech investor, correct?
Correct.
And how, I just have questions on how that works, in like, how do you guys generate a return as a tech investor, right? So you invest, it's almost like you're identifying companies that you think are going to succeed, and then you at some point sell out your share in that company. And so the return, are you paid on a multiple of earnings, how is that? My understanding is you would get some multiple of the earnings of the company is how you would exit.
So the way that industry works, my former industry, is you invest in a company whose prospects you do think are positive. That company goes on to hopefully grow. By the way, the companies I invested in created tens of thousands of new jobs. And then, yes, if it is successful, the company would either sell or go public. And oftentimes that exit is based on a multiple of earnings.
Multiple of earnings. And so additional costs would then reduce that multiple of earnings, right?
Any additional cost would reduce earnings and therefore reduce, I wouldn't necessarily reduce the multiple, but it could.
Okay. I guess another question I have is, when is it necessary to update laws, right? And I think you you say you don't want to, or not. How should I phrase this? You think it's too early, right here, to regulate. And one thing I'll point out is, you say there are existing laws, so there are things that are already illegal, but at one point those things weren't illegal, right? Until we had the Civil Rights Act, it wasn't illegal to discriminate. When I was younger, until there were lots of drunk driving crashes, it wasn't illegal to drink and drive. Throughout history, there have been harms that weren't illegal until we passed a law, right?
Yeah.
And I think one of the things is, if we're going to rely on the courts, right? If we're going to leave this, and again, through CUPPA, through the courts for suing, we're kind of, in some ways, abdicating our responsibility as legislators. We're going to allow the courts to create the laws of how AI can be used. But I'm just wondering, when does it become time to pass a law? Because what is, well, yeah.
My general view, and by the way, I don't think we're abdicating. I'm not suggesting the legislature abdicate their role in creating laws. What I'm suggesting is we update existing laws to reflect this technological development. When do I think a law or regulation is required? Is when we've been able to understand the risk associated. And what I'm struggling with is thinking of and understanding examples where something that is already illegal is no longer illegal because AI was leveraged as a tool in the process of the illegal act. And where that is the case, what I think the governor's bill is suggesting, what I am suggesting, is let's update existing laws. Again, AI does not make the illegal legal, and not create an incremental regulatory burden early in what is a large economic opportunity. You were asking questions about my prior world and its compensation model. So let's be super clear about my motivation here. I retired from that world to come into public service. My role here is as a steward of our continued economic development. My sole focus here is to suggest that we not sacrifice our state's opportunity to play a unique role in what I think is a defining moment of economic acceleration by being one of the first states in the country to say, no, we don't want that here. Now, look, I know that's not your intent, Senator. You and I have spent a lot of time together talking about the economic development opportunity here. I am in such harmonious support of investing in what I refer to affectionately as the back half of this bill. It's just sections 1 through 10 where I am concerned about the limiting impact it could have on that continued economic progression.
Yeah, and I mean, and to imply, and I hope that no one thought that, I was just trying to get the background information on that. So I apologize if you felt that was implying it was for your personal benefit. I know you had left. You are working harder, I think, than you did in your previous world for significantly less money, try to make a difference. So we do appreciate that effort. I guess onto the workforce development. I know we agree on that. I just want to point out, in your testimony, your written testimony, you do point out that, in any technological revolution, more jobs are created than have been lost, right? And we've seen that throughout in all of these different cycles, right? More jobs end up being created. But one of the things that we need to be cognizant of, that the jobs that are created aren't exactly the same as the jobs that were lost. There are people who are going to lose their jobs, and this isn't being done out of fear. This is being done out of forethought, recognizing that, Bureau of Economic Research study, 1/3 of women are in jobs that are at risk of being automated by AI, only 1/5 of men. Half of gateway jobs are at risk of being automated by AI. As a state, we need to be intentional and thoughtful about providing outreach and training opportunities to make sure that everyone has the opportunity to succeed. And so I appreciate that you support the efforts for the outreach and the training.
Can I clarify one point on that, Senator? You said, I said more jobs are created than lost. That is true, but over the long term. So I do want to be clear, when there are these waves of innovation, oftentimes, and by the way, I do think this is going to be the case here, there is a shorter term economic dislocation. What I worry about is that the initial reaction to that dislocation can be resistance and can we slow this down? And that never works. If an economic innovation, sorry, if a technology innovation creates higher degrees of productivity, it will always eventually spread ubiquitously. So resisting the development actually renders our workforce less competitive globally versus accepting that it's going to happen and getting in front of it. So I only want to bring up that nuance because I actually am concerned about an economic dislocation in the short term from artificial intelligence. And I agree with you wholeheartedly that we need to get in front of that. And I know through some of your work and through some of our work, we are.
Right. And we also want to get in front of the harms as well, because we've seen them happen before.
But Senator, what can we talk about harms that are uniquely created by AI that aren't already illegal? That's what I am struggling with understanding. And sorry, I'm not here to ask you questions, so I apologize, and that's probably a break in decorum, but I'm just trying to understand. I do think we should update our corpus of existing law to make it very clear that that which is illegal remains illegal. So if there are harms that are potentially created uniquely by AI that aren't already illegal, that would expand my thinking personally on what I would think we'd want to get in front of from a regulatory perspective.
Right. I think one of the issues, because of the black box, there's a few issues, right? One is because of the black box nature of AI, it's hard to know if it's discriminating unless you're requiring explanation and transparency that went into the decision. Two is the scalability, right? In that if you have one person discriminating at one company, that's one thing. If you have 80 to 88% of companies using a program that, because it's not transparent, they don't know that it's discriminating, that's a much larger scale, right? So speed and scale are issues. There's also the issue that there are, and this comes from the bipartisan AI task force that Congress released, there are issues that are harmful but not illegal, right? And so we need to test for those. And so I think last time we went through the 4/5 example of how you determine if there's a disparate impact. And, I shared the Lehigh article where, if you were white and you had a 640 credit score using this program, you had a 95% chance of getting approved for your mortgage. But if you were black and had a 640 credit score, you only had an 80% chance of getting approved for the mortgage. Technically, that's not illegal because the 4/5 rule says that 4/5 of the 95%, which would mean as long as more than 76% of any other group were approved, it's not a disparate impact. But I don't think anyone in this room would say we want a program that is going to discriminate in that way. Even though it's not illegal, that is harmful. The difference of discrimination in AI and a person is that if an algorithm is discriminating, you can definitively test for it. But more importantly, if you test for it and find it, you can fix it. And that's all we want to do, is we just want to say, I want to see AI adopted. I'm in the 10% of the people who are more optimistic about the future with AI than are more concerned, whereas more than half the population is more concerned about the future with AI than they are optimistic. But in order for us to yield that full potential that we both see coming, we need to make sure that people feel safe. And that's my issue.
Yeah. And as you know, I believe every time there's an innovation like this, there is that concern. I would suggest we not regulate fear, we regulate outcomes. What you just described is, to me, you can look at those outcomes, and even if they're not illegal but are not optimal, and retrain algorithms, retrain AI to be less discriminatory. I believe that when properly trained, AI will be less discriminatory than a human, because humans are still subject to the subjectivity of, biases that exist in our culture, as unfortunate as they are. So I actually take that optimistic view. I would just rather we focus our time on making data available and then focusing on outcomes and that which is either already illegal or frankly making it illegal if it's not, if in fact that's what's better for society.
And so agreed, but who is going to make people retrain their algorithms if it's not the law? How are they going to know if there's no data transparency? How are we going to know they're using representative data sets? So we agree on a lot of things. We just need to work through some of these details. So thank you, Commissioner.
Thank you, Senator. I'm just going to highlight a few things. We have a number of folks with questions. I'm going to highlight, and you referenced in your testimony and in conversation with Senator Maroney, what likely won't get a lot of attention today, but I think are really exciting aspects of SB2, which are sections 11 through 27. Again, this you indicated support for. It would require DCD, the Chief Data Officer, to create and administer an AI regulatory sandbox program. You seem supportive of that. Would require Board of Regents to work together with Department of Labor, workforce investment boards to create AI academies in our state. Require Department of Labor to provide notice to anyone who makes a claim for UI that there is this data, an AI academy that we've established. Providing parents with information about the AI Academy, ensuring that the development and enhancement of AI in the state, whether it be public or private academy work, it's getting into the hands and knowledge base of our constituency on a very broad level. This transformative nature of the technology, the early stage innovation and accessibility of that revolution is going to be paramount to the long-term success of our state. And like you've indicated support for those as well. There's some other few requirements that DECD would hold. DECD would have to work in collaboration, develop a plan to establish a technology transfer program. Would require DECD to establish a confidential reporting system for the exchange of health information for academic and medical research. There's a few other requirements specific to DECD that you've indicated support for. I don't know if you want to weigh in more on those specific requirements that DECD we entrusted with, or
Yeah, no, I purposefully kept our feedback here broad because it is the regulatory component 1 through 10 that I really want to keep the focus on. On the sections that you just mentioned, some impact other agencies, and I won't opine on that relevancy. On the areas that do impact the DECD, we are broadly supportive. I am broadly supportive. Senator Maroney is aware that some of these initiatives we're already working on. My only broad level piece of feedback is not going to be a surprise. It just needs to also be paired with resources. At times we are asked to do something and it isn't paired with resources, and that, as you can imagine, is a challenge. But Perfect. Beyond that, we are broadly supportive of the economic development components of this bill.
Excellent. And I think a lot of attention is going to come down to sort of this level of disagreement that is a necessary tension of all early stage industrial revolutions or economic disruptions, whatever level of you want to assign to the advent of AI and its applications more broadly in our economy. What is the regulatory framework? And I think that's a compelling narrative to say, we don't want to be too early. We don't want to cut off business development. We don't want to cut off resources that might otherwise come into the economy that won't now because we've established this regulatory framework. The challenging part is when I ask people to go through those sections 1 through 10, looking at the regulatory framework that we're seeking to establish, they don't find problems with any one of the sections, right? They agree, like they don't want to be too early and they don't want too many regulations in place. But when they get into the specifics of section 1, which just sections 1 through 3 establish definitions, requires developers to prevent algorithmic discrimination, requires disclosures of risks and public reporting on AI models, people generally aren't in opposition to that. We look at section 4, which requires developers to use reasonable care to protect consumers from known or reasonably foreseeable risks of algorithmic discrimination. People are generally supportive of that. Section 5, requiring disclosure of training and testing data, and that's compliant with copyright laws. Like as we go through section by section, generally people are supportive of each of the protections that we've put into place. They're more in opposition of the idea of the regulatory framework than they are of the very specific regulations that we're seeking to administer here. So I think that's where our tension is going to be as a committee, as rulemakers, like working with you, who's got a different perspective and different priority base and different relationships in this space. So I think there is tension, a necessary tension. Like I don't think the tension between you and this committee or the governor and the Senate or my role in the House I don't think that's a bad tension. I think it's a necessary tension at this stage. And I do look forward to working with you to relieve some of those tension points and hopefully get to a
Yeah.
product that
And just to comment, look, this is democracy, right? This is a natural tension. This is how it's supposed to work, and that's why I think we all agree this is a worthwhile investment of all of our time. The point you make was the right one. If you ask the average person, are you concerned about AI's impact on your job or your prospects or et cetera? The average person will say, yes, I have concerns here because we don't yet know how it's going to evolve. I think if you said to the average person, though, do you have concerns? But if we implemented a broad-based approach to regulation and it had an impact on our economy such that your lifestyle, your economic prospects were diminished, how would you feel about it then? Then they might say, well, all right, I've got some concerns here, but let's see how this plays out a little bit. And that's where I need to bring this dialogue bring this dynamic to this dialogue, which is, here we are. At a moment where our economy is accelerating for the first time in 20 years. We are experiencing relative economic growth right now that we have not experienced in a long time. We're seeing our population increase again after a decade of challenges, both economically and in terms of our populace. We're seeing companies be excited about the fact that finally Connecticut has a predictable environment where we're not in this permanent state of fiscal crisis that we all live through. Things are good right now. And because things are good right now, we're working on a series of meaningful investments in our future prospects. Innovation Cluster is a $100 million program focused on the application of AI in our most important industries. Advanced manufacturing in support of our national defense, financial services, insurance services, healthcare. These are technologies that will have fundamental impact on these meaningful, large components of our economy and therefore meaningful, large contributors to our job base. At that very moment, I don't want to be the state that says, now if you want to innovate here, if you want to apply AI to drug discovery, if you want to apply AI to technologies in support of our national defense, you got to now understand a regulatory burden that exists now and may evolve versus our neighboring states that don't have that burden. I just got to tell you, the economy has become too fluid. In a post-pandemic world, the economy has become too fluid. The employers have become too fluid. The attachment between employee and employers has become too fluid. And so when you start to do that on a state-by-state basis, that's when I get very concerned about its impact on our economic prospects and therefore on that average person's long-term job and wage wage increase possibilities. That we can't actually see and the average person doesn't understand yet. That's why I want to bring this dynamic to this dialogue.
And I appreciate that. And I think that does too also highlight two natural tensions that exist in any robust democracy, which is when is the appropriate time to regulate. There's a lot of academic studies on the appropriate time to regulate an industry is at its onset, right? Because once the industry is established, there are too many entrenched financial interests where regulating of that industry becomes too difficult. Too many people have started to make too much money, too much has already happened in the space, and then suddenly the regulation of that space becomes much more difficult. You think of the automotive industry arguing against speed limits and seatbelt laws, and they were entrenched industry for about a part of 40 years. Those conversations happened, which we now recognize after the final passage of those laws, the importance of them. But because the industry was so entrenched when those conversations started, it became much more difficult to put in reasonable regulations. So I think there's always going to be this tension. I actually think that as an intellectual exercise, this is a fun component, but actually at a core moment of the development of this industry, I do think we're in a space where we need more than just let's see what happens before we regulate it. So I think that's where we're at. Senator Maroney has a quick follow-up, then we're going to go to Senator Kissel. Okay, Senator Maroney's fine. Senator Kissel.
Thank you very much, Chairman Lamar. Commissioner O'Keefe, I just want to compliment you on attending this hearing from India. Tell Governor Lamont Senator Kissel says hi. I understand people's concerns with the movement in this direction. It's actually sort of ironic that you're in India right now because what we saw with the movement of technology, I don't think anybody in this room would be surprised if I used as an analogy call centers, right? It used to be that all the IT folks and everything was based here in the United States. And then all of a sudden we woke up one day and if you had a concern and you dialed that 1-800 number or for customer service, you were somehow you knew that you were being addressed by someone based in India, and that they were handling all the call center activity. And that was a business decision. It was a kind of decision that could be made, and that kind of endeavor could be done from a different country. And businesses felt that their business model would accept that, and then they were able to find more profit in using that. Now we see sort of heightened desire to have some of those jobs transferred back to the United States. When this bill came, when a similar bill came before the Senate about a year ago, Commissioner, I actually, despite Chairman Maroney's passion and hard work on a variety of IT bills, I voted against it. And I used the analogy of the iron horse. It's interesting that you say a new industrial revolution, because people had the same concerns with the railroad. And I sort of view artificial intelligence as essentially technological railroad, right? We're not really worried about the lines, where it goes, things like that. It's transferring. Rather than transferring physical goods, it's transferring ideas, dots and dashes, X's and O's, and that gets translated between the front end and the back end with decisions of a variety of sorts. And it can be done at the speed of light, and it can be done at speeds we have never seen before. But the iron horse, the railroad, is not the enemy. We can be concerned about what it carries, the information that it carries, the net results of what it had carried, but it's not the enemy itself. Yeah, there can be some glitches along the way, the paths that it takes. So I just want to address two quick questions to you, Commissioner. And again, your analogy to what we're dealing with in the Regs Review Committee. I've had meetings with Commissioner Katie Dykes. I know that your department on the Transfer Act, we've got that bill, those regulations in front of us. We hope to address them at our March meeting. And speaking to Senator Hartley, she still has some concerns with some of the nuances, but I'm hoping that we can address that. And I applaud you and your efforts for addressing that with the Department of Energy and Energy and Environmental Protection. My first question is this. Do you see that if we continue with the part that you're concerned with, which I don't want to demean it, because I understand where Senator Maroney's coming from. Yeah, if I was going to be dislocated by the transfer, this revolution, I would be very worried. Also, if I was the net recipient of a bad decision and I didn't know how it was determined, we've got to get to the bottom of that. So I get all that. But if we go along this path, as you had indicated, too early, too soon, will that have a chilling effect on investors investing in artificial intelligence businesses here in the state of Connecticut? That's my first concern, because it's a burgeoning area. I know that having toured the University of Connecticut's campus at Storrs and talking to the president and all of that, that we're trying to get behind businesses that are cutting edge, leading the way. And this is it's a new area. So even though we're a small state, we are wonderfully located between New York and Metro Boston. And so to that extent, I think that affords us some advantages. We have a very educated workforce. It seems to me that a smaller state like Connecticut can be nimble if we don't scare away the investors. Is that one of your major concerns, Commissioner?
That is one of my concerns. I mentioned it in both my written and my spoken testimony, which is, I worry that in an environment where there is greater fluidity, that this concept of a chilling effect, when regional neighbors don't have a similar regulatory burden, will be quite impactful. Look, very, very quickly, you mentioned, India and call centers, and look, I actually think that analogy is relevant. If you look at what happened with what was globalization, that impact was the internet democratized commerce globally. We saw an economic shift that occurred, which is labor went where labor was cheap. There was an economic dislocation that happened to our workforce in the United States. I actually believe what we're experiencing right now in terms of rising populism, in terms of rising protectionism, I think we're experiencing an echo boom, an after effect of that economic dislocation. And I think the reason is we didn't get in front of it quickly enough to retrain our workforce, to move up the value chain and start competing for jobs where labor wasn't necessarily the primary component of monetization. That is what I worry about. You can't. That is a great example of an economic dislocation that could not have been resisted. It could have been slowed down, but where I think now I realize, having been trained during that time, because I was active in at that time in terms of my career. What I would say is I think we need to get in front of these dislocations much more aggressively, which is why I am so focused on investing in our workforce, investing in the infrastructure required to make sure Connecticut can be a leader in this area. I think we are at a moment right now, this is again not hyperbole, I think we're at a moment right now where the emergence of quantum computing and quantum technologies and artificial intelligence happening at the same time is a bigger economic opportunity than the emergence of the semiconductor and the emergence of the software layer in the 70s and 80s. I think that this is actually a Silicon Valley kind of moment. Connecticut has all of the assets to take advantage of this. We have the president of UConn here with us in this delegation. We have the head of research from Yale with us in this delegation, folks who are working together for the first time to take advantage of these opportunities. This is not our moment to slow down. This is not our moment to say a state representing 1% of the population, even though I love it and it is my home and is where I'm raising my children. This is not the moment to say we should lead in trying to slow this down. I know there are concerns, and I think we need to be thoughtful about them. We need to pay attention to them. And in moments where we see actual risk, we need to regulate. I'm not anti-regulation. It is just a matter of being thoughtful and patient as we consider it.
Okay, and Commissioner, one more quick question until Radenka said hi from UConn as well, because I was out there at the campus with her not that long ago. This could be very serious. I don't want to kill the goose that might lay the golden egg here in Connecticut. I share your optimism. I also share the concerns raised by Senator Maroney and Chairman Lamar, but I think that we can bridge that gap. I don't want to see the governor ultimately vetoing a bill that comes out of the legislature and then we all decide whether the legislature is going to override the veto. I want to see the lion sleep with the lambs on this by the time June hits and we end this session. And I think it can be done. I think we can address some of the concerns that the legislature has without ruining our environment for investment. But if we do go in the direction that you have concerns with, as opposed to driving away investment dollars that could very easily land here in Connecticut, we have great corporations, corporate citizens in our state right now providing tens of thousands of jobs. Electric Boat, Sikorsky, Collins Aerospace in my district. I have North Central Connecticut, Commissioner. You're very familiar with it. Governor Lamont came up not too long ago with some wonderful news regarding brownfield remediation. He spoke about how the vestiges of the last industrial revolution were just polluting the land and left fallow, and we're trying to turn that around, right? The whole Transfer Act, the last industrial revolution. But if we go down with, I don't want to refer to it as like nanny legislation, but over-regulate this so that we poison the environment, aside from ruining our chances to grab onto the future of where this revolution is going, will we ultimately jeopardize the ability of our businesses, especially our defense and insurance businesses that we have already here in Connecticut, so that they may have to look elsewhere if they're either going to expand or they're going to be too hobbled to continue with the businesses that they're doing here in Connecticut? Because I'm really worried about that.
Yeah. Well, look, I would say, first of all, we would maintain very close relationships with our national defense primes and all the supply chains underneath them. We recently announced a strategic supply chains initiative, which is a program aimed at expected rising protectionism under a Trump administration, so seeking to repatriate production capacity to our shores. That's not only aimed at the companies in support of our national defense, but obviously that is a meaningful industry here in the state of Connecticut. What I will say to you, and also those same companies are seeking to invest in artificial intelligence, as you can imagine any company would, but particularly those companies. And innovation clusters, that $100 million program I mentioned before, hasn't announced final awards yet, but one of the three finalists is in fact centered around the application of AI in advanced manufacturing, which for us is principally those supply chains in support of our national defense. Those companies remain very great supporters of Connecticut, and they remain because we have developed over the last 100+ years a very specialized workforce that knows how to make these incredibly complicated machines. Not just, by the way, those in support of our national defense, but also in the semiconductor supply chain, with ASML having their North American headquarters here. That's it, despite some high cost inputs, some of which I can explain, right? We have a high cost labor force, but we have an incredibly highly skilled workforce. That makes sense. We have a high cost of energy here, and that I can't sell. I can't sell a megawatt that is 2x as expensive as the rest of the United States. That is a very difficult thing to sell. I don't care how good I am. So those companies, and I understand it, they're not growing here as quickly as they are in some cases in other states. And that's why the answer to your question is yes. I do have a concern that if we and forget about cost for a second. It's not about cost. This is about innovation. If we start to say that innovation here in an incredibly important category has an incremental regulatory burden on top of the fact that you have an incremental cost of energy, that I think makes it more challenging for us to continue to grow those companies here. I don't have a concern that they're going to leave per se. They're very committed to Connecticut and they're good partners. But I do think they could be growing faster here, and I think that should be a priority for us.
Thank you very much, Commissioners. Thank you, Mr. Chairman.
Thank you. And it looks like that exhausts the questions. I'm sure there'll be a lot more as this conversation proceeds over the next few months. Thank you again, Commissioner O'Keefe.
Great to see you all. Thanks again.
We have Commissioner Caffarelli. Came back in just in time. Good to see you this morning.
Good to see you. Thank you for allowing me to appear before you again. Representative Lamar, Senator Maroney, Representative Rutigliano, Senator Ciccarella, and all the distinguished members of the General Law Committee. I am Brian Caffarelli, the Commissioner of Consumer Protection, and I want to thank you for raising Senate Bill 1357 at the request of the department. You do have written testimony on it, so I'm just going to briefly summarize. The proposal amends statutes related to the department. It modernizes and streamlines processes for licensees. It avoids duplicative licensing submissions. It reduces overly burdensome reporting requirements. This bill also contains language that will improve the functionality of our investigation and enforcement activities. It protects consumers by providing us with a new tool. It's a stop work order at specific locations for violations like performing work without the appropriate credential. And it aligns food safety enforcement powers with the Commissioner's general enforcement powers. It also improves customer access to restitution. It allows the Attorney General to take criminal action against new home construction businesses that engage in fraudulent activity. It expedites consumer restitution, and it aligns with the changes from last year in Public Act 24-142 related to the Home Improvement Guarantee Fund. Finally, this bill improves transparency by providing a pathway for retailers to accept cash at retail by installing a reverse ATM. It ensures that car dealerships clearly and conspicuously disclose each fee charged to purchase or lease a vehicle. And it encourages businesses to obtain affirmative consent for auto renewals. And I want to thank you again for raising the agency's 4 bills and providing the opportunity to testify in support of them. I'm happy to answer any questions on this or other matters.
Thank you, Commissioner. We would have ideally loved to have this one done in time for your prior appearance before the committee, but this is a complex and comprehensive bill with a number of sections that demanded a lot more staff time. So we're sorry to bring you in on separate dates.
Glad to be here. Thank you.
That's right. This is a comprehensive bill that I know that folks internal to the agency have been working on for a long time, just providing enhanced consumer protections across a wide variety of transactions that occur in the traditional marketplace. I appreciate your leadership and the agency's leadership on developing this bill. And I think constituents across the state will be happy to see your agency working on their behalf. So I appreciate it.
Thank you.
I'm going to move on to Ranking Member Rutigliano.
Thank you, Mr. Chairman. Good afternoon, Commissioner.
Thank you.
I just have a couple quick questions. When you said that this expands the disclosure of the fees charged by an auto dealer, does it also will it also sort of explain which ones are optional?
Yes, it is, it does. So oftentimes, well, I shouldn't say often, but there are times that in purchase or lease agreements where it's confusing and they can be lumped together. But it does say, now it is requiring the dealer to list out the fees. And I believe, does it, which the optional and the required ones are
So
specified.
it
in
will
the
say
front.
that. So, because I noticed like, so somebody looks at the sticker price, it's gonna have basically the conveyance fee, what it's gonna be before they get involved in the transaction. That's what you're looking to do, correct?
Correct. Well, that among other things. I mean,
Right.
the lemon law fee is $3. That's required by law.
Okay,
VIN etching is not required by law.
right. That's
And-
the optional question.
And
that I
it
had.
is an optional thing, but a lot of customers we found don't understand that. And when it's just listed on the purchase agreement, they think it's just part of, when it's lumped together with mandatory fees and optional fees, it can be very confusing to consumers.
I actually agree with you. That's why I asked the question.
Yeah.
I wanted to make sure that that part was in there. We just went through the purchase a couple months ago and I saw these extra things. I'm like, I had to ask what they were. They're like, oh, it's security. I'm like, it's like a 10-year-old car. What do you mean security? And it was all optional. They didn't let me know. So I thought that was important. And if we want to move on to the architects,
Sure.
currently they don't have to have any sort of continuing education requirement. And now you're sort of mandating continuing education. Who gives the class? Where do they go to get that continuing education to keep their license?
I would have to get back to you on who actually administers the class. It's a third party. And it is, I'll have to follow up with you on that.
Is there any, had the department contemplated making their license longer? Because it does say yearly renewal in the legislation. And we seem to be going to like 2 years, 3 years on other licenses. I didn't know if that you guys had all contemplated that at all.
That would be up to the purview of this committee if it's, it would be a statutory change if that's something you wanted to
Do you think the
entertain.
department would have anything against making their license slightly longer than it is right now?
I'm sure we could operationalize whatever the committee felt necessary.
And then the only other part of the bill that I quickly read through, I started getting confused about slightly was the guarantee fund, you know, for when people have problems with construction companies, you're going from 30,000 to 50,000, right?
Correct.
That money comes from a pool collected by the state, right? It's not, do they buy insurance for that? Or is that money that the state sort of collects and disperses when somebody has a complaint?
It's a fund that is collected by the state with the registration of the, we have guarantee funds that we administer at the agency and the new home construction is one of them. So when the license is applied for, there's an additional fee that goes into a fund, similar to the home improvement guarantee fund, where, claimants, after they receive a judgment in court or an administrative decision from us, can claim up to, well, it would be $50,000 in this case, and then we would go after the bad actor to recover that money.
So you have the ability to go back and sue to replace the money into the guarantee fund. Because when I was reading, I was thinking, boy, this might increase the outflow from that fund with the 30 to 50. Plus, you're also changing that it could be, the award could be based on an arbitration decision as opposed to going to court, which I guess seems fair because most of the time with every contract they sign up for arbitration.
But I mean, so it would come out of an administrative decision that's held, a hearing that's held by our agency. And so oftentimes in either the hearing order, or if we entered into an AVC with new home or a home improvement contractor, they could have a payment plan to, you know, make payments to us, but we would lay out or reimburse the homeowner so that they were not out this money. So for, in the instance of a home improvement project where you're having some windows done, so if you have a hole in the front of your house, you want to, and someone has absconded with that deposit or didn't finish the work, or it was otherwise not completed, you would be able to get that money from us so that you could finish that work. And then we would go after pursuant to either some type of terms that we have with the bad actor or other means to go after them.
Was there any calculation done? What would happen to the fund since there could be increased money going out? is the fund in any danger whatsoever? Or are you guys pretty good at recovering from the bad actors, for lack of a better term?
Well, the fund is solvent. And I would like to think that we are good at recovering the money from the bad actors in all the funds. And we did look at that and believe the fund could sustain the increase.
All right. Thank you very much. Appreciate it. Thank you, Mr. Chairman.
Thank you. Representative Turco.
Thank you, Mr. Chairman. Commissioner, Section 31 regarding the cancellation of health club contracts, can you provide some additional information on what this language is intended to do?
Sure. So one thing that it does is it prohibits health club owners from assigning consumers to an alternate health club without getting their written consent. So if it was a chain of a health club and they were closing the one near you, and they couldn't just say, okay, we don't have to, make good on, canceling your agreement, we're going to transfer your membership to an alternate location. The health club would need written consent from the consumer to allow them to do that. Another thing that it does is it provides consumers with rights to void a contract if the health club no longer offers facilities or amenities substantially similar to those that were offered when they signed up. So for instance, if you signed up for a health club and it had a pool and you were interested in swimming and the pool closed, you could then have the right to cancel that contract because it didn't offer that service.
Thank you for that. And we have a large gym in Newington on the Berlin Turnpike that is closing now. And I've heard from constituents concerned with contracts being transferred and then having to drive, a distance that they're not comfortable doing. It's inconvenient for them. So this sounds like it would help them. So this is only dealing with when a health club is canceled or if an amenity is not being offered. Does it do anything to change in instances where that isn't happening and somebody just wants to cancel their health club membership after, a year?
Well, no, I mean, it is regarding closures of health clubs, but if someone wants to cancel after a year, those terms are normally included in the contract. And if it's gone month to month, there should be, provisions in the contract for how to cancel that. So if they're having issues, they can contact us.
Sure. Oh, thank you so much, Commissioner. I appreciate that.
And as you might imagine, with a 49 section or so bill, there are some concerns that might hear later on today. The Association of Certified Public Accountants has some concerns with sections 1 and 2. So I think there's a number of things that we may need to work on with your team over the next few months to make sure we've got some clarity in how these sections will play out ultimately. But I do appreciate your forthrightness, your ability to be here for each of the meetings we've scheduled you for,
Thank you.
but also your team's availability to help us work through these issues.
Right. Look forward to it.
Thank you.
Thank you.
We will be joined by Senator Looney and Senator Duff. They're currently in another meeting, and they will join us soon thereafter. Representative Piscopo and Representative Zullo have also signed up to testify. When they are available, we will take them. So with that, we're going to move to the public section of our agenda. And first up on that list is Ed Hawthorne, to be followed by Christopher Gilreen.
Good morning, Senator Mulroney, Representative Lamar, ranking members, and other distinguished members of the General Law Committee. My name is Ed Hawthorne. I'm proud to represent over 250,000 working people in the state of Connecticut as the president of the Connecticut AFL-CIO. I'm here to testify regarding SB 2. First, I have to commend the leadership of Senator Mulroney, who has dedicated significant time, resources, and I'm sure personal time to this issue. We want to applaud you for being early in leading the way to promote common sense regulations. We don't want to wait for a disaster in order to respond to it. And I think this bill is starting to go along that path. I've said it before, but it bears repeating. While AI presents incredible opportunities and potential limitless uses, it also brings numerous challenges, not the least of which are likely to be borne by the most vulnerable in our state unless significant protections are established. it is essential that we do not hide behind the guise of innovation to allow corporate developers and profiteers to increase economic inequality, curtail our rights, and undermine our democracy. We all know nothing is coming out of DC on this. And we can't wait 4 years to protect people from the possible harmful effects of automated decision-making. The narrative of too early, too soon has been said repeatedly here today. But I worry, when is it too late? AI is here and it's advancing at great speed. And we need to make sure consumers and workers don't get railroaded by failing to enact reasonable regulations. Money shouldn't be the sole motivator when it comes at the expense of consumers and workers alike. The potential harms are real and substantial. Discrimination, surveillance at work, suppression of labor rights, the promotion of contingent work and gig economy jobs, lower wages and job loss, especially in high-risk workplace decisions such as hiring, compensation, task assignment, promotion, discipline, and termination. We ask for a worker's voice in how technologies are developed and implemented to ensure they enhance rather than undermine our working conditions. Now, the labor movement has a framework for AI governance. You'll hear from the Tech Institute later on. It's also in my written testimony. But many of those ideas are incorporated in this bill, such as workforce development and education programs in Section 18 and 19. The state agency consultation with labor unions when actually deploying the use. We would ask for one tweak to that, where AI to be used in the public sector be a mandatory subject of bargaining under MIRA and SURA. The proposed amendment is in my testimony as well. Once again, focusing on worker involvement to come to a place where we all work together. We also have recommendations for enhancing AI policy to the working group composition. We commend the fact that there are 2 seats allocated to labor organizations, but there are 8 seats reserved for industry representatives and no representation for consumer or civil rights advocates. We would ask that the public interest groups have an equal voice on that commission. So once again, we can all work together. Recommendations for the training of the state employees is also in there, the establishment of the Labor Management Committee, appreciation for consumer rights, that companies shouldn't be permitted to have the right to deny appeal. All of this is included in my written testimony. I can go over the concerns with consumer to include workforce, substantial factors should be basis or partial basis, private right of action is also in there, the funding for the education campaign. But in conclusion, I want to get to a point where we can wholeheartedly support this bill and that we can work together, that where workers and consumers and developers alike come together and get to a place where we can support this bill, we can do it together and show our Connecticut values and really lead the way. Because Connecticut should be a leader. We are a small state, but we're a mighty state, and we should act like it. And we need to get out ahead of this technology because it's here, it's coming fast, and it's going to completely revolutionize the way we consume and the way that we work. So I thank you, and I'm happy to answer any questions.
Thank you, Ed, for your questions here. For your comments here today. Let's see if there are any questions from members. Yep. Chairman Maroney.
Yeah, thank you for coming here to testify, and duly noted on the working group, right? I think you're right. It's critical that we have diverse voices and incorporate more voices. So making sure we represent the consumer advocacy groups as well. So thank you for pointing that out and for the rest of your testimony. And I'm sure we'll be in touch. But yeah, the best product involves the boots on the ground, right? The people who are seeing it and multiple voices. So thank you.
Thank you.
I just want to say thank you again. Your team specifically has been reaching out to me for the last couple of months, trying to make sure I'm fully aware and understand the broad implications of this industrial revolution, new industrial revolution will have on workers, and considerations of which who oftentimes were not taken into account with the 5 or 6 previous versions of economic revolution that's taken place in this country. So I think it's important.
It's often like drinking from a fire hose is what I often say to people on national calls, but luckily we got a fireman here that can slow down the flow for
That's
us,
right.
with Senator Mulroney.
Thank you so much, Ed.
Thank
Appreciate
you.
it. John Piscopo. Then Chris Gilrain, then Joe Zullo.
Good to go?
I didn't know if you were inviting any special guests to come up with you as well.
Oh, yeah, sure. They're welcome. Yeah. Yes. Yeah.
No? All right.
Okay, Mike.
There we go.
We could have killed two birds with one stone, as they say. I just want to thank you, thank the chairs and ranking members of this committee, for raising House Bill 5425, an act concerning heritage railways. I appreciate you raising this bill for a public hearing. What we have is, you have my written testimony. I won't go over that. So very quickly, we have a little recreational railroad, basically from Waterbury to Torrington. They bought a facility. They renovate the old cars, the golden age of the rail. Beautiful 1930s, 20s cars, carved cherry and mahogany, beautiful. In the old days, they used to, someone that was real rich could attach an apartment, a luxury apartment, to a train tour of the country. And they've renovated a couple of those. So we're pretty proud of it. And I know our House, the House Chair, Representative Lamar, is an honorary engineer down there. I saw him on the tracks this summer. So congratulations on that, Representative, Mr. Chairman. And they just offer recreational rides. And the problem here, the crux of why this bill is in, is we always pay $200 a year for the permit, because we have rides, and then we offer area breweries, Red Dog Brewery, Torrington, Clocktown Brewery in Thomaston, Litchfield Distillery. They offer tastings on the train, something for the adults, and so we always pay $200 a year for the permit. And then all of a sudden last year, the permit goes up, this year, the permit goes up to $2,000, like we're the old Metro North, when they had their bar car. That's all it's no fault of theirs, the agency. That's all the only regs they had to go by. So all of a sudden, 200 to 2,000, it would hurt us pretty bad. So I just want to thank you for this, and the way it's worded too, the bill. It's written very well, and I think we could all live with that. And I definitely appreciate it, and hope you have a favorable outcome to this bill.
Thank you. Terrific. Thank you for your testimony. I wish that honorary degree got me a job at DOT or something. Turns out it's not really worth that much. It's too bad. Though I do appreciate the great work that Mike put into designing it. And congratulations. I think this is the most controversial alcohol related bill we had before the committee this year. So that's great.
That's rare.
Any questions for Representative Piscopo? Seeing none. Thank you again, John. I
Thank you
appreciate it.
again very much.
Chris Gilrain, followed by Joseph Zullo.
Thank you, Chair Lamar, Chair Maroney. Appreciate your time, and appreciate learning about a new train that I might have to check out. Chris Gilrain, representing TechNet. TechNet is an industry association comprised of nearly 100 companies, representing about 4.5 million employees throughout the innovation economy. Here to discuss SB2. TechNet was a member of the working group in 2023. We were honored to be a part of that, and frankly would be more than happy to join if the new one is established in Section 25 there. I'm just putting in a plug there. Connecticut is extremely well positioned to be a leader in applied AI. I've said it before, regardless of where these models are developed, I believe that the states that will reap the most benefit from the advancements in AI will be those with incumbent industries that are ready to harness those technologies, and an educated and diverse workforce that is ready to deploy them. The native industries here, like aerospace, insurance, finance, defense, and healthcare, are already top employers of tech talent and early adopters of AI tools. And the forward-thinking investments and workforce strategies in sections 11 through 24 of SB2 will help ensure that there is a pipeline of homegrown talent ready to take on the jobs of the future. As Chairman Maroney is fond of saying, for AI to reach its full potential, people need to trust the technology and the companies that develop it. TechNet supports AI legislation that identifies known risks in the development and deployment of these systems and tailors remedies appropriately without unduly burdening companies or risking the disclosure of commercially sensitive information that has little value to consumers. With regard to sections 1 through 10, in general, we ask that the proposed regulatory framework focus on known risk, known use cases, known limitations, and not get into hypothetical scenarios with terms like reasonably foreseeable. We want to avoid overburden a nascent industry with onerous requirements or forcing the disclosure of proprietary information. Similar to the discussions we had around data privacy, we want to avoid mandating reporting of information to the public that has little information in their role as consumers, but creates burdensome requirements or trade secret concerns for the companies. We want to leverage existing laws and frameworks and avoid layering over and creating confusion, understand how the existing rights that consumers have under the data privacy law interact, or in some cases are overlapping with the proposed rights in SB2. And ultimately, these kinds of things come down to the definitions, right? Definitions help us ensure that the scope is appropriate and compliance is possible. I will submit all of this in our written testimony, but very quickly, the definition of AI system, we would hope that it is a machine learning-based system, which is consistent with other states that we've seen. On the consequential decision front, we would generally appreciate more tailoring in these categories. High-risk systems should be focused on systems that are intended to make decisions without human review or intervention. Substantial factor we've discussed. We would hope that you look to New York or Virginia for that. Finally, we do support Section 27 on non-consensual intimate images, which was a recommendation of the task force. We'd further support language regarding the disclosure of election communications that use synthetic media, as was also recommended by the task force. And there are some other states that we would love to point to on that front.
Excellent. You referenced the question I had for you, which is, can you provide a lot of
Yeah.
this in written testimony?
Yes.
It's a great benefit to me as we move forward, being able to reference back some of the very specific recommendations that you're making. So if you can get that into the committee, that would be very beneficial for me. So I appreciate that. Any questions for Chris?
Yeah.
Senator Maroney.
Hey, Chris, thank you for coming to testify. Nice to see you. Yeah, I look forward to seeing your written recommendations. It's a little easier for me to look through that. Just the
Absolutely.
one thing I will say on, your recommendation on the AI system, it is consistent with the OECD definition that we
Right.
have, which is kind of, as you know, most of the companies used to say, stay international, use accepted definitions. That's the definition that's in the bill that passed in Colorado. It did change in Virginia, which did pass out of their House and Senate, awaiting to see what the governor does there. But it is again, the OECD accepted definition to my knowledge, and I did check yesterday, they haven't changed that yet. So I'll just point out that people say, use other states or use other definitions unless we don't like them, and then we'll tell you something else. So, but
Yeah.
that was the intent of using that definition, is that was the internationally accepted definition.
I fully recognize that I come here constantly seeking interoperability, right? And that in this case, as we are kind of at the crest of the wave here, that becomes a bit of a moving target.
Right. Great. Thank you. And I'm fairly certain we'll be in touch over the next couple months, once or twice.
For
So,
sure.
all right.
Thank you, Chris. Appreciate
Thank
it.
you.
Joe Zullo. Representative Zullo? Rep. Zullo just texted me saying he was available, so we're going to give him a moment.
Much better. Can you hear me now?
We can hear you now. Thank you, Joe.
Perfect. Sorry about that. I had to be upgraded as a panelist. Good morning, Chairs Lamar and Maroney, ranking members Rutigliano, Ciccarella, all the members of the General Law Committee. It's a pleasure to be before you today. I'm here before you for a simple reason, to testify with respect to the bill before you regarding wholesaling, real estate wholesaling. Not many people necessarily know what real estate wholesaling is. It's a new niche industry developing within the real estate industry. You're probably familiar with a lot of other industries where there are intermediaries, online travel booking websites, car dealers, stockbrokers. They're all intermediaries, right? What's the difference right now between those, though, and real estate wholesalers, at least in the state of Connecticut? They're regulated. And in Connecticut, real estate wholesalers are not regulated, they're not licensed. But in the contrary, most of the other people or actors who work in real estate or with respect to real estate are regulated or licensed. You have lawyers, real estate agents, insurance companies, banks, lenders, all licensed, all regulated in some way. So you might be asking yourself, why do we need to regulate or license wholesalers? Well, the reality is it's much like any other industry. The majority operate in good faith. They really do perform a valuable function, facilitating sales of properties for people who can't do it themselves. Maybe they have difficulty managing or organizing their lives. They might be behind on a mortgage debt, and they need somebody to come in a creative way and employ creative strategies to get the transaction over the finish line. Unfortunately, though, wholesalers often deal with people who are vulnerable. And there's often an asymmetry of bargaining power, information, and comfort in a real estate process that makes them more susceptible to being exploited or taken advantage of. If you're not familiar, a wholesaler would come in, for example, make an offer on a property to a seller. Maybe they're in distress. They just can't get the property ready for sale. That seller accepts that offer, and then the wholesaler goes and either assigns that contract to a third party, finds a party to buy it, or does some other, structures the transaction some other way in order to get it over the finish line. So they're an intermediary. At first glance, that doesn't sound like it's so bad, right? Again, no different than a travel booking website, something else. But unfortunately, in my line of business, I've come across deals and scenarios that I'm going to acknowledge to you definitely don't represent the norm, but they represent situations that have come up that will continue to come up if we don't regulate, if we don't license, we don't don't take action to stop these bad actors. One of those situations is when wholesalers put up minuscule or very tiny deposits into these contracts. Unfortunately, when they do that, there's no skin in the game. There's very little financial recourse if a wholesaler breaches a contract that a seller can rely on. Sometimes they have secret escape clauses. They use like a title contingency, saying that if the title to the property isn't acceptable in any way whatsoever, that they can back out of the contract. That's really just a secret escape clause. Most sellers won't recognize it, but that's how it functions. I could talk about a couple other things if members have questions. I want to end by saying, I don't want to destroy this industry. Nobody should want to destroy this niche industry. It's contributing to Connecticut's economy. It's a growing industry. But what we do need to do is regulate it. Thank you.
And thank you, Rep. Zula, for that. I mean, this was something that I was unfamiliar with until you brought it to this committee's attention. And it was certainly something during the screening process that engaged each of us, because we do recognize what your concerns are, that there needs to be some level of regulation internal to this industry. The potential for exploitation is clear. And so I'm hoping we get a final product over the finish line this year, because it definitely, I think, is demanding of effort here and regulation. Representative Retigliano.
Thank you, Mr. Chairman. Good afternoon, Representative. Could you just walk us through what a wholesale real estate transaction looks like? Like, how do they find the seller? How do they find the buyer? What it actually looks like as compared to a typical real estate transaction?
Sure, and I appreciate the question. Thank you. Let's start with a traditional real estate transaction, right? Somebody's getting ready to sell their property. They perhaps ready it to get sold, right? They might perform some yard work, do some basic improvements, get it, make it look really nice. Then they employ a real estate agent or some other broker usually. They could also list it independently on the multiple listing service. There are mechanisms for doing that for very small commissions, right? That involves taking photos and then marketing the property. A contract would eventually be drafted once somebody submits an offer on the property. They'd retain lawyers. A closing would eventually take place. And the seller who originally listed the property would convey the property to the buyer who initially made the offer on the property to purchase it. In a wholesale transaction, as I was alluding to earlier, there's an intermediary. And a seller could find a wholesaler, maybe by Googling it. But oftentimes it's through prospecting. A wholesaler will be dialing, looking for people to sell their properties. And that wholesaler will contact somebody and it will come out in the conversation, hey, I'm behind on my mortgage, or I really don't have the time to do this, or I'm really scatterbrained and I just can't get all the pieces together. And the wholesaler says, no problem. We do this every day. We'll give you cash for your property. You don't have to worry about us getting a mortgage. We're gonna and we'll take care of it. And so they sign a contract for the seller to sell to that wholesaler, but the seller doesn't necessarily know that wholesaler is going to take that contract and assign it to somebody else. They're going to go and find a buyer for the property. Once they do that, they either assign that contract or the rights that the wholesaler has are transferred in some way to that buyer. The buyer completes the transaction and the wholesaler is compensated in some way with either an assignment fee or with a portion of the proceeds. So again, the real difference is they're being an intermediary.
Oh, thank you for that. So I read that there's very detailed testimony in opposition to the bill. And there was a couple of points that it brought up that concerned me. Why would you limit the amount of time? It says there's a 70-day term where the transaction has to go through. That's not typical of a normal real estate relationship. I was just wondering why it was in the bill, or am I reading it wrong?
You're absolutely not reading it wrong. And I do want to credit both the wholesalers and members of the real estate industry and others who have weighed in on this. They've educated me as to some of their concerns, and having been educated as to some of those concerns, I'm perfectly willing to acknowledge that that's probably not a practical limitation and that we can impose or should impose. But it was suggested because oftentimes these contracts have very long close dates, because let's be real, a wholesaler's job is to find a willing buyer. And sometimes that can take a while. But in the meantime, remember, you're dealing with people who are in financially precarious situations sometimes. So they have mortgage interest penalties accruing, right, if they're behind on their mortgage. So what you don't want to have happen is have a wholesaler who has the right to drag these contracts out for 5 or 6 or 8 months, keep people on the hook, only to walk away from them with very little consequences. And then that person is left really in a financially worse place because they're further behind on their mortgage after maybe being promised, a way out, and then having somebody not deliver.
So I guess that was a pretty good answer, because I thought maybe this wholesalers had sort of a standard contract where they either pay for the property and then they resell it while the people are in there. But you're saying that they could sort of design that contract any way they want. So people are still responsible for their mortgage and their taxes while the wholesaler's trying to, for lack of a better term, flip their house to whoever might purchase it.
Yeah, it can be structured in any number of ways. You have situations where the wholesaler will buy it maybe to stop a foreclosure, right? To stop those fees from accruing and then flip it. Other times you have situations where the person is living in the house, and then they're under contract with the wholesaler, and the wholesaler is looking for a buyer. You might even have a situation where the wholesaler buys the property subject to the mortgage, and the mortgage continuing to accrue interest and penalties, and they're fixing it up and the person is still living in it, or maybe they've moved out for a small period of time, depending. It's simultaneously a great thing because, again, you're not going to see a lot of people who walk into these transactions with the creativity and the willingness to do some of the things it takes to get these deals over the finish line. But because of that, it lends itself to situations where people can also get hurt.
So by licensing the wholesaler, because that's basically what the bill calls for, is that really you're just sort of looking for a mechanism for the state to come in and say, hey, this is right, this is wrong, you can't do this, you can't do that kind of thing?
Yes, and what I'm really looking for, and I think would be the most productive and best way to help make sure everyone's treated fairly, is that there be some type of disclosures, required disclosures from wholesalers to people that they're working with that explain what their rights are, the general contours of the transaction. And I know that there's been substantial work by interested parties on these topics, and I think that's the best thing that could come out of this legislation.
So you're not looking to ban the practice, you're just sort of looking to have a standard contract. That's what it sounds like, or standard disclosures, sort of like we do with real estate agents, right? I mean, they all have the same paperwork. Am I
Definitely
understanding that correctly?
very similar to real estate agents, and the enforcement mechanism or the oversight mechanism, I'm thinking would look a lot like what we do with new home contractors or home contractors, where DCP licenses them, regulates them. If you have a complaint or an issue with a contractor, then a lot of times it's a CUPPA violation. So that's the duality that I'm looking at.
Thank you. I appreciate it. I feel more informed. I appreciate it.
Thank you for the questions.
Got an East Haven thing going here. Senator Chicarella.
Good old East Haven. Good afternoon, Representative Zullo. I appreciate you bringing this forward, testifying today. I was made aware of this situation through some realtors. Steve Miller, president of the Realtors Association, was talking to me about this. And, we're not trying to restrict anyone from conducting business with this legislation. Is that correct?
Absolutely. I can't emphasize it enough, but the goal here is absolutely not to destroy this niche industry. It performs a really vital function in situations, again, where people can't put these transactions together themselves, people in distress. And when it works, it really works, and everybody ends up winning. The wholesaler earns a valid and justifiable fee. The person sells their property and either gets out from under a mortgage that maybe they're having trouble with, or they're, gets out from under a property they just can't manage, and a buyer gets a great property. So again, it's an emerging industry. It's not a very large industry. You'll probably hear testimony on that. I think it's less than 1% of the transactions that are taking place in Connecticut right now. But because it's an emerging industry, it lends itself to some sticky situations too.
Got it. And I appreciate answering that question. And to that point, I think I've heard some great stories with individuals that were contacted and it was a legitimate, cash purchase. It was quick. There wasn't that middleman process there. There was individuals that had the funds. They bought the property. They closed quickly because obviously they couldn't put it on the market in the condition it was in, or they had other, personal issues that would stop that from happening. But I heard some stories that individuals really got the wrong end of the stick, if you will. My understanding is some of the maybe bad actors are cold calling. Do you know how they're getting the information of the people that may want to sell their house in this fashion?
Absolutely, there's cold calling. And I also want to be clear, there's nothing wrong with cold calling. There's nothing against the law about it. But yeah, you have teams of people that sit in a room and they use automatic dialers and they dial for dollars, but that's no different than a lot of other industries. But I can tell you that that's the impetus for this legislation. The handful of bad scenarios that I've seen, one of them I'll give you, and it's probably the most controversial, but it's really what inspired this was I had somebody come to me that was offered and accepted about $100,000 less than the actual value of their property. And when I say $100,000 less, they had similar comps in the same condominium complex that had sold in the last year for over $100,000 to their unit. Now, this was a person where there was definitely an asymmetry of bargaining power. There was a lack of information on their part. They made a really bad deal. And you may hear testimony, you may hear somebody come in and say, well, that's life, right? They agreed to a contract. They're free to do that. But I remember being a young attorney and going to court and sitting on short calendar and watching people go up to the stand when they wanted to do one of those, cash money now things, where they cash in an annuity or something like that. And a judge would question them ad nauseum for 10 or 15 minutes to make sure they understood the nature of what they were doing. Because we're not just talking about, maybe a $200 or $300 difference in the price of what somebody's buying or contracting for. We're talking about people's nest eggs, their retirements. We're talking about substantial sums of money. And I'm not asking you or us to legislate that somebody's got to go before a judge anytime they want to do something like this. I don't want to see anything near like this. What I want is for us all to recognize that we're talking about substantial sums of money, people's livelihoods. We need to be careful and cognizant and make sure that they're protected.
Absolutely. I agree with that. The cold calling, again, I totally understand that. It's part of sales. That's fine. I guess the question I was trying to get at, and I'm really talking to the issues that arose in a negative light, not the great stories that I've heard from individuals that do it professionally and do it correct, and they're fair actors. My understanding is individuals that are in distress, and there could be a public record of that. They're in debt. Maybe they're pre-foreclosed. Maybe there's liens for taxes, and people are buying those lists and then cold calling. And again, as you stated in your testimony, these individuals are already in a bad way. And I've heard horror stories where they were taken advantage of. You also referenced, and I heard of a situation just like this as well. They went into contract with one of these individuals because they had to get out of it quickly. They thought it would be a quick transaction, and it took a very, very long time. And there was no activity, so they wanted to list it with a realtor and make some different moves. But they were locked into the contract with the original, cash buyer, if you will. So those are the things I think that we're trying to get at here, and making sure, again, we deal with the Department of Consumer Protection, and I think that's really what this issue is. It's just to make sure that there's an even playing field, especially with individuals that are dealing with not so great things in their life at the time. And I think that's what we're trying to get at here. And in no way are we trying to hinder anyone from conducting good, legitimate business. So I just wanted to try to see if you had any examples of how they were getting those lists, or if you heard any stories like that. That was the question. But I do appreciate your time. If you don't have a response to my statement, I really appreciate you putting this forward and testifying today.
No, out of respect for the fact that you're all there, and I know you have a lot of other people to testify, I can get you offline and we can talk more about it, but I appreciate the questions.
Thank you.
Representative Yakarino.
Real quick, thank you, Mr. Chair, and thank you, Representative Zullo, for putting this bill forth. And is he here?
Yeah, I'm here.
Yeah, thank you for putting the bill forth. I get about 3 texts a week. I live about a quarter of a mile from maybe a half a mile from Quinnipiac University. And how they get my number, I don't know. I report them, I delete it and block and report it. I get postcards. It's a little frustrating, but I think the importance here, if I'm reading the bill correctly, is they're going to be regulated and licensed. So now a realtor, if you go to a realtor, they're licensed with DCP, they're licensed with the state. Will this be similar to that, Representative Zullo, where they actually have credentials?
Yes, and again, that's the whole point, right? We want to know who's doing this, who's engaging in this process. And we want to have a fair mechanism for people to be able to hold them accountable, just like every other person who's involved in the real estate process. The lawyers, the real estate agents, the banks, the lenders, the insurance companies, everybody is heavily licensed and regulated. And again, it's an emerging industry, so I get it. There's no mechanism for it right now. That's why I'm talking about the need to create that mechanism.
No, I appreciate that. And I think it's important. I would actually go as further down the road if they'd get the same licensing. But as long as we get some regulations now, I think it's important for our market and our consumer. So thank you, Mr. Chair. And thank you, Representative Zullo.
Thank you, Rep.
Thank you. Thanks again, Joe. See you soon.
Thank you, everybody.
We have Angel Melendez, followed by Senators Looney and Duff. Is Angel here? Well, Senator Looney, Senator Duff.
Thank you. Co-chairs, Representative Lamar, Senator Maroney, Representative Vertigliano, Senator Ciccarella. Thank you for the opportunity to testify here today. I'm Martin Looney, Senate President Pro Tem, and also State Senator for the 11th District in representing New Haven and Hamden. And want to especially acknowledge the presence here as the new chair of this committee of my longtime friend and colleague from New Haven, Representative Lamar.
Good afternoon, everybody. Bob Duff, representing Norwalk and Darien, Senate Majority Leader, and a pleasure to be here. Thanks to our chairs and ranking members for allowing us to testify together.
But we are here to testify on Senate Bill 2, the artificial intelligence bill. And our great concern is that it is critical that we move towards state regulation this year. One of the severe problems, if you look back over the last 30 years of history regarding the internet, going back to the 1990s, many of the problems and challenges we face today is that the internet was not adequately regulated back at the beginning, before it grew to what it is today. Many of the abuses we see, many of the problems we see are because there was a vacuum of regulation at the time. And AI is growing at such a rate that there's a danger of that happening now in that category. Some have argued that states should not venture out to do this on their own because it would be better if you had uniform standards and federal regulation. Well, I think that it is very unlikely that we're going to see any federal effort in the next 4 years to do anything on this subject, and it's critical for us to do this at the state level. We have a well-researched bill. I want to commend the committee chair, Senator Maroney, who has become a national leader on this subject. In fact, last year, Senator Duff and I were at a conference of the State Legislative Leaders Foundation, and one of the main presenters was Senator Maroney talking about the bill that had been developed here. And it is time to act. One of the grave concerns that we all have is about automated decision making, which affects so many people's lives, with algorithms being devised so that people are being discriminated against without even a way to know it or to find out about it, and that can be devastating. So I will turn it over to the Majority Leader at this time.
Thanks, Senator Looney. And good afternoon, everybody. Keep it very brief because I'm sure you have a lot of people who want to testify today. I want to thank the committee for bringing us up for hearing today again, and thank Senator Maroney for his work as a national leader on artificial intelligence policy across this country. As Senator Looney said, this is a really important issue, and we articulated that at a press conference earlier today, where we really talked about setting up the guardrails and the boundaries for an emerging technology that will have a place in all of our lives and actually does already, but to make sure that we're doing it in a way that protects consumers and protects the residents of our state.
It's really, really important for us to get it right, but also to do it in a way that tries as much as we can to get ahead of the curve. We're seeing, as Senator Looney said, when the internet was developed, social media was developed, a lot of times the call was hands off, the market will figure itself out. And in fact, what we've seen is a lot of times where we have technology companies that are monolithic, they're unregulated, they run the show, they don't have any boundaries whatsoever. It's harming adults, it's harming children, especially children's mental health. And we have the opportunity right now, not that AI is in its infancy, but I think we still have this, the window is closing on us, and we have to make sure that we put those guardrails around that. I think this bill is a good bill because it is modeled with other states as well, so that we're not having a patchwork of 50 different laws. And I commend Senator Maroney for his work on that, leading a national group to put together legislation that that can work, because we do know that Congress will not act on this issue. Frankly, I think no matter who's in control. So that's why this is important. We need to get in front of this. We need to put Connecticut as a leader. I think that this legislation will do that. And last year there was concern that Connecticut would be the first state. We would be an outlier. We've now seen that 5 other states have already passed legislation. We need to be a part of that as well. And I think that it'll be good for consumers, it'll be good for businesses. And again, most times people just want to know what the boundaries are, what the guardrails are. And this will show that, and that'll be helpful as this technology continues to emerge. Thank you.
Thank you for your testimony here today. And as you mentioned, I am a great benefit of having Senator Maroney, who's led on this issue for a number of years, who's educated everyone on this committee over the last couple of years on some of the challenges and opportunities that we face as a state in attempts to regulate this industry. I'm going to turn it over to him in just a moment, but I want to, probably to you, Senator Looney, go down a conversation that we had earlier with Commissioner O'Keefe. Largely, the bulk of his testimony centered on the fact that this may forestall economic opportunities in Connecticut if we were to become an early stage innovator of regulation. It touched off, for me at least, an intellectual conversation about when is the appropriate time to regulate an industry. Is it at its onset, or when it's during those nascent stage where you potentially could cut off innovation, or after it's been entrenched and it becomes almost impossible to regulate an industry? You referenced the internet and the advent of social media and the social media apps that are almost impossible for us to determine how to put the genie back in the box, even though we recognize there's extraordinary problems in that industry on a year-by-year basis. We're constantly up here trying to get the bare minimum done to regulate one specific component. We harken back to the automobile revolution, where at the early ages, you didn't conceive of speed limits or seatbelt laws or intoxicated driving. And then when we recognized that it was time to regulate that, well, by then the automotive industry was so entrenched and so profitable, there was so much money to push back legislatures from adopting appropriate regulation. And so I think there's that necessary tension between economic development and regulatory constraint. How do you determine when is the appropriate time to regulate an industry? Is it now at its onset, when we recognize the potential problems, the known problems that we foresee? Or is it waiting until we've got a couple more companies in the state and then asking them if it's okay to regulate them?
I think that is a key pivotal question, Mr. Chairman. And I think the answer is that you have to look at how important is the entity that you are considering regulating, and does it have potential dangers as well as potential benefits? And I would argue that the potential dangers are so high here that it argues in favor of as early regulation as we can. As the Majority Leader said, we wouldn't be the first state to do this. But it would be part of a consortium of a number of other states that are looking at this at the same time. And it's important for us, I think, to be among that group, that relatively early group, because we need to learn from the history of what happened, with the internet and social media, because getting this wrong or not doing it adequately could be just a disaster. You're talking about genie getting out of the bottle. This could be a much more lethal genie than anything we've seen up to now. And I would commend to the committee the opinion piece by former Senate President, former Lieutenant Governor, and former Commissioner of Revenue Services Kevin Sullivan that appeared in the Hartford Courant on Sunday, making that argument.
Thank you. I think that's the right response. I mean, ultimately, regulation and over-regulation can be used as a boogeyman of like to encourage state governments to do nothing and let a business environment take shape before we deem ever appropriate to put in reasonable constraint. And when I asked them to review the regulations that are proffered in this bill, well, it turns out they're not opposed to any one of the specific regulations. They're more opposed to the concept of regulation. And I think that's the challenge for us, is we deemed a number of these constraints and regulations to be appropriate. I think they have broad constituent support. I think it's a well-reasoned and responsible look at regulation. And I really commend my Senate co-chair for taking the lead on this and for you guys being here and offering that differing intellectual opinion about when the appropriate time to regulate an industry is. Senator Maroney.
Thank you very much. And to follow up, Ted, regulation isn't necessarily anti-innovation, right? I think earlier before we heard reference to this may harm our biotech industry and our defense industry. And I would just call out to the people who have actually read the bill. Those are industries that are both explicitly excluded from here, and that we have lots of innovation happening in biotech, but biotech is very tightly regulated. Right? If you look at with the COVID, we think back to COVID, once a vaccine and, the modeling helped to accelerate the development of the vaccine, but we didn't just give it to people. We waited until it was safe, right? The whole world was at a standstill, but we waited until it was safe. It was tightly regulated. Bob, you've been a great advocate for data privacy and pushing for data privacy since 2019, was it?
Something like so long ago.
Or long ago, yeah, even before. And I'd heard in discussing data privacy with other legislators and even people from industry that if the internet were built with data privacy in mind, it would have been built differently, right? So with that and with the lessons from social media, if we could go back, I'm sure we would have regulated that differently. Do you think that there are costs, as Representative Lamar mentioned, once you have entrenched interests, it's harder to regulate, but it's also more expensive when we make companies redo the way they are doing things. So do you think it would be better for us to take a proactive approach with those thoughts in mind?
Yeah, thank you. And I appreciate that, because I think that's what's great about this bill and the work you've done is the fact that you're working with other legislators around the country to build a national model. It may not be exactly the same in every state, but it's generally very similar in every state, so that corporations that you may hear from today at least know what the rules of the game are, and they're not wildly different in every state. And I think that's what we've been trying to do, you and I, on data privacy. It's the same type of thing. We know Congress isn't going to pass legislation, which is not great, because we're I think we're the only country left in the Western Hemisphere that does not have data privacy. And so we need to learn from those lessons and be smarter about AI. Let's just not forget that, especially generative AI is controlled by very few companies. There's only a few companies that actually have that. And if you take a poll of citizens, as Representative Lamar said, of average Americans, they will tell you that they have a concern about AI and how it impacts them, whether it's on discrimination, whether it's on revenge porn, whether it's on privacy issues, whether or not they're actually speaking to a real person or not, and how that all is going to influence their lives each and every day. So I think that we're providing, again, the guardrails for businesses to be able to understand what the rules of the game are here in Connecticut and across the country. And we're also providing some help to our constituents who are rightly worried about what this can bring. And like I always tell people, AI is not a bad thing. It's not terrible. We've lived with AI for a long time, but it continues to evolve and change and grow. And so as that is happening, we have to be proactive. And as I said this morning, the window on this is closing. We've got to get this done sooner rather than later. Otherwise, we will miss that opportunity like we missed with the internet, with social media and others. And again, think about social media right now. How many companies is social media controlled by? Very few.
Thank you.
Are there any other questions? Seeing none, thank you both for your testimony here today.
Thank you.
And I'll probably see you on SB3 in a couple of weeks. So. Next up, we have Supriyo Chatterjee.
Can you push your button so the red light's on? Okay.
Honorable coaches, Mr. Lamar and Mr. Maroney, and esteemed members of the General Law Committee. Thank you for this opportunity to present a public comment on the bill 2025 SB2 regarding artificial intelligence. I'm in the policy and technology sectors for economic development in Connecticut for almost 40 years. I work with small startups, major corporations, hospitals, nonprofits, and academic institutions. I was part of the State Innovation Model SIM Healthcare Program in the PTTF group. I have served as a co-chair of the Economic Security Working Group in the Department of Public Health's State Health Improvement Plan, SHIP plan that occurs every 5 years, and also on the Consumer Advisory Council of the State Office of Health Strategy, OHS. Since 2015, I'm a Connecticut Health Foundation Health Leadership Fellow for Health Equity and Health Disparities. The views expressed in this testimonial are my own. The subject of artificial intelligence is vast, and for your consideration, I will confine my testimonial here to only one aspect, and that is the AI applications in healthcare. That includes public health. Health data concerns new regulations and new technologies. While the security and privacy of health data remains a major concern, its secondary and tertiary use has garnered an additional concern with newer AI algorithms. On June 7, 2023, the legislative bill, which is now PA 23-16, this statute addresses the data algorithms used with various state agencies and related organizations, including the Office of Health Strategies. Earlier, the federal agency ONC proposed HT1 rule, algorithm transparency and information sharing updates, and this may be subject to change with the current administration. In addition, the recent display of AI and its power over the consumer has garnered increasing public concern about the use of AI and the need for consent. This calls for meaningfully managing the consent of Connecticut's patients and their healthcare data. However, the current rendition of SB2, the 2025 SB2, falls short on data management, privacy, and security that would address the much-needed trust in the patient consumer. The rapid rise of AI and the accompanying hype and fear and doubts have raised the need to address it diligently. An accompanying bill, SB 1331, does call for healthcare data selection and consent to assuage the patient consumer. Now, whether it is an opt-out or opt-in of the submission of the healthcare data, the patient would still like to know the choices before making a decision. Meaningful consent occurs when the patient makes an informed decision and the choice is properly recorded and maintained. Last year's bill, SB2, had a provision, Section 30, calling for the Connecticut Department of Public Health to study and make recommendations regarding AI in healthcare. Perhaps like SB2 last year, this year's AI in healthcare deserves a bill of its own. I'd like to summarize with a quote from a very notable publication, Nature. The title was The Inconvenient Truth About AI in Healthcare. The potential of AI is well described. However, in reality, health systems are faced with a choice to significantly downgrade the enthusiasm regarding the potential of AI in everyday clinical practice, or to resolve issues of data ownership and trust and invest in data infrastructure to realize it. I just want to close with one. I mean, this is literally ongoing news. The FDA got hit with the Dodge cuts, the AI, and their AI division in the FDA currently is facing cuts, and that will definitely affect the AI, the med tech, and the medical devices industry. I thank you for your time and this opportunity to talk.
Thank you, Mr. Chatterjee, for your testimony here today and for your commitment and focus on this issue for a while. I know your input has been valuable for us for a long time, and I appreciate your testimony and the written testimony you help provide so we can reference it at a later point in time. Are there any questions? Senator Maroney.
Thank you very much for coming here to testify today. What do you see that the state can do to incentivize the growth of health AI businesses?
First and foremost, data. Revisit the previous data that we've had. I spent about, along with a lot of fellow health advocates at the Connecticut Health Foundation, getting the bill passed on race, ethnicity, and language data. Was a huge issue. It took us well over 3 years. And revisit that statute and see how that would apply in algorithms. We know it does, because in the middle of COVID, we had a serious crisis because we did not have a system that was updated with the well data thing. So if AI hits the healthcare systems, we may still be very short on that. So I would say revisit the healthcare data statutes first and foremost.
So in terms of like healthcare data, I guess, would you then recommend allowing access to researchers, and where would we start as a state? Would it be with Connie utilizing that information, or?
Actually, the bill I cited, 1331, gives you some insights into that. 1331 is the act concerning the exclusion of patient health information and opt-in and opt-out procedures related to statewide health information exchange. That's Connie. That would be a good place to start and see if, to see it through an AI lens, to see Connie through an AI lens would be a great place to start.
Great. Thank you very much.
Thank you.
Any other questions for Mr. Chatterjee? Seeing none, thank you. Angel Melendez, to be followed by Bonnie Stewart.
Good morning, Chairs Maroney, Limar, Vice Chairs, Ranking Members, and distinguished members of the General Law Committee. My name is Angel Melendez, and I appreciate the opportunity to present my testimony today in support of Section 2 of the Senate Bill 1355. I bring 40 years of law enforcement, military, and security experience to this discussion. Over the course of my career, I have developed strategies aimed at enhancing public safety, national security, and colleague protection. My work has involved advising the President of the United States on transnational crime, engaging congressional leaders, and providing counsel to corporate executives on security matters impacting business operations. Prior to joining Pfizer, I served as the special agent in charge for the New York Field Office of Homeland Security Investigations. My background in security allows me to speak with authority on the critical issue of protecting our colleagues. Pfizer is proud to call Connecticut home for the past 65 years. More than 2,000 scientists and other research and development professionals of our Groton laboratories lead the way in drug discovery and development across Pfizer's therapeutic areas, while also operating a state-of-the-art clinical research unit in New Haven. Pfizer is also proud of our 300 field-based colleagues in Connecticut who play a crucial role in healthcare industry by educating healthcare providers and other medical professionals on how medicines can help treat specific diseases and conditions. Our field representatives go through ongoing mandated training sessions to stay updated on new products, trends, and best practices while adhering to all regulations and guidelines related to pharmaceutical marketing and sales to ensure ethical and legal practices. In 2023, Public Act Number 23-171 became law, requiring manufacturers to register as pharmaceutical marketing firms with the state and including reporting requirements such as the number of contacts pharmaceutical representatives had with prescribing practitioners and pharmacists, and whether samples, materials, or gifts of any value were provided. Pfizer supports these reporting requirements and welcomes the additional transparency. Our concern surrounds the portion of the legislation requiring the prominent posting of the names of pharmaceutical representatives on the DCP website. For several years, Pfizer has faced an elevated threat landscape, posing a real danger to its employees at all levels, who have been the target of threats and harassment. Pharmaceutical representatives are one of the most public-facing employees in our industry, and publishing their names on a state website without any recognizable benefit to the healthcare system only adds one more avenue for those seeking to potentially bring harm to our colleagues. Pfizer supports the proposed removal of the language found in Section 2D of Senate Bill 1355, which we believe will go a long way to ensure the safety of our colleagues. I thank you for the work that you do in the name of the great state of Connecticut, and I thank you for the opportunity to appear before you today.
Thank you, Mr. Melendez, for your testimony here today, for your service to our country in so many different ways, and your testimony on behalf of this issue. We had an opportunity to meet with representation here in Connecticut early on in session and got informed in great detail about some of the risks that some of your employees are under because of this. We think this is an appropriate, happy medium to accomplish the public disclosure needs that we have as a state, but also ensure that your individual employees are not put in any undue risk. So I appreciate your testimony held here to help clarify that issue.
Thank you, sir.
Are there any questions or comments? Seeing none, thank you again for your time today.
Thank you. It's an honor to appear before you today.
Bonnie Stewart, I don't see in here. Oh, she's online. Okay.
Hi, good morning. My name is Bonnie Stewart, and I'm the CEO of the Connecticut Society of CPAs. I'm here today to comment on two measures. The first is House Bill 7020, and the second is Senate Bill 1357. I want to thank everyone for raising House Bill 7020. That's an extremely important bill to the CPA profession, and actually to people throughout the country, because we are in a crisis state, according to the Wall Street Journal, given the lack of CPAs in our country right now. And Connecticut is one of the states that unfortunately has seen a drop in CPAs. This measure that's before you today would modernize the pathway to becoming a CPA by recognizing that there are multiple pathways that meet people's needs while still providing individuals that have the proper experience and training to serve and serve people well. In addition to the additional pathways that have been added in this measure, there's also a provision that allows for what we call automatic or enhanced mobility. Connecticut already has mobility when it comes to CPAs from outside the state having practice privileges within the state. But what we don't have is something that would allow for the changes that are taking place throughout the country now with these alternative pathways. So as these new pathways are adopted, we may have somebody from another state that has a bachelor's degree and 2+ years experience that may want to come over here prior to the effective date of this legislation and try to gain those practice privileges. They would be turned down, even though the bulk of CPAs actually got their license that way in Connecticut now. So as these changes are taking place, the adoption of automatic mobility, which requires people to have achieved their CPA credentials in one of the 3 ways that you get licensed in Connecticut, it would give them the practice privileges here is extremely important. I use CTCPA as an example. We represent a number of CPAs in the state, and yet we were not able to get an auditor in the state. We're a small nonprofit, and others like us have great difficulty finding an auditor these days. So we did have to go out of state to get one. So that practice privilege is extremely important, and we ask for your support of this measure. It's extremely important, like I said, to the profession and the people of the state that require CPA services. The second bill is Senate Bill 1357, which has been brought to you by the Department of Consumer Protection. Sections 1 and 2 apply to CPAs. We understand what was intended behind Section 1, which they say is to modernize and streamline peer review submissions. I will tell you, as drafted, it does not do that and actually would make the measure they're trying to, or the problem at DCP they're trying to address, even worse. The State Board became aware of this, the State Board of Accountancy, at their January 24th meeting when it was first brought to their attention, and decided right away that action needed to be taken. And it was extremely important that they're the ones that started to move on this measure, because it was clear that people within the Department of Consumer Protection were not familiar with the peer review process. And why should they be? It's a very technical, complicated process that only applies to CPAs. So it's just fitting that the State Board of Accountancy is looking into this and trying to address this issue. So they are currently in the process of having amendments developed, and we'll vote on them at their March 12th meeting. I would ask that you not move on this measure and wait until the State Board of Accountancy makes its recommendations, which I assure you will address the concerns of DCP and do so in an effective and proper manner. And we will bring those amendment, or the amendment that they believe serves the DCP the best, right back to not only you, but to Commissioner Caffarelli. The second section in this bill also is a concern to us, as we have noticed lately that the lack of the CPA experience and knowledge has become somewhat problematic. For example, the problem with the peer review that we just talked about is that a year in peer review is a very different year than a calendar year or a fiscal year, the type of years that most people are used to. And they differ from person to person based on a client's fiscal year. So there's a lot of intricacies in the CPA profession. I would ask that at this time, especially because the State Board of Accountancy was not made aware of that request was going to be made, that you again allow the State Board to review what is being asked of you and have the ability to, or the time to make sure that it makes sense. I say that because you've got a number of education provisions in here in terms of classes and certificate issues that, again, may require that CPA expertise. So we're at present, we have concerns with both sections, would like to have the State Board make their final decision on an amendment at their March 12 meeting, bring that back to you, and at least discuss Section 2 in a little bit more detail. So where we can accommodate DCP, we'd be happy to do so. But if we have significant concerns, legitimate concerns, we'd like to address those so that we don't create any problems as we move forward.
Thank you, Bonnie, for your testimony today and for your help in the first bill you referenced on our agenda that I think we're in broad agreement on. With regard to sections 1 and 2 of 1357, I do recognize where DCP was trying to go and the concerns that they brought to the committee. So I think there's an opportunity for us to work together with you post the March 12th meeting you referenced to ensure that we're not putting undue constraints or regulatory structure in place for the accountants, but also take the advice that you are able to provide. So I think we'll try to schedule a meeting soon after that board vote to determine like best process to move forward with, because I think we all want to get to the same place.
Absolutely.
And so I think
there's not disagreement about the problem. It literally was a lack of understanding of the rules that surround the peer review program. So we are actually working with the National Peer Review Program to come up with a solution. And 52 of the 53 jurisdictions actually have something that works. So we should be able to come up with a solution easily.
That sounds like the good recipe there. All right, so we'll be in contact after your March 12th meeting and try to get some resolution on this.
Perfect. Thank you very much.
Thank you. Katrina Fitzgerald, followed by Cara Williams.
Lamar, Chair Maroney, members of the committee, thank you for the opportunity to testify in support of Senate Bill 1356, which updates the Connecticut Data Privacy Act. My name is Katrina Fitzgerald. I'm Deputy Director at the Electronic Privacy Information Center, or EPIC. EPIC is an independent nonprofit founded over 30 years ago to secure the fundamental right to privacy in the digital age. Many states have enacted laws based on the Connecticut Data Privacy Act, and that's why when Epic and Consumer Reports decided to propose a model bill last year, we used the CTDPA as a baseline and we redlined our recommendations on top of it. There have been some lessons learned and some new developments since the law was originally enacted, and Epic commends Senator Maroney for working to keep it up to date. The provision that is most obviously in need of a fix is the limit on data collection, also known as the data minimization requirement. The CTDPA currently says that companies can collect and use data as is reasonably necessary for whatever purposes they disclose to the consumer. This, unfortunately, incentivizes companies to list as many purposes as possible and make them as broad as possible to cover every conceivable use they'd ever want our personal data for. And they do this in a privacy policy that no one ever reads. I mean, I don't even read all of them. I wouldn't have time to do anything else. The privacy policy could simply say that they're going to collect and use my data for marketing purposes, which tells me nothing, but allows them to do basically anything they want with my data. We think that data collection and use should better match up with what consumers expect. And the Maryland General Assembly did that last year when they enacted the Maryland Online Data Privacy Act, which set a baseline requirement that entities can only collect personal data that's reasonably necessary to provide the product or service I'm asking for. And what this standard does is better align businesses' data collection practices with what users expect. So Meta can collect data about what I do on Instagram and Facebook. I expect them to do that. But they can't put trackers on every website I visit to collect and monetize my every click online like they do now, right? I don't expect when I look up symptoms on WebMD's site that what I was reading is automatically fed to Meta in the background, but that's exactly what's happening right now. The key with a good data minimization provision is to ensure it's tied to that specific product or service requested by the individual, not simply whatever purpose the collecting entity decides it wants to collect data for and discloses in their privacy policy. So Epic supports Senate Bill 1356 because it does just this. There are a lot of other important provisions in the bill, and we have a few suggestions that we outline in our written testimony that we submitted with Consumer Reports, but I just can't stress enough the importance of updating the data minimization standard in Connecticut's law to meet the standard set by Maryland. So Epic asks the committee to give a favorable report to Senate Bill 1356. Thank you.
Thank you, Ms. Fitzgerald, for your testimony, both written and in person. We do appreciate it, and specifically the references to the Maryland legislation that this legislation seeks to model. We appreciate the time that you have and highlighting the importance of early stage regulation. We wouldn't be in this predicament that we're in now, where we're trying to retroactively apply regulations to an industry that has emerged and gained significant market share. So we appreciate it. Senator Maroney.
Thank you very much for testifying and for your feedback, and look forward to continue to work with you as we move through the process.
Thank you for your leadership.
Thank you.
Next, we have Kara Williams, followed by Carmen Koa Barker.
Hello, can you hear me?
We can, yes.
Okay, great. Thank you, Chairs Maroney and Lamar, and members of the committee. My name is Kara Williams, and I'm a law fellow at the Electronic Privacy Information Center, or EPIC. As you just heard, EPIC is an independent, nonpartisan nonprofit founded 30 years ago to secure the fundamental right to privacy in the digital age. I'm here today to support SB 2 and to urge key amendments to further strengthen the bill. This bill tackles an urgent problem. Companies across sectors use high-risk AI systems every day to make important decisions about our lives. Whether we get a job or admission into a university, if we qualify for a mortgage or a loan, how much we pay for rent or insurance, and whether we can access healthcare or government services. Right now, Connecticut residents have no way to know whether companies use AI in making these decisions about them, or how these decisions are made. SB 2 addresses this issue by requiring real transparency from developers and deployers about the AI systems they are building and using. This bill also gives important rights to Connecticut residents who are subject to these systems. SB 2 is a necessary stopgap measure to reinforce consumer protection and civil rights laws as they apply to the use of AI. While existing laws, of course, do still apply to companies' use of AI, SB2 eases the burden on individuals in proving discrimination claims in which AI is a factor. AI is often referred to as a black box, and individuals rarely have access to information about how these systems work. This information asymmetry makes it exceedingly difficult for people who are discriminated against using AI to prove it, especially when companies are using systems that they do not understand and cannot explain. The transparency requirements in SB2 will start to address this problem and give more information and control back to Connecticut residents. However, SB2 does require a couple of amendments to more fully address the issue of algorithmic discrimination. First, the duty of care provisions should be strengthened to instead prohibit companies from using or selling AI systems that cause algorithmic discrimination. Second, the enforcement structure should be strengthened by adding a private right of action, which is already a traditional remedy under Connecticut's consumer protection and civil rights laws. Both of these changes would align SB2 more closely with existing law and avoid muddying discrimination claims that have an algorithmic discrimination component. These amendments would ensure that SB2 recognizes that algorithmic discrimination is just as harmful as discrimination by any other means, and gives Connecticut residents who are harmed by companies using AI access to the information that they need to hold these companies accountable. The risks of relying on AI systems to make important decisions about people's lives are real, and people are being harmed every day by the unregulated use of this technology. SB2 would be a welcome step toward mitigating those risks. With our suggested amendments incorporated into SB2, Connecticut could both protect the rights and privacy of residents and encourage responsible technological innovation. Thank you for the opportunity to testify today, and I'm happy to answer any questions.
Thank you, Cara, for participating here today. Are there any questions? Senator Maroney.
Hey, Cara, thank you so much for testifying. And I'm going to ask this question. You don't have to answer it. It's just a thought. I'm kind of thinking out loud here. I understand, right, we don't allow discrimination, right? Discrimination is illegal. But with the algorithmic discrimination, I don't know, like, because we know there is bias embedded in almost all systems, and we're trying to mitigate and manage the risk, just like with, driving a car. We're not going to prevent accidents, but we require people to wear a seatbelt and do other things to make it safer. I guess my concern is if we do an outright prohibition, we wouldn't necessarily be able to use any AI system, but then I want to make sure we're not taking away existing rights. So I agree with you that transparency is key, right? So that people will know that AI was used, so that if they do need to test it for the outcome, they would have their existing rights. I guess I'm trying to balance that, right? I see why you would want the outright prohibition, but I also am concerned that, our goal is in managing risk, which you can never completely eliminate a risk.
Right.
I guess I'm trying to strike that balance. I don't know if you want to offer thoughts there, and then also just on what you would prioritize for the bill, as you think the transparency is the most important piece, or what are the other pieces that you would think would be most important?
Right. So I'm not going to attempt to tackle that massive question, but I do have some thoughts. If I had a magic solution, I'd be happy to provide it. But I think we're all in a bunch of different states still trying to balance exactly the concerns you raised. So I do think the transparency pieces of SB2 are essential. Like I said, this strengthens people's rights in other contexts like civil rights claims and consumer protection claims. So those pieces are essential and should be strengthened and retained. I also want to point out that there is a risk of discrimination in these systems. Like you said, we do know that they cause bias oftentimes right now, but that doesn't mean that individuals shouldn't have recourse for that bias. That goes to the point about the private right of action I was making as well. Individuals should be able to take action if the systems do harm them. The companies that systems choose to use harm people, they should be able to do something about that. And as to the point about testing, I can follow up with language later, but we have seen in states that have introduced bills fully prohibiting algorithmic discrimination, they often have language in the definition of algorithmic discrimination that allows companies to self-test and mitigate discrimination. So we're not saying that companies can never admit that these systems are biased, we want them to recognize if their systems are biased and take steps to mitigate that concern.
Great. No, thank you. Yeah, again, understood that the big difference between discrimination in a person and in AI is we can test for it, but more importantly, fix it in AI, whereas a person will probably never admit if they didn't hire someone because they're a woman or another reason. So thank you very much for your time and thought.
Thank you, Senator.
Carmen Koa Barker, to be followed by Adam Devine. Good afternoon.
I had an interview, but I'll wait and listen to you because you've been sitting there all day.
It's gonna be really quick. Okay, sorry, it's gonna be really quick. So we are here today. I'm here with the owner of Division 5. It's a small structural manufacturing steel company out in Stafford Springs, Connecticut. We are here today to express our support for House Bill number 5685, which speaks to prohibit pay if paid clauses in construction contracts and ensure timely payment for subcontractors and suppliers. This time last year, I was here with State Representative Kurt Vail. He represents the 52nd District, and he stated for the record that he does support Senate Bill 135, but he did request some changes be made to add language to support small businesses' timely chain of payment between owners, contractors, and subcontractors on construction projects. He did submit a lengthy written statement last year where he suggested that sections 42-158J of the Connecticut General Statute be amended to model the terms of the portion of Virginia's law that prohibits the use of pay if paid. So Virginia is the 7th state to make this paid if paid clause unenforceable, and I hope today Connecticut will support this bill to be the 8th state. I could continue, but if you guys want me to, or if you have questions, or because I know you had to run away, I apologize.
No, that's all right. I mean, this is one of those issues that's really complicated to me because I'm trying to determine who ultimately should be responsible for paying a contract if like the general contractor does not pay one of its subs and you're sub of a sub, like how far down the line does this go and how do we find who the responsible party is? So it's something that I'm looking at other states' models for to determine what the appropriate way to do it is. It seems wrong that the person at most risk is the person lowest down on the food chain, right?
Yeah, that would be me.
Right. Is
Right.
the person who's carrying out the basic day-to-day job responsibilities. They don't get paid because someone 4 steps above them didn't pay somebody else, and ultimately the nature of these contracts seems somewhat exploitative. So that's where this bill comes from and why I think it's a really interesting policy area for us to delve into. So I appreciate your testimony.
Okay, just want to speak on that from personal experience, what
Yeah.
I've experienced being in the business. You would have some really dishonest contractors, general contractors. They will get paid. Then they would tell us, hey, as per the contract, you only get paid if we get paid. So they were dishonest. They would receive payment, they would take those funds and invest in another project. So this leaves us now with the financial burden, which is funds, we rely on to pay our vendors, supplier employees, and things like that. So now the financial risk is now put on us. And of course, then the next step we can go to is the mechanics lien, and that's a whole nother process in itself. And that's also taking away funds that we could use for another project. And as we know, this is not an isolated situation. We're just asking to be paid in a timely manner. If it wasn't for the dishonesty and for finding out that there is dishonesty, we wouldn't be here today. And we're not the first state to realize that this is an issue. There are 7 other states, and I think there are 9 other states that have a little, they don't have it as unenforceable, but there are some leeways to say, hey, you really need to pay these subcontractors in a timely manner. We've finished some projects since 21, 22. It's now 2025, and we're still waiting to get paid for it because you're telling us they're still waiting to get paid for it. So I believe if we put a little bit of press, light the fire under the contractors, maybe that would say, say do the right thing then, basically. And we're not asking to be paid, right away. We're not asking for something that we're not due. We're just asking to be paid fairly and in a timely manner. And that's, kind of why, we're here trying to say, hey, if we could just get this far. Again, we wouldn't be here if it wasn't that dishonesty going down the line.
Yeah, no, it's a complex issue because ultimately, like, there's competing interest. Like, one, like, your subcontractors will sign the contract with you with this clause in it, but oftentimes those people feel pressure to sign that contract because those are the only contracts that exist, are these pay-to-play,
Yeah.
paid contracts. And so therefore, it's like a current just standard business practice in many industries to have these pay-if-paid clauses, which don't exist in most other business relationships in the state. Like, my good colleague to the right can't essentially decide to not pay one of his vendors because he didn't get paid for a wedding last night,
Right.
or something like that. And like ultimately, as a nature of a business relationship, if you have a relationship with a sub, it's on you to pay your sub, and it's on you to negotiate with the person who's supposed to pay you. And so I think trying to figure out the right balance is incumbent upon this committee. So I appreciate your testimony.
Right. Thank you. And just to say that the issue is, whereas if you purchase services or goods from someone, or, and you say, hey, they don't pay, you could take them to court. Hey, say, I did provide the service. We can't do that
Right.
because they say, hey, we never got paid.
Right.
Okay, well, if they didn't get paid, you don't have any grounds to stand on because your contract says they get paid if you get paid. A lot of times these contractors have way more money than we do, so they continue to extend it in court, they continue to file appeals, so it's just an ongoing process that continues to burden a small business like myself.
Representative Tigliano.
I was gonna, the good chairman asked you about the standard contract. I didn't know, when you sign on to a job, I'm just sort of taking the other side just for a second. I am totally sympathetic to what you're testifying to, but you're free to negotiate that contract in any way you choose, correct? Is it one of those things where if you don't say yes to this, you're not going to get the job? Is it that sort of intimidation? I guess is my question.
It does happen. It has happened. It does happen. We do have some cases where it's, it's a contract that we know, hey, this is really going to be beneficial to us. This is something we can definitely do. But then it's in there like this, we at a higher risk then. So if we get a contract for $2 million, that's a lot of paid if when I get paid money sitting there versus if you get a contract for $20,000, I think I can handle that risk. You know?
But when you're talking with a contractor, do you have the ability to say, hey, listen, 30-day terms, or the minute what is it, the sign off from the building inspector,
Right,
30
right.
days from that point.
Right.
Do you have the ability to negotiate that into the contract, or is it sort of like more of a take it or leave it situation, I guess would be my question.
That's a really good question. From when I came into the industry, it was a take it or leave it. It was a take it or leave it. I have not seen anywhere where we've tried to negotiate. And that's where I came and I said, this doesn't sound right. This doesn't sound, it's a contract. It should be negotiated. But as they would say, oh, this is how it's always done. So me as a minor person, I'm like, okay, all right. So, and then again, with the paid if paid, and then we have our vendors. So now we have our vendors, they provided us the steel, we designed it, we installed it, we did all of that. Our vendors now, they're on a 30-day or might be a 60-day payment terms. So I have a 30-day net with my vendors, but then I have a paid if paid with my general contractor. So this leaves us now, how am I supposed to pay my vendors? So the contracts.
So you have a cash flow problem. What do you have to
Oh.
borrow? If that happens, what do you borrow? Short-term lend?
That does happen
And then
and
you
it
have
has
interest on
happened.
top of
And
that.
then we continue to end up in more debt in regards to that.
I totally understand your issue. I really do. I didn't know if maybe they didn't give you an opportunity to at least negotiate for yourself. But I thank you for coming out. And thanks to Representative Vale did bring this to our attention. So we
Yeah.
appreciate it. So
All right, thank you so much for your time.
Thank you. Yes, we're doing this despite Representative Vale. So no more questions. Thank you again. We have Adam Devine, followed by William Martinez.
Representatives, Senator, thank you guys for having us today. Appreciate it. Adam Devine, Managing Broker, Dorrance Realty, Co-founder, Perch Rock Real Estate Marketplace. I'd like to talk today a little bit about HB 5572 and our opposition of the bill. Assignments have been around for many of years in many of industries, finance, insurance, private equity, hedge funds. This is something that's been pretty ongoing in many different regulatory rules. I'd like to talk about that and say that there's a lot of bad actors out there. And for us, we really pride ourselves on being the pioneer to do the things the right way. We've spoke with the CT Realtors. We've spoken with several other folks. We even had a nice call with Zulo on Monday. So for us, we really would like to start to see the right things put into place here. 10-day right to cancel. We believe that's an interference on contract law. What that says there is you have the ability to go shop this offer. I have an offer, and then I have 10 days to go bring that to my counterparts and competitors. Again, always for things to protect the consumer. This is a real leg up for them to say, hey, listen, there's a better option out there. So it ultimately interferes with business being done. Could be said it's unconstitutional, but that's another conversation. 16-point fine. The 16-point fine is, it's a fear striking into a seller to say, hey, there's a problem that doesn't exist. For us, we're less than 1% of market share in the entire state of Connecticut. In this state, it's not a title state, so there's attorneys involved in every transaction. There's a buyer's attorney, there's a seller's attorney, and then there's an investor's attorney. If there's, some kind of mediary there, putting that in place is going to do nothing but destroy the ability to transact. That'll be a huge red flag for any seller to see. 70 days to close is pretty unrealistic. I mean, again, some of these deals drag on for tenant issues, issues with the seller having to relocate. So there's a lot of things in there. Even if we look at the average days to close on a regular transaction, it's significantly higher than 70 days. Ultimately, the bill doesn't do what we believe protects consumers at all. We understand where the bill is coming from based on conversations. This doesn't have anything to do with the protection. It's the elimination of our business. We've heard it from attorneys. We've heard about it saying we make all this money. I haven't seen it. I know our overhead is drastically high in this industry. And for us, we want to lead the way and say, hey, what can we do to help put something in place to work with the realtors as well as the investors collectively? Ultimately, that's what I have today. Have any questions? Thank you for your time.
Thank you. And I think you helped to highlight that there are some bad actors in this industry generally, and Representative Zula did a good job highlighting very specific ones he's encountered in his day-to-day practice. And I think that's sort of where our committee is going to come from. Representative Zula referenced a willingness to work with you and industry folks to determine the best ways to regulate against those bad actors. And I think that's the important direction that we're going to take as a committee is determining what those appropriate restrictions are. Like I said, in all industries, folks who are just going about doing an honest work and an honest job are fearful of regulations impacting them in a negative way. But oftentimes you can recognize where the regulations may need to be buffed up a little bit more. And so we're going to talk to you and others in this space to see what protections we can put into place to the average home seller who does have a lot of risk inherent in this business contract and may not be as sophisticated with the understanding of the real estate market and the timelines and the direction of it as the person who's purchasing their home on this option. So I think there are regulatory structures that we're looking at. And so we might be in contact with you to determine the best way to apply those regulations. Are there any, Representative Retigliano?
Real quick, is your business registered with is there a license for any of your businesses? Is it registered at all or just with the Secretary of State as an LLC or something like that?
All of our businesses are registered in the state of Connecticut that we do business under, including my license as a broker, my business partner as a licensed agent. Most of our folks are licensed in our office because we want to go above and beyond rather to say, hey, there's a lot of those other folks that aren't invested in it. For us, we'll do everything we want to do to be as professional as we possibly could be.
Are you required to have a real estate license to do what you do in the wholesale business?
To buy and sell a home? No. I mean, that's all we're doing. The word wholesale is a buzzword, right? It's really the contractual legal term is assignment. I'm assigning my right of an agreement to somebody else. Do you need a license to buy and sell a vehicle on Craigslist? No, you just show up with a bill of sale and you sell it. It's a very simple concept. I know a lot of sellers, it's been a huge uptick for us about their complaints where a realtor promises them the ability to sell a home for a very low amount of money out of their pocket to pay for fees. They see a 7% realtor commission, a $4.95 doc prep fee, and then an $8.95 processing fee. So they're starting to come to us and we want to say, hey, listen, we're licensed folks, right? I own a brokerage. I have to register. I have to do everything required by the state of Connecticut. Our reps in our office, they're licensed agents. You can look us up. You could realize that we have to follow the same requirements of disclosure. We always have to disclose. We have a lot of consent. I can't speak for others, but our forms, all of them have consent to say, hey, this is what we're doing. We're assigning the property. We're going to find an end buyer. And transparency has been key for us.
So you say you have a form. which I would love to see, by the way, if you want to.
Absolutely.
And is that standard throughout your industry, or do you just have a developed form for your particular company?
Yeah, great question. So what our attorneys do, who we work with regularly, they advised us to take that step forward to put that in place. So we have one for any type of MLS consent. We have anything for assignment consent. All of that's in place. So a lot of the stuff that we're seeing is that these issues, or so to be said, a lot of them are arising from seller's remorse, right? A folks says, hey, I want to sell my home. My tenants don't pay rent. Okay, great. Here's the disclosure. This is what we're going to do with the property. We can give the tenants cash for keys. We'll clean the home out. There'll be no realtor commission. There'll be no closing costs, no attorney fee, no conveyance. We're covering all of it. But then they come to find out, they have that feeling towards it, which for us, we're protected because, again, we make sure our documentation is in place to say we've disclosed everything. So we don't run into those same types of problems that are being discussed.
So when you say no conveyance fee, somebody's paying the conveyance fee. It's just not the homeowner.
It's us. Yeah, it would be
Yeah,
us.
it's you guys.
Yeah.
So if somebody has a problem or they feel they've been aggrieved by your company, what's their method of redress?
For us?
Yeah, for them, for the consumer. I'm just saying, I'm not saying that it happens. I'm saying that if it was to happen, somebody had an issue with whatever, how do they address their grievance?
Well, I mean, you can go to the Department of Consumer Protection and put a complaint in, right? It's a very common practice that we see.
But you said you didn't have a license, so why? Does the DCP even regulate your industry? I mean, it might do your real estate license, but if you did, you're saying you could do this without a real estate license. Where would they go?
To put a complaint in or
Or
grievance.
just-
Yeah, they'd go to the Department of Consumer Protection, which is done now. We know several other investors out there that have had the complaint. Jill Conklin will then send over a written testimony or response to that complaint, asking for a response in 14 days. So when we talk about regulation, I mean, it's already in place. You have to respond to the DCP if you have a complaint put in.
Is it only in place because you carry a broker's license or just because you exist?
It's for anybody. I mean, whether you have a broker's license, a realtor's agent's salesperson's license, or you're not licensed, if you're just one of those operators out there that buys and sells, you didn't decide to go the extra step and become licensed, they would go to Jill Conklin. They could put that complaint in. They can also go to the AG and put a complaint in. I mean, I've seen what those complaints are from, unfortunately, folks that have had complaints put in. They say, hey, Adam, can you take a look at this? What do you advise doing? Oh, I'm not an attorney. I can't do that. But I've seen what it looks like and what repercussions are. You have to respond, and there's potential further actions on that. So when we talk about being held accountable, it's kind of like any other unfair trade practice. If you're doing the wrong thing, you're going to get those complaints, and you're going to have to speak to the powers that be about it.
Do you think with some sort of regulatory structure, just, I'm not saying I'm in favor, I'm saying I'm asking you a question. Wouldn't that help a company like yours that's doing a better job than everybody else to sort of shake the tree and maybe get rid of some of the unscrupulous actors out there?
Yeah, that's a great question. I guess we'd have to say what are the unscrupulous actors and what is it that they're doing? What is the volume? From what we've been told from several folks is that there was only a handful of complaints. We were on a call with several folks from CT Realtors and attorneys. There were only several complaints last year of the hundreds of transactions that were done. So we have to ask where are those complaints and what are they and what can we do to address? There really needs to be a very gray area that we cover everything. It's not a black and white type of thing, right? And who's regulating that, right? Is that the realtor board or the CT Realtors regulating wholesalers? When we sat with them, we had to educate them on what it is that we do. And I'm happy to do that. I've always opened up any type of luncheon, roundtable discussion. We're all for working with them. If we all work together, there will be more money made for all the folks, agents, brokers, investors, buyers that don't have the ability to get access to these deals that are sold off market. So hope that answers your question.
I appreciate the discussion. I really do. Thank you for your answers. Thank you, Mr. Chairman.
Senator Chicarella.
Thank you. And thank you for coming up here and testifying. And I understand this is your profession. Sounds like you operate a above board shop. And as you said, you were speaking with Zulo and you pointed out some of the concerns that's in the legislation, the 10-day right to cancel, closing in 70 days. And it sounds like we are willing to work with both sides to come up with a finished product that does address the bad actors and have a level of consumer protection. Is there any things that you would recommend besides those two to take out of this bill that you think hinders you guys conducting business.
Well, the 10-day, yes, that would be removed. The disclaimer, that would be removed. The 70-day, that would be removed. And then for the licensing, what does it look like? Sure. Do we agree that there could be some more structure in place to, again, oust the bad actors or the folks that are less knowledgeable? Can we provide some kind of training course to require them to go through in the state of Connecticut and how that's structured? I know us at PerTrack, we're more than happy to help with that type of organization to help folks do the right thing. Because again, there's a marketplace for it. It's quite a big marketplace, but again, it's never going to be anything close to what the realtors do, right? We're never going to be able to get that particular big circle. We play in a very small niche. But in terms of that structure and regulation, we're happy to cooperate within reason. Again, it can't permit us from doing business where we're presented as the bad apple. That's what we feel right now in our industry. The term wholesale, again, I can't stand that term, right? We're a marketplace. We want to merge buyers and sellers. But for us, what can we do to put the right stuff in place for everybody, right? That ultimately allows us to do business, but it does regulate us at the same time to follow a certain protocol. If that makes sense.
Sure. No, it does. And again, as I said, when I was talking with Representative Zullo, I've talked to individuals on both sides of this issue. Other professional realtors that have whether it's a side business or perform the service that you're doing on a daily basis. So I understand that there's a place for it. We don't want to hurt an industry. We want to be business friendly here, but we have certain concerns. To Rep. Retigliano's point, if there's an individual that doesn't hold a license that's governed by DCP and there is a complaint, there's not much they could do. The individual that feels that they were wrong by that business could take legal action. Clearly, if they don't have the money to fix up their house, they're not going to be able to hire an attorney to advocate for them. Even if the AG, wanted to go after the individual and they had an LLC, we see in all different professions, you just get another LLC. They close the LLC, get another LLC. So we're trying to address a concern while not, again, trying to be anti-business in any way. So that's why the questions were, and again, maybe offline we could speak and see what we could do to address both of those concerns. But we do want to make sure that there is protection for individuals that may be in a vulnerable point in their life, don't have the means to litigate something if it gets to that point. As you said, you're aware of bad actors in your area that give you a bad name. I'm a member of a professional association with my profession, and that's one of the things that hurts us a lot are individuals that are doing bad things, and we see it all the time. I'm on Veterans Affairs. There are professional, great businesses that provide certain benefits to veterans because it's hard to navigate paperwork and getting things you're entitled to. But unfortunately, those good actors that help our veterans, there's a series of bad actors that are taking advantage of veterans. So I'm sensitive to both sides, but we need to find that middle ground. And that's what we're hoping to do by having this process and then speaking offline to come up with a finished product that will address everyone's concerns. I appreciate you coming up and testifying.
Thank you.
Thank you. A few little things. I think the conversation's been illuminating to me, and I think I wasn't going to ask these questions now, but I think I want to try to get to the bottom of it. When you offer how do you market the properties that you have under contract? Like, how do you when you approach an individual, how do you solicit that person? Is it like you call them, text them, you recognize, like, how do you determine what properties you're going to attempt to not acquire? You don't intend on purchasing the property. You intend on getting a contract and then selling the contract. How do you determine who to approach?
Just to confirm, I understand your question. You're referring to who do we approach to acquire the asset, or
like, how do you determine how you're going to acquire and which contracts you're wishing to acquire?
Yeah, great question. So, I mean, there's a lot of different data points. There's a lot of ways to market for a property. I mean, for us, again, we try to do things on the up and up. I know mentioned before it was that there's nothing wrong with cold calling, but if you look into TCPA laws, it'd tell you a different story, right? I've been doing this industry almost 10 years. I'm quite aware of the ins and outs and a lot of the stuff that gets overlooked. But for us, and we try to do everything as transparent as possible. We run television commercials, online ads, Google ads, a lot of stuff that you can see on us for our marketing. It's outbound and inbound branding. So we take a lot of pride in our brand, right? We take a lot of pride in our reviews. And again, the brand speaks for itself. There's a reason folks work with us. I mean, for the last 5 years, we've been the leader in the amount of transactions done in the state of Connecticut. And for us to continue to do things the right way and keep that positive brand, we have to do things on the up and up.
Yeah, and I think that's important. Having like reasonable, rational actors in a marketplace makes it easy to have a robust conversation about what the appropriate rules and regulations should be. So when you have an industry that is also dominated is the wrong word, but there's a number of actors within the marketplace who may be taking advantage of people who are under distress, right? Who are unfamiliar with the local real estate market, who are not dealing with a licensed broker or a licensed real estate agent. It's just someone who's essentially cold calling. They look for, I mean, the Consumer Reports thing that I saw is like they look at obituaries and call up next of kin and say, we're looking to acquire your asset. They look at neighborhoods where there are a number of foreclosures and start calling people, and they feel like they're being threatened or being told, and there's a product out there that's going to help save them before their property goes down in value. And then ultimately, people sign a contract with someone in this space who never intends on purchasing the property, right? Like oftentimes they're signing a contract to purchase that home, but that person never intends on purchasing that home. They intend on selling the contract. So when they market the property, they don't then market the property like, they don't say like, hey, come please buy my contract. They essentially say, hey, come please buy this home. They essentially are selling the home, but really what they're doing is selling the contract. And it ends up like as an investor to investor sale rather than a traditional real estate listing that most people are familiar with, right? So the rules and regulations that we've put on brokers or agents on fair conduct of business, disclosure laws, like it seems like an end around is the wrong word, but it seems to exist in a more gray space than our traditional real estate market exists in, and that this committee has experience ensuring that protections are in place for. And so I think you probably understand like why there is concern about how this marketplace has evolved and the potential problematic elements that Representative Zullo identified. And I think as additional transactions take place in the state, there's going to be growing worry that individuals who are oftentimes in distress may be taken advantage of and might not have the same protections and the same regulatory scheme in place. I think you understand why there's some concern here, and you're hearing it from us that there might need to be something.
I know for us, and we always see attorneys on every side of a deal. So for us, it's I guess I would look for more clarity on what you're projecting in terms of what that looks like. You know, again, maybe I misunderstood, but I think there's a lot of bad actors in everything altogether. There's agents out there that tell a buyer that they can get them approved for a mortgage that they can't get approved for. We just bought a home from a seller in East Hartford. Home was purchased for $250 back in 2022. It was listed at $215. FHA buyer. They're now underwater $275. We're closing in 2 weeks. So, I mean, there's a lot of ways to look at it and how we can regulate things. I think ultimately we're on the same page here. We're happy to work together and put something that is in place that works for everybody and allows business to continue to move forward without the impediment of folks being able to buy homes.
Thank you. Any other questions? Representative Aniskovic.
Thank you, Mr. Chair. So I'm just trying to wrap my head around the whole process of this all. So when you're promoting and you're trying out there and you're advertising that you're paying cash for homes, correct?
There's a couple different approaches you could take. I think the most common one is, hey, we can buy your house cash.
Okay. So if you're out there and you're advertising that you're paying cash for home, but you're technically not, I mean, you're buying a home and then you're reselling the home or reselling the contract, correct?
No, we're assigning the contract.
Okay,
We're not.
okay, assigning the contract, but you're assigning the contract at a number then that you determined?
Correct.
Okay.
Well, what's agreed upon between the end buyer and the assigner.
Okay, correct. But then when you're going in and you're trying to buy this property from a seller, your cash purchase offer isn't related to any appraisal done on the property?
No.
Okay, so then how do you determine what that number is?
You could look at sale comps in the neighborhood, and we do residential homes, so it's
Okay.
pretty easy to arrive at what a home is worth. If there's a 3-bed, 1-bath, 1,500 square feet that's fully renovated, and another one that is dated and looks like it hasn't been updated since 1992, I think it's safe to say we can then work backwards, have a GC, or for us, we have different technologies and softwares to arrive at what the as-is value would be of that home. Again, I'm not an appraiser, so I can't speak to actual values. But I mean, there's a couple different tools. I mean, folks use Zillow, for example. Hey, my home is worth X. Zillow's not an appraiser; it's a technology platform. So
Understood.
yeah,
Okay.
it's
So I've
kinda-
been in the mortgage business for 30 years. So I'm just trying to kind of get a part of, how this whole process works, with the understanding. And I think that the regulatory piece is the important part. So obviously we're here to also protect the person that's selling the house. And if they're going and they're selling a home, how are you then determining a value without having an appraisal and using some of the other platforms that are out there, whether a house is or is not, updated, or, things have been done to that house in any number of years. So, reselling or assigning, I should say, that contract to somebody else, obviously, and I think just hearing the conversation, I think a lot of it just has to do with regulatory oversight. So like when you're advertising a house, you're not advertising that you're a licensed realtor.
I'm not sure I follow. I'm not advertising the home. I'm selling the contract.
But if
it's
you go to your
disclosed.
website, you say we buy homes for cash, which is insinuating that you actually buy the home.
Our site discloses our purchase agreements, everything. Our documentation discloses we're licensed professionals and we're licensed realtors. So
Understood, but
we
what I'm
disclose all.
understood, but it still says that you're paying cash for a home, correct?
Correct. In some cases, not in every case.
Well, I guess that's the misleading part.
Well, if
So
we're-
the misleading part to a consumer would be if they're looking at a website and they say, sell your home quick for cash, correct? You contact, if that person contacts you, you contact them, you're coming up with an amount that you're going to pay cash for that home.
Could be cash. It could be a DSCR loan. It could be hard money. It could be private money. I mean, the
Either
term
way-
of cash, we defining cash at close, like we showing up with cash. Is it a bank check?
Mhm.
So there's several different approaches.
You're not putting a lien, you're not taking out a lien. You're going and you're physically paying for the home so that you take ownership of the home.
In some
And then you
cases.
can assign the contract.
No, we don't always take title to the property, if that's what you're
Okay,
asking.
that's my point again. So then this is, I think, with the problems that kind of we face on a committee is that there needs to be some regulatory oversight on this space. And the reason there needs to be is that realtors do it differently. So this is a different space. And yes, there's bad actors all over. Like I said, I've done this 30 years, bad mortgage brokers, bad bankers, there's bad everybody. And again, I think the protection that we need to help and try to provide to the consumer, to the person that's going to sell their home, is that they need to make sure that, they're being told up front how this transaction will take place. Because a lot of times, and I guess we would need to see what documentation is provided so that we understand what those people are getting when they're going to sell their home. Because ultimately they're selling their home. All they know is we're selling our home.
Everything that you just mentioned is what we disclose, verbally, written, so it's all there in terms of what that looks like for the seller and bad actors. And that's, again, it's
right.
Who are they? What are they doing? I think examples would be great, but I agree. Sure, there's regulatory that could take place within a degree.
Okay, thank you.
Thank you. This has been a great exploration. I think there's a lot of interest in looking at this a little bit more, and I appreciate your time and effort with us here today.
Appreciate it. Thanks, guys.
William Martinez, followed by Robert LaChance.
Good afternoon, Co-Chair Maroney, Co-Chair Lamar, members of the General Law Committee. My name is Willie Martinez, and I represent the State Privacy and Security Coalition. We're a coalition representing over 30 companies and 6 trade associations across a wide variety of economic sectors. In addition to my advocacy work, I have a background in data privacy compliance, and I'm a certified AI governance professional. We appreciate the opportunity to provide input on SB2 and have submitted detailed written testimony outlining our concerns and recommendations. First, we want to commend the bill sponsor, Senator Maroney, and his office for their dedication and engagement with stakeholders throughout this process. We recognize that this is the second year this legislation has been considered and appreciate the ongoing efforts to refine it. Our organization has worked with the sponsor in the past, and we look forward to continued collaboration. As mentioned previously by other witnesses, There is no national consensus on comprehensive AI legislation. While Colorado recently enacted the Colorado AI Act, efforts are already underway to revise it as the sponsor, the governor, and stakeholders acknowledge that the law is not yet ready for implementation. Similarly, Virginia recently passed HB 2094, and it remains unclear whether this bill will be enacted as it awaits the governor's decision. Given this evolving landscape, we urge the committee to proceed cautiously in regulating AI to ensure a well-balanced, interoperable, and effective framework. With that said, while we oppose the bill today, we seek to amend certain sections of the bill in order to establish interoperability throughout the states. For example, we recommend removing the term integrator. As written, this category introduces ambiguity into the AI supply chain and confusion about which entities are subject to its requirements. The duties assigned to integrators merely compel developers and integrators to allocate responsibility through contractual agreements, something they would need to do regardless of a legal mandate. We're also concerned about the affirmative reporting obligations to state authorities under Section 2 and 4 and encourage further discussion on these provisions. Our written testimony provides additional details on these and other concerns, and we welcome the opportunity to collaborate on a workable and effective AI governance framework. Thank you for your time, and I welcome any questions.
Thank you for your testimony here today. Senator Maroney.
Hey, Willie, thank you for your testimony. In looking through your written testimony, you had some comments on definition of consequential decision. I think that is an area we do need to look at. I did look back at our previous data privacy bill because it really is the same as decisions that have significant legal consequences, and we didn't include judgment there, but we did, as we pointed out there. So I think for consistency, that change makes sense. One of your other changes, I'll just point out, you're asking us to change something that was requested by one of your members, so I'll talk with you about that offline. I guess the purpose of the integrator, and this is something we need to talk through to get to, is so if you've developed a general purpose AI model or one of the large language models, once you change that, right, for your own purpose, then you become the developer. The concern, if we don't put in requirements when you go developer to developer, is that the person who has changed this to make it a high-risk AI system, right? So they're integrating the API, using that to make a decision for something. I feel there needs to be an obligation for the original developer to give them the information they would need to comply with the law. Agreed, it may not make sense to include integrator as a term, but I think we need to look at the developer to developer responsibilities within the bill. So I don't know if you have thoughts on that.
Just thinking back to interoperability, I know in Virginia, HB 2094, initially they did include integrator, but in the final version that passed the House and the Senate, that term was removed. So thinking about interoperability, that's why we recommend removing the definition, but we would agree that when one of our recommendations, we recommend that deployers notify other deployers or developers of any changes in their systems or known risks to their AI models. So I think something along the lines of contractual obligations, similarly to the data privacy space, when we have controllers and processors agreeing to certain things, I think something like that approach would be better than classifying a new category of integrator, which leads to blurry lines between developers and deployers that could potentially fall within multiple categories.
Right. And I actually modeled it off of, right, we say the processors and controllers, their relationship has to be defined by a contract. So that's kind of what we're using here for the developer to integrator, or I think it would be a developer to developer responsibility, probably in the end bill. Texas proposed bill does have the term distributor, which is similar to integrator. So it's still, this concept is kind of being floated, but I think it can be solved with the developer to developer obligations. So the affirmative reporting, beyond, I think for the affirmative reporting to the AG's office, we just require you disclose if you discover that a system has discriminated against more than 1,000 people. And we try to model that off of data breach legislation where, you know, if one person's data is breached, you don't have to notify. But there comes a level where I think that the AG or the government needs to know. So are you arguing at all about that, or that the level is wrong?
I think we just need, there are some concerns around these reporting obligations, and I think, you know, we can talk more offline about the concerns our members have. But yes, I can see how that can be framed similarly from the data breach statute, and we just welcome further conversations on that piece.
Okay, thank you. And then the last thing I'm going to ask, you know, in your testimony, and I've seen others who are saying that an annual impact assessment is too much. But, you know, most of the risk management frameworks based on model drift and the fact that models change, they require ongoing and recommend ongoing assessments. So as an AI governance professional, certified AI governance professional, do you have a recommendation then on what the time frame should be if you think a year is too often? And I think there are some who would argue that that may not be often enough.
I think anytime there's an intentional and substantial modification to an AI model, that would require a revised impact assessment.
But I guess my argument is that because the models change as they learn, right, and infer data, that we can't just wait until it's an intentional and substantial modification. There has to be a time period when we're reassessing to make sure that new risk or bias hasn't been introduced into the system.
No, yeah, I understand that concern, Senator. And so your focus on the question is whether annual is too often, or what time
I think you
frame?
testified that annual is too often. So given that I believe most risk management frameworks would recommend regularly testing, what would the interval be if annual is too often? Because I don't think you can wait, because as we've mentioned of the model drift, these models change, they grow, they ingest new data, learn, we can't wait until an intentional and substantial modification for new testing. So I don't know if you have recommendations. And if not, you know, we can.
Oh, yeah. We can follow up. Yeah.
Okay, great. Thank you very much.
Thank you.
Seeing no further questions, thank you again for your testimony today.
Thank you.
Robert LaChance, followed by Carmen Clarkin and Dr. Emily Knox.
How are you? Thanks for having me. Appreciate it. I'm in opposition of Bill 5572. You guys did a phenomenal job talking to Adam Devine, so I don't want to beat a dead horse over here. I've been in business, real estate agent and investor for well over 20 years. So I've seen a lot of stuff happen. And I'll just talk clearly about this bill. I also want to thank Representative Zullo. We met with him on Monday, had a great conversation, a little over an hour, to try to work through a lot of these things. But in particular about this bill, I feel that this one violates Fair Housing Act under the definition of steering, which is illegal. Because if you look at a lot of these things, and I'll break it down for you on how I look at this. Two things. Number one, this is brought upon by the Board of Realtors. And what it looks like, if you look at the end result, number one is steering and the other one is creating market share. So they're trying to eliminate one industry to gain them access to more business. So we look at things and go down the line. Licensing, I think we've talked about that. We all agree that we could work together on creating something. Like I said, been in this business for a long time, and you know, you've seen a lot of those bad actors out there that we would love for them not to be in this business, right? So again, I got gray hair now because of this business, but it's just part of the game. The second part on this, when you look at the bill, again, brought upon, it's clear it's brought upon by the Board of Realtors. And again, I kind of feel bad because I'm an agent myself. So it's like I'm arguing with myself. But If you look at these on the second part where it says wholesale contracts and 10-day period to allow it to walk away, that could be construed as steering where you're influencing someone to go somewhere else, right? So if I just look at those two things, and if you look at what would happen if we allow these contracts to be in place and then you allow it on regular retail transactions, or you allow this on a listing agreement. Now, if I'm an agent and you put this wording on a listing agreement, you know, I'm a seller, I'm going to shop it to everybody. I'm going to say, you know what? Oh, you're charging 3%. I'm going to go to, hey, could you do it for 2%? Could you do it for 1%? So if you look at what this looks like, the trickle-down effect could be very damaging to the agent world. So that's, and obviously the investing world. Next part is a 16-point font. Again, I know you guys touched upon this, but if it has a 16-point font, that is in essence steering someone to not work with that individual, but push to a different industry or different type of transaction, if you will. Now, it's also an attempt to eliminate competition. If this is allowed, I mean, I love it if I put my marketing hat on. I mean, it's a phenomenal marketing ploy to get this bill passed because then I really don't have to work hard to get listings. All the 1% transactions are going to be pushed to the real estate agent world. So if you start looking at that, that's again, that falls under attempt to eliminate competition. And then the final thing is the closing date, 70 days. I think you guys, we all addressed that one. So I don't think we have to touch upon that because if that's put into regular retail transactions, when average days on market are around 120, kind of doesn't align. But licensing, I know that's one of the big things.
Some pretty solid points there. I appreciate it. Look, this is again, the exploration that this committee is going to go on this specific issue, I think is interesting because it's illuminating when it was brought to us a couple months ago, digging deeper into this with Representative Zullo, yourselves, real estate agents. I think there's some concern about potential exploitation and some attempt at regulation, and licensure is probably appropriate in this space. So we're actually going to probably rely on you and the realtors and a couple other folks in this industry to try to determine what the proper protections are for a broader marketplace, generally recognizing, I think what you're recognizing, like there is potential for some bad actors to enter this space and take advantage of folks in distress, and that's what this committee is largely designed to protect against. So,
and the only thing we ask is to have a seat at the table because the worst thing that happen is if it's a licensing from someone who doesn't understand the industry, whether it's a licensed agent, because we sat with the Connecticut realtors and we had to explain what wholesaling was. So we don't want to, something that's going to be licensed when the full understanding is not there.
Yeah, sounds reasonable. Representative Tigliano.
Quick, when you sign a listing agreement or a exclusive buyer agreement with a real estate agent, do they have an opt-out clause in that contract?
So
Any time period, there's asking, this legislation contemplates 10 days for somebody to say, no, I'm changing my mind.
Yep.
If you sign a listing agreement, is there that same opportunity?
I don't play in that space that much, so to be honest with it, maybe you guys can answer that question. Is there?
They'll be here separately.
Yeah, so if there's a right or rescission on a listing agreement, I don't have that answer.
Okay.
Yeah.
Thanks.
Thank you again. Seeing no other questions. Thanks.
Thank you.
Carmen Clarkin and Dr. Emily Knox. My note says together. Is that okay? And I've called you up together. Does I have a note that says together? If that isn't okay.
Thank you. Good afternoon, Senator Maroney, Representative Lamar, Senator Ciccarella, Representative Vertigliano, and esteemed members of the General Law Committee. My name is Carmen Clarkin, and I'm a Research and Policy Associate with Connecticut Voices for Children, a research and advocacy organization working to ensure that one day Connecticut is a thriving state where all children can reach their full potential. With me today is my colleague, Dr. Emily Knox, who's here to help answer questions. Connecticut Voices submits testimony in support of Senate Bill 2, an act concerning artificial intelligence, which seeks to establish a comprehensive framework for ensuring transparency, equity, and accountability in the development, deployment, and use of artificial intelligence. CT Voices believes AI holds immense potential. However, without proper safeguards, it can also deepen existing inequalities.
AI has become more and more integrated into essential domains, and it's increasingly being used in decision-making contexts in critical areas like healthcare, education, finance, housing, and employment. Presently, significant regulatory gaps leave Connecticut residents of all ages exposed to a number of dangers, including but not limited to algorithmic discrimination, data privacy violations, and exploitative digital practices. These risks are more and more enhanced by the processing power of AI, and we are especially concerned for our children and youth who have grown up in a culture where digital interactions are increasingly unavoidable. SB 2 presents a balanced approach that encourages responsible AI development and growth while ensuring strong consumer protections and support for ethical innovation. It also implements accountability measures through transparency in training data, requires bias mitigation, as well as strengthens consumer opt-out rights. Rooted in national and international best practices, SB 2 carefully balances regulation without imposing unreasonable burdens on developers and deployers of artificial intelligence technology. It does not hinder the development and use of open source AI, nor does it impede AI's potential to enhance productivity across various sectors. In fact, we commend the bill's strong efforts to balance regulation with innovation. Specifically, we would like to uplift the implementation of a regulatory sandbox. Enacted in both Utah and Texas in 2024, regulatory sandboxes include mechanisms to incentivize ethical AI development. A regulatory sandbox will foster safe and innovative AI use across various sectors, providing clear guidelines for testing and deployment. With additional provisions that focus on AI education and workforce development, this bill represents a forward-thinking approach aiming to harness AI's potential while mitigating its risks. It promotes transparency, innovation, and education, ensuring AI is developed and deployed for public good. Over 30 states have passed or proposed laws aimed at addressing growing concerns around AI, and more than 140 bills have been introduced to Congress, highlighting the urgency of AI regulation. Now is the time for Connecticut to establish clear standards to guide its use and ensure that AI development aligns with public interests. For these reasons and more, we respectfully urge the committee to support SB 2. Thank you for your time, and we're happy to take any questions.
Thank you for your testimony. Dr. Knox, do you have anything to add at this time, or do you want to just some questions?
I don't have anything to add at this time. Thank you.
Sure. Senator Maroney.
Great. Thank you very much for your testimony, also for your very thorough report on AI. So just a few questions. So one, you'd mentioned the sandbox. I just want to float another idea by you guys in that what if instead of just the sandbox, we were to create like an AI safety institute within the state of Connecticut? So creating tools so the small businesses could comply as well as housing the sandbox within that. So I guess there's two thoughts. One is the AI Safety Institute. The other is it was just at a conference in Florida where they have an Institute for Applied Engineering. That's a nonprofit that's housed within USF that can help solve problems for businesses. You come in, bring issues. The thought of creating an Institute for Applied AI in Connecticut that would have that safety institute housed within there. So again, there are safety institutes like UK safety institutes. There are lots in other countries. We don't necessarily see any AI safety institutes in the US. So just love to get your feedback on that thought.
Yeah, thank you for the question. I think that's certainly something very interesting that the committee could consider.
Thank you. The other, I guess, question I'd ask, what are we missing, right? And especially looking that you guys are Voices for Children on outcomes for children. I think we don't necessarily have any regulations here, although you can argue that maybe some of our children's privacy applies. But to the chatbots and the use of chatbots by children, there's the example in Texas where unfortunately the chatbot ended up convincing a boy to take his own life, and he died by suicide. Are there things we should be looking at in terms of requiring, I guess, the Utah passed a bill where they required any disclosure. So if you're interacting with an AI, a chatbot, you have to disclose. But I don't know if you would have thoughts on those types of issues, right? Because there's Replica, there's others that are creating that you can have an AI friend, right? And then they can sometimes go off the rails. So I'd be interested if you had thoughts on that.
Sure, I'll take this one. Thank you so much for your question. And like you pointed out, this is a children's issue because children today are the first generation to grow up in this AI-driven world. They don't just use AI, they're shaped by it, from algorithmic recommendations to automated decision-making. AI systems don't pause at childhood, and parents can't reasonably be expected to regulate every AI-driven system their child interacts with. And I think you asked if this bill was missing anything, and I want to point to the real strength of this bill in that it is so comprehensive. So my answer to that is no, in that the strength of this bill is in how well researched it is, how detailed it is, and the totality of this piece of legislation.
Thank
very
you.
much.
Well, I used to be a runner. Obviously, I'm not anymore. You can look at me. But every race I finished, I thought I should have run faster. So I think we're always looking to make this piece of legislation better. So thank you for saying that. Last question, I guess I'll ask you in regards to one thing I think we are missing, we had contemplated before, was the K-12 education, right? We do look at creating the Teen AI Academy. I think, it had worked previously on computer coding education, requiring every school to offer that, not necessarily every student to take it. But I'm wondering, and this is probably a follow-up question, not to answer now, but what do we need to look at in K-12 to make sure that we're giving the students, but it's not even, I think we have to start with the teacher. So one of the ideas was just in professional development and, offering or having the state fund professional development in AI for teachers. But I don't know if you could get back, again, it's probably get back to me with recommendations for what we should be doing with the K-12 education.
Oh, certainly. We have thoughts on that and would be very happy to work with you moving forward to strengthen that conversation.
Great. Thank you very much.
Yeah, thank you all.
Seeing no other questions, thank you again for your time this afternoon with us.
Thank you so much, and thank you for your leadership in this space.
Thank you.
David Zbori, followed by Carl Lands.
Good afternoon. Chairs Senator Maroney, Representative Lamar, Ranking Members Senator Ciccarella, and Representative Rutigliano, as well as members of the committee. Thank you for the opportunity to speak today on this AI regulation bill. My name is David Zabore, and I represent VRSim Incorporated. We're a small virtual reality development company in East Hartford, specializing in training systems for skilled trades, allied health, and public safety. AI is transforming industries at an unprecedented pace, and Connecticut has the opportunity to be a leader in advanced technologies. To do so, AI regulation must foster innovation while providing clear and fair guidelines for all businesses, both large and small. Though large corporations with immense resources have traditionally dominated AI development, small businesses and startups now play a crucial role, bringing fresh ideas and competition that drive better outcomes for both businesses and consumers. Without regulations that consider the small business impact, we risk an uneven playing field where only tech giants can afford to navigate the legal and compliance landscape, forcing smaller companies out or leaving them in uncertainty, fearful of future regulatory action. We need to make sure the smaller but no less innovative businesses are not shut out. Clear regulations provide predictability, allowing startups and small businesses to innovate without the looming threat of legal and financial uncertainty. And without this clarity, Connecticut's small businesses risk falling behind in this rapidly growing field. We must act now to ensure AI innovation is not ceded entirely to a handful of tech giants, simply because we failed to create a regulatory environment where smaller players could thrive. This is avoidable right now with this bill. To avoid this, Connecticut must adopt AI regulations that, 1, establish clear and accessible compliance standards so that businesses of all sizes understand what is expected of them. 2, ensure fair AI oversight and enforcement so large corporations are not given undue advantages in regulatory interpretation or influence. 3, encourage responsible AI innovation and application of the technology through financial incentives and support programs that help small businesses compete in this space. And finally, 4, prevent monopolization by designing regulations that avoid consolidating AI development in the hands of the biggest tech firms. Connecticut has the opportunity to be a leader in AI policy, one that fosters competition, innovation, and responsible development. However, without well-defined and equitable regulations, we risk handing over the future of AI to only the biggest corporations, leaving small businesses behind. I urge the committee to craft legislation that ensures AI development remains open, fair, and competitive for all. Thank you for your time and consideration.
Thank you for your testimony, both written and in person. It's really helpful for me, specifically, to be able to go back and reference any of the things that you testified to as I broaden my understanding of AI in the space that I'm now occupying here. Written testimony has been invaluable to helping me go back and have greater understanding of where we're going and how we're going to get there. So I appreciate that. Senator Maroney.
Great. Dave, thank you very much for coming here today. I just wanted to, it wasn't in your testimony, but in Matthew Wallace's testimony, he mentioned that, you know, he felt that for you to comply with this bill, the cost to your business would be de minimis because you're doing many of these things anyways. Could you just elaborate on that, on your development process? And then well, I'll have more questions. I'll go one at a time.
Sure. Yeah, I would say that the cost of compliance is very, very minimal in comparison to what a project normally is. We already do compliance for everything else for data privacy nowadays. This is essentially an extension of that, if you will. So
Okay.
I don't think that this would actually impact economically small businesses in any way. And for us, I think it would be relatively straightforward to do.
Great, thank you. Now, I believe one of the products you are launching some kind of a virtual chatbot, right? Could you tell us about that and then what testing that you guys do to ensure that it doesn't go off the rails?
Oh, sure. Yeah. So we're working on a chatbot right now for the healthcare industry. We're looking at dementia care as well as a number of other types of things we're prototyping. And that chatbot is really to help people both communicate and better understand how to role play in different scenarios, as well as a way of asking questions that you can't normally ask someone in real life or don't have direct access to, something that the web can give you a textual definition, but you can't really interact in a great way. For the testing that we do currently, we're trying a number of different variations of talking with these chatbots and seeing how they react. We do find from time to time that they go a little bit off the rails here and there. That's something that we're learning and trying to work with at this point. But oftentimes with the biographies that we have for the assistants, it does rein them in to some extent. But yes, I agree. More testing and more limitations will be helpful overall in order to help these assistants really both be helpful and not go off the rails.
So are you doing adversarial testing with, I guess, trying to break it and then fixing it based on that? Is that part of your process?
So part of our process is, it's both trying to go the normal route, which is do it correctly, if you will, and then do the opposite, which is try to break it and be adversarial to what, or counter to what you're trying to do. We do that. We also are putting in places some pieces of the AI where we're essentially saying, don't do this in these sort of situations in order to combat that. We're not going to be able to do that 100%, and that is sort of the overall aspect of AI right now is you can't rein it fully in. But yes, that is correct. So we're basically kind of limiting or funneling as we're getting more and more experience using it. Yeah.
Great. And then you also mentioned the medical simulations, right? You do the CPR training, I guess, for paramedics and other products. So I just get your thought on another idea. So again, the conference I was at in South Florida, they also had a Center for Advanced Medical Simulation where they were doing training for the med students using VR, similar to your system, haptics gloves and other things. So to train the surgeons without having to actually put the needles or put a main line in a patient, doing it virtually. Would you see an opportunity? I mean, given the number of med schools we have in here, our need for more nurses, right, in training, would you see an opportunity for somewhat a similar center in Connecticut?
Yes, yeah, I would definitely see that. I think that would be beneficial. We're having a tough time in a lot of these different industries, including nursing, and emergency medical care where we don't actually have enough people trained, and that is a growing need. So I do think that would actually be very beneficial. And yes, you're correct. We do things both for certified nursing assistants as well as emergency medical first responders, and trying to help train them as well and make the tools for that.
Great. Thank you very much. Thanks for coming to testify today.
Thank you, everyone.
Thank you for your testimony. We have Carl Lands, followed by Joanne Breen, or together, it looks like.
Thank you, esteemed members of the General Law Committee. If it's okay, in the interest of time, we'll both say our statements and then you can ask both of us questions. Excellent. Connecticut Realtors appreciates the opportunity to submit testimony relating to HB 5572, an act concerning real estate wholesalers and real estate wholesale contracts. CTR supports this legislation with changes. CTR represents nearly 19,000 members involved in all aspects of real estate in Connecticut, including some wholesalers, as we found out today as well. Our members work with many thousands of buyers, sellers, and landlords and tenants annually. We've drafted more expanded legislation that has been submitted and incorporated certain language from HB 5572 into the draft as well, which we applaud and appreciate. CTR also requests strong penalties be placed upon individuals who violate this proposal, including in Section 3, making failure to disclose intentions to wholesale the property to be a Class A misdemeanor. Joanne?
Hello, thank you to the committee for having us here today. As Carl said, we are in support of HB 5572 with changes. This is a bill that calls for the licensing and regulation of real estate wholesalers and their contracts. The wholesaler typically in these transactions finds a buyer for the property and ultimately retains the difference between what that buyer pays for the property and what the wholesaler agreed to pay the original property owner. These are often not nominal amounts of money, but can be in the $50,000 to $100,000 price range or more, which is a significant amount of equity a seller may be giving up, and very often without ever learning what the real market value of their home is. Often the seller is offered a small amount of money up front in the way of about $1,000 to agree to have their property wholesaled. These sellers may be elderly, they may be in financial distress, and unaware of the substantial equity that may be left on the table. The practice of wholesaling currently has no consumer safeguards in Connecticut. These sellers are interacting with individuals who may be unlicensed and unregulated, and whose business practice is to collect a significant amount of that property's equity. CTR appreciates the good intentions of the proponents of the bill, but we are recommending additional changes to ensure that consumers receive important disclosures and to provide enhanced regulations to the practice. CTR has drafted legislation which we submitted with our testimony, and our draft contains definitions of the wholesale buyer, seller, their contract, as well as a definition of the wholesale transaction. Our draft bill would require the following be clearly disclosed. First of all, the wholesaler must share with the seller that they are not purchasing the home themselves, but intend to sell or assign the contract to another buyer. Secondly, the wholesaler intends to make a profit from selling or assigning the contract. And additionally, the seller should be certifying that they understand they are granting the wholesaler the right to make decisions to accept or reject offers to purchase the property without the seller's knowledge or consent within the terms of the wholesale contract. These terms and conditions I just noted are spelled out in Section 2 of our proposal, which creates a new statutorily required disclosure form called Notice to Sellers in a Wholesale Transaction. CTR incorporated certain language from the current draft into our proposal, including clarity that professionals should be consulted to evaluate the market price and legal terms of the agreement and options for termination of the agreement. We applaud the bill's proponents for identifying the needs for those details. CTR would also like to see strong penalties placed upon individuals who violate the law. Section 3 of our draft would make failure to disclose intentions to wholesale the property to be a Class A misdemeanor and grant the seller or the buyer, who is not the wholesaler, the ability to cancel the contract for sale at any time prior to closing without penalty and to have them retain deposit money or be refunded fees they've paid. CTR would be willing to discuss specifics of the bill with the members at your convenience. And just in a final closing note, I work in a highly regulated industry. I've been in real estate for 46 years, and over time it's become more regulated, and we've had to provide more and more disclosures. And very honestly, I welcome that, because that means I'm dealing with informed consumers who are making informed decisions. Thank you. If you have any questions, we'd be happy to answer them.
Thank you for your testimony. I think you've been here to witness sort of the exploration that we've had on this and on this topic. It started with Representative Zullo coming before screening a couple of weeks ago, just on the topic, and us finding it somewhat interesting and somewhat in need of greater understanding and potential regulation. You heard some of the testimony earlier from a couple of folks who look like we're licensed realtors, where we hold ourselves to a specific standard. We're operating in good faith. People are aware of what our business model is and what we're doing. Like they're open to the idea of regulations, but like want to work in concert together to craft appropriate regulations. If, you know, ranking members and chairs of this committee invited you to sit down in a couple of weeks and work through some of this stuff, would you be open to that conversation?
Absolutely would, yes.
Okay.
We'd welcome that.
Because I think I agree with you that there needs to be some regulatory framework in place here. I'm not sure I would go as far as you wish to go at this point in time, but I do think the conversation is an important one. I do think there needs to be some protections in place, particularly for a lot of potentially distressed constituents who might find themselves in a bad spot, like not quite understanding the product that they're signing up for, or the nature of the relationship, how it differs from traditional real estate agent relationship. What your obligations are to a home seller versus what their obligations are.
Exactly.
So I think there's a lot of concern there, but I may not be willing to go as far as you guys want to go. So I think it's an important conversation to have.
We're gonna, you know, I don't want to prolong today. It was an interesting conversation. I think your perspective is well represented. I think we came in, I'll speak for myself. I came in with a preconceived notion, and I've been enlightened a little bit, and I ended up with a few more questions. So we were talking over here what the penalty was for a Class A misdemeanor. Do you know?
Is it $1,000? I
So
believe.
no threat of incarceration over a
No.
contract
it would be
violation? Okay, that would be good, because I think that might be a bit much. Yeah.
Right.
Okay. All right.
We won't send them to Exile Island.
No.
Just pay the $1,000.
Well, thank you for your testimony. We will definitely be in touch.
Thank you.
Thanks again. Bradford Murray, followed by Grace Getty.
Hi, are you able to hear me?
We are.
Excellent. So hi, my name is Brad Murray, and I'm the Deputy Director for AFT's Research and Strategic Initiatives Department. I'm here to testify on SB2. I appreciate the opportunity to testify on behalf of the 1.8 million members of the AFT and the more than 30,000 members of AFT Connecticut. I know a great deal of thought and work has been put into this legislation by Senator Maroney and others, and we really appreciate the work that has gone in, soliciting multiple viewpoints on this important topic. In the absence of proactive federal legislation to protect citizens from the potential harms of automated decision-making, it is an important topic for state legislatures to take on. We appreciate in particular the precise language used in this bill and the thought and care that has gone into crafting this legislation. As a union representing educators, we are also pleased to see that this bill addresses deepfake pornography, which is an issue plaguing classrooms across this country. While we would love to support SB2 in its entirety, we would like to suggest a handful of small changes to this bill. We're troubled by the exemption for human-in-the-loop decision-making and the definition of substantial factor. I understand the need to balance the burden of this legislation so that it's not applied in situations where it would be unwarranted. But that said, exempting from this bill decisions made by recommendation of an AI will foreseeably cause real harm to Connecticut residents. Companies selling AI systems will simply require human review in their terms of service and exempt themselves from all the work that has gone into protecting them in this bill. Earlier, there was, with Commissioner O'Keefe, there was some discussion about the Fair Credit Reporting Act. And I think an analogy there is actually very apt. Data brokers get away from all of the restrictions around consumer investigative reports that were put into the Fair Credit Reporting Act by specifying in their terms of service that their products can't be used for purposes covered under the Fair Credit Reporting Act. Additionally, I think we would like to see some tweaking around the regulatory sandbox as well. The 3-year time frame for participation is probably a bit too long. We'd love to see state agencies be able to recommend the revocation of the active participation in the sandbox for issues other than the ones specified in the bill currently, when the AI poses an undue risk to public health, safety, or welfare, or violates federal law. I think, if you're playing in the sandbox and you're not playing nice, it should be easy to kick you out. And agencies shouldn't be handcuffed just by those 2 provisions to recommend termination to the Department of Economic and Community Development. AFT and AFT Connecticut would also like to second the proposals made by the Connecticut AFL-CIO to increase worker voice in AI governance. We're strongly in favor of all of the recommendations made in the written testimony by Connecticut AFL-CIO. And finally, we want to support amending this bill to allow for a private right of action against developers whose artificial intelligence programs violate the rights of Connecticut residents when making consequential decisions. I think a private right of action would really help advance the enforceability of this law and advance the public interest aims of the bill. I'd like to again thank the legislature for the leadership that they've shown in crafting this bill and the leadership that they've shown on this issue in Connecticut and nationwide. And thank you for the opportunity to testify on it today.
Brad, thank you very much for your testimony. Okay, I do have some questions. I think agreed, the sandbox needs more thought. What would your thoughts be on an AI safety institute that within that safety institute house the sandbox, and who is the appropriate agency, do you think? Is DECD the appropriate agency for the regulatory sandbox?
I'm not sure that I'm well equipped to answer that. I don't know, I like the idea of a safety institute. You mentioned before that, these exist in other countries. I think it's a good idea. I'm not sure on which agency in Connecticut, would be best to house this. Sorry.
No, don't be sorry. That's thank you for being honest about that, and sorry for putting you on the spot. So back to in the definition of a substantial factor where we tried to narrow it. Some of the other states have gone to like a principal basis, which I am hesitant to go there because they say it's I think it was in Virginia, and then it's in other proposed states, but it was in the bill that passed in Virginia. But the principal basis is a factor that's weighed more heavily than other factors. I guess I'm not in favor of that language because my concern is how do you know what's weighed more heavily? And I think someone had mentioned on the screening the resumes, by eliminating them, maybe it wasn't the final decision, but if they're not getting reviewed in the next level, I think you've impacted their opportunities. But I don't know if you have thoughts on the substantial factor language, and if we didn't go back to our previous version, which was passed in Colorado, if instead we lowered the bar on disclosures, requiring the disclosures maybe at a contributing, if the AI is a contributing factor, it would be disclosed to you and on the whether it was an adverse determination or that it was being used as a contributing factor, but then some of the other like the risk management framework and some of the other obligations would only be triggered by a higher level. And again, I'm throwing this at you now, so feel free to say we'll get back to this later. and give it some thought, but again, trying to figure out where's some middle ground.
Yeah, I think I appreciate all of the thorough thought and consideration you've given to this issue, both this year and last year. I think we got to a good place last year with substantial factor in the final version of the bill in Connecticut, and I agree that we do not like the Virginia or the as introduced in Maryland language for substantial factor. I think you've put a lot of work into crafting a really incredible piece of legislation. And if the substantial factor piece isn't, right, it's really all for naught, right? So I'm not sure on the exact language, but my recollection is where we got to in 2024. That was pretty good.
Okay. Yeah, no, I agree. I think that is probably the most, that and the consequential decision. Those are the two most important definitions that we have to get right. And I don't want to see what had happened with our data privacy, where we narrowed the right to opt out to just solely automated decisions, which means all you have to do is someone needs to push a button somewhere and you're exempt from that right. So agree that the definitions matter on that. So I'll see if anyone else has questions. Hearing none, thank you very much, Brad.
Thank you.
For coming to testify. Okay, next, Grace Getty from Consumer Reports. And are Grace and Matt testifying together, or?
Senator, I believe we're testifying sequentially.
Sequentially? Okay, great. All right, Grace, please go ahead.
Thank you so much, Senator. Good afternoon, chairs, co-chairs, vice chairs, ranking members, and members. I'm Grace Getty, a policy analyst at Consumer Reports, where I focus on artificial intelligence policy. CR is a nonpartisan nonprofit with 6 million members across the country, and today I'm here to discuss SB2. We appreciate Senator Maroney's leadership on this critical, urgent issue of the use of AI in high-stakes decisions about Connecticut residents' lives. Despite companies' best efforts to keep under lock and key information about how predictive AI systems work, or for that matter, don't work, a steady stream of research and testimony from experts suggests that these products can bake in bias, be error-prone, or simply be snake oil. The bill has several important provisions, including the right to a pre-use notice, the right to a post-decision explanation, the right to correct personal data used in a decision, and the right to appeal. It also has some provisions that must be strengthened and loopholes and liability shields that we worry will allow companies to escape responsibility. These issues are enumerated in my written testimony, and I look forward to working with Senator Maroney to ensure they are addressed. I'd also point to the testimony submitted by AFL-CIO of Connecticut, because it's critical that this bill work well for the workers of Connecticut. But I'd actually like to spend my remaining time addressing some of the arguments presented by tech lobbyists and other entities opposed to this bill in their comments and their written testimony. First, this bill has the potential to be a necessary patch to existing consumer protection laws and civil rights laws in the AI era, so long as loopholes are closed. These existing laws do apply to AI systems, but cases are incredibly difficult to bring in practice with AI products due to their black box nature and their ability to partially stand in for humans with intent. I believe Senator Maroney has very skillfully made this point this morning. Second, it is not too soon to put common sense safeguards in place on high-risk AI products. In fact, we've surveyed consumers nationally about AI decision-making products and their use in the kinds of scenarios that SB2 covers. Across income levels, across ages, across party affiliation, overwhelming majorities want the right to correct, and they want the right to explanation. Third, some industry advocates have pointed to Virginia's HB 2094 or its specific definitions as worth emulating. That bill and its definitions has some serious shortcomings that we suspect will lead to non-compliance. It was opposed by consumer protection and civil liberty groups, the very groups you'd expect to back a bill promising to address bias in consumer protection, which should give legislators pause. What you don't hear tech lobbyists talking about are the many bills pending in other states that are considerably stronger than Virginia's bill. I appreciate Senator Maroney's leadership on this critical issue, and I thank the committee for its time.
Grace, thank you very much. Are there any questions for Grace? Grace, I'd like to say you pointed out something to me that sometimes laws are necessary to patch, right? And that's, it's interesting, I think, that some people will agree we need to go in and update some definitions in laws. And so, for instance, we have broad agreement on the deep fake revenge porn, but it's not illegal until we go in and update that. And so I think there are other areas that are necessary to patch, as you point out. So thank you for testifying, and I'm sure we'll be in touch, but I look forward to working with you going forward.
Thank you so much, Senator. I look forward to being in touch.
Thank you. Next, Matt Schwartz from Consumer Reports.
Co-chairs and members of the committee, thank you for allowing me to testify today, and thank you for your continued work to advance consumer privacy in Connecticut. I'm testifying in support of SB 1356, which will make several common sense changes to raise the standard of consumer privacy protection in the state. For the record, my name is Matt Schwartz. I'm a policy analyst at Consumer Reports based in Washington, D.C. You heard about what CR is from Grace, but I should mention that CR was involved in the original passage of the Connecticut Data Privacy Act. And we've worked tirelessly to ensure that the subsequent efforts based on Connecticut's law meet their core goal of protecting consumers from data-driven harms. As my colleague Katrina Fitzgerald mentioned, Consumer Reports and Epic recently released a state model privacy bill that uses Connecticut's law as the baseline. It was partially inspired by the Connecticut AG's report to this committee in February of last year, which outlined several recommendations they saw as necessary to strengthen or clarify privacy protections under CTDPA. Through our tracking of the development of state privacy laws around the country, we've also observed several areas where we think that the Connecticut law could be strengthened to match that of other recently passed legislation, and to close certain loopholes that are resulting in gaps in consumer protection. That's why we're so glad to see the introduction of SB 1356, which addresses many of the issues identified by the AG and groups like ours. First and foremost, the bill would amend the bill's data minimization standard to ensure that businesses can only collect personal data that's reasonably necessary to provide the service requested by consumers. Companies often abuse the current framework to collect extraneous information about consumers that's ultimately used against their interests. And this results in issues like unfair price setting, scams, and data breaches. For example, recently Allstate was caught secretly collecting consumers' driving behavioral data and using it in some cases to raise consumers' insurance premiums. The proposed standard here would help prevent those types of unexpected collection activities, and it would match the framework currently in place under Maryland's privacy law. The proposal would also scale back certain entity-level exemptions that potentially provide loopholes for big tech companies to evade compliance, and they improve key definitions of terms like biometric data and sensitive data. While we'd love to see the measure go further to ban the sale of sensitive data outright, as was done in Maryland, and as is currently being contemplated by several other states, including Washington, Massachusetts, and Vermont, we still think these improvements are worthwhile. So I'll wrap it up there. Again, we're very supportive of this bill. I'd just like to thank the committee again for giving me the opportunity to testify, and happy to answer any questions.
Okay, Matt. Thank you very much for testifying, and also thank you for pointing out the AG's report. We'd be remiss if we didn't thank Michelle Lucan and John Newman and the AG's Data Privacy Unit for all of their work in that very thorough report, which a lot of these changes were requested by the AG's office based on their enforcement, where they saw that unfortunately a lot of consumer complaints fell under some of these exemptions that we had given, and so we needed to tighten up those. I do have a question for you, and again, feel free to say you'll get back to me. One of the things we're looking to update is the knowledge standard, right? And that especially when it comes to whether someone is a child, and that's something we've seen, you know, in the data privacy law, or more of the social media laws that have been challenged in the court, and the age verification is typically found to infringe on others' right to free speech, right? And based on, I think, Reno versus ACLU, but we're looking to update our knowledge standard instead of actual knowledge or willfully disregards. We have the know or should have known, but I guess I don't know if that's too vague. I'm considering using this standard. I think that the COSA that had passed the Senate but didn't make it to the House, the federal bill, where they have the knowledge fairly implied. And I'm just wondering if your thought on going to an actual knowledge or knowledge fairly implied on the knowledge standard.
So that's a little bit out of my wheelhouse. I know there's some speakers coming up who might have some thoughts on that. Eric Null, I think, was going to cover that in his testimony.
Okay, great.
In our model bill, we have knew or should have known.
Okay.
Just for your awareness.
Great, thank you. Now, a lot of the complaints fell under what was in the publicly available information exemption. So I didn't know if you had thoughts on the language around the publicly available information.
Again, a little bit out of our wheelhouse. Consumer Reports are mainly focusing on kind of commercial uses of data. So those public uses of data aren't normally what we spend a lot of time thinking about. I can take a look at those provisions and provide some thoughts and follow-up feedback to you, though, if you'd like.
That would be great. Okay. Are there any other questions? Okay. Thank you very much.
Thanks.
All right. Next, Joseph Fiorella.
First time doing this, guys. Thanks for having me. My name's Joe Fiorella. I'm here to talk about the wholesale bill and the wholesaling real estate bill. I'm Italian, so I talk with my hands, so I might slap the mic or something. I don't know. Look, I understand there's a lot of misunderstanding of how like the business actually works, and I think that's an essential part of this bill to make something that makes sense for the realtors and wholesalers and for homeowners as well. To give you a glimpse inside of my business, we are a big referral-based company. So we get a lot of referrals from attorneys. We get a lot of referrals from realtors. I have a TV commercial, I have billboards, and we get people who call me and they don't want to go through the typical process of listing with the realtor and they want to sell their house fast for cash. 25% of people that call us, they already have the house on the market with the realtor and it's not selling. For whatever reason, it's not selling. The realtor promised them it would sell. It's not. 25% of people that call us, I tell them to go list it for a realtor because it's not a fit for our business. The others we talk to and we try and find a solution that makes sense and makes sense for us and it makes sense for them. I keep hearing people talk about like Zulo and some of the other people that spoke today that they don't want to destroy this industry. They just want to regulate it. And I believe that there is some regulation that needs to go into effect. But this bill would not be good for this industry. It's not fair. It's not right for homeowners. People need to have options outside of just listing their house with a realtor. And it's the bottom line. So, you know, I don't know if you guys have any questions for me, but I just have some notes here. One of the points exactly that I want to talk about is the 10-day cancellation period. So with our business, we put a house under contract, and then oftentimes these people don't have money to move or to relocate or to do the things that they need to do. So after we sign the contract, it's quite often for us at least is we write the homeowner a check directly. They take that check, $5,000, $10,000, $15,000, whatever it is, and they go and pay the deposit and 2 months rent for their new spot, or they hire a moving company, or they go and do something. If they have a 10-day cancellation period, we can't offer this to them anymore. So we're going to put homeowners in a tough spot because of this policy, because if I give them a check for 10 grand and he could back out in 10 days, it's going to put limitations on everyone in the industry. And it's actually going to hurt homeowners more than it hurts anybody else. The average assignment fee is $12,000. Okay. Everyone knows what house they're selling in for Connecticut. Realtor commission is 5 to 6%. It's pretty notable difference between assignment fee and a realtor commission. Something else, and I'm personally not a fan of the word wholesaling, but it's a assignment of a contract. That's what wholesaling is. And it's done in finance, it's done with banks, it's done with mortgages, it's done with everything. So when a contract is assigned, the seller gets the same exact deal as they signed up for. Nothing changes. It's literally an assignment of rights. So the seller gets the same amount of money, they get the same amount of terms, they get the same closing date, they get the same everything that they were promised up front. All that's different is the name on the closing documents. Instead of going to Joe, it's going to Rick or, you know, whoever it is, the other party. So nothing actually changes for the homeowner. So, I mean, I don't know if you guys have any questions. I'd be happy to talk. I'm not against legislation and regulation. We just need to do it in a way where it's not biased towards realtors strictly, and it's beneficial for everyone, including the homeowner. And that's what I would like to say.
Great, thank you. Senator Ciccarello, do you have a question?
Thank you. And thank you for coming to testify.
Sure.
You neighbor Joe?
That's me.
That's it. All right. I think I saw your commercials. All right. So a couple of questions.
Sure.
You stated when engaging with a client, you may determine the deal's not for you and you may advise them to go to a realtor. Can
Right.
you give a situation what that looks like?
Beautiful house, perfect condition. They want to sell. They don't care if it sells in a year, 2 years, 3 years. They want top dollar. They don't have, and it could sit on the market for 12 months and they don't care. And it's a beautiful house, doesn't need any repairs. They'll make the repairs themselves if it's needed. That's someone who I would recommend to a realtor.
Got it.
Yeah.
Thank you for that example. And you talked about the 10-day cancellation and why that would hinder a benefit to someone in a situation where they need some quick money, relocate, get out of a bad situation. Now, is that their compensation or would they also be getting a piece of the sale? How is the deal normally structured? And I know that might be a loaded question because there's probably hundreds of different examples of houses you may purchase, but if you could give me an example.
Yeah, so I'll give you a great example. We put a house under contract in Shelton. We gave the seller upfront $5,000, and that goes towards the sales price. The sales price was $375,000, and the seller in that deal, all he has to do is pay off his mortgage. He owes like $100,000, so he's gonna walk away with hundreds of thousands of dollars at the closing, and then we give him that money up front just to, so he can start his next chapter.
Got it. And when you talk about your fee, so you would only make 12% on the profit or the total number, the 375 in that example in Shelton?
Well, no. So the industry average wholesale assignment fee is $12,000. Not, it's $12,000. So on that particular deal, I'm actually buying it cash myself. But the point is that I could assign that deal today to another buyer. The seller's gonna get the same exact amount of money. He's gonna get the same money up front, same thing. That's like what I think is a misunderstanding here. Is like people, the understanding that I've gotten is that these people are getting, it's not clearly communicated what they're getting. It's not fair. They're getting, if the deal's either assigned or it's closed in my name, the seller is getting the same exact agreement they signed up for up front. But yeah, the industry average wholesale fee is $12,000.
Got it.
Right.
So I think part of the concern, it sounds like, you run a professional operation, you do marketing, you're doing things above board.
Yeah.
The concern is the individuals that aren't doing it, they don't have the finances themselves, or they don't have hard money backers that could write the individual in Shelton a check right there. You make the deal, buy the house cash, and you're out. What they do is they'll lock somebody into an agreement
Right.
and then try to make that deal. And if they made a bad deal or they can't do what they said they were going to do, it hinders that person now from making a move.
Right.
And then they could be accumulating whatever it is, more interest on their mortgage, and they could be locked in a bad situation.
Sure.
I think I stated before, like I'm a part of a professional organization, and one of the things we try to do is regulate our own so we don't have a bad name. So I guess the question after that comment is, why would you not want to stop those guys from kind of, I don't want to say doing the wrong thing, maybe just trying to be an entrepreneur, but they just don't have the means to do it. And again, promising a deal a little sweeter so neighbor Joe doesn't come in and buy it quickly.
Yeah.
What would be the opposition of trying to stop those individuals from doing bad business?
Yeah, I'm not opposed. I think homeowners do need to be protected. I think that going about it this way isn't the way to do it. I think we need to sit down and have a conversation. And I think that's all we're asking for is just a seat at the table. There are some ideas that I have that we could do, and I would like to talk about them privately. But you know, I'm not opposed. It's just like any other profession, doctors, attorneys, anything. There's some guys that aren't above grade. It's just nature of life. It's a fact. So that's I think we could do some stuff. I just think that these specifics in this bill are detrimental not only to us as small business owners, but like to the homeowner as well. Like I just it's gonna have long-term implications that are negatively gonna affect every homeowner that is in a distressed situation because there's more people than you think that, let's say their house is hoarded. I've seen some really terrible situations where maybe there's dog feces, human feces. We've seen stuff where it's just they're so embarrassed. They don't want to put their pictures on the house on the MLS for thousands of people to see. Have an open house, have 70 agents come through, have 70, they don't, it's stressful. So like to take away that option is just not, and that's really what this bill is doing. It's taking away that option and it's making them go the realtor route. And that's, you know, that's how I feel about it.
Got it. And I appreciate, again, you answering those questions. And, you know, there is a willingness up here to have a conversation and leadership could reach out.
Right.
And we'll try to get this to a point where we could address all of the concerns. But again, as some of these examples I said, with people being held up with a contract, or some bad actors, you know, somebody's behind just on, you know, the house is paid off.
Sure.
It is in distress. And they're falling behind, whether it's blight and their taxes,
Right.
but they have a house, you know, the land alone's worth 250 grand. You come in and say, hey, I'm going to give you 100 grand. And someone goes and sells that for $350,000. We also, you know, want to make sure people aren't getting taken advantage of at the same time. So there is concerns. It sounds
Right.
like you realize that, you know, there should be protections for the homeowners and we look forward to trying to find that balance.
Yeah. And I just want to reiterate, there's, like I said, 25% of the phone calls we get from the TV commercial, there are people in those situations that did list the house with the agent, and that agent is actually holding them hostage, won't let them out of the exclusive listing agreement. So like, it's not just industry specific to like real estate wholesalers. There's going to be distressed people out there no matter what. To have a wider variety of options for them to get out of their situation and start their next chapter, I think it's important. And, you know, I'd love to talk to you guys and work out, you know, a win-win situation for everybody.
Absolutely. And I think we're willing to do that. I appreciate you taking the time to testify.
Thank you.
Thank you, Mr. Chair.
Thank you very much. Yeah, we would appreciate if you would share. I know you'd referenced, you have some ideas. We'd love to hear your ideas.
Sure.
I believe Rep. Aniskovic has a question.
Thank you, Mr. Chair. Thank you for your testimony. And I think it's just enlightening to hear all of this. I mentioned before, I've been in the mortgage industry for 30 years. And when we first got in this industry, had a bad rap. The rap was we were all used car salesmen and, you know, this is everybody where everybody went. And then the Frank Dodd bill comes out and then we regulated. We were regulated and we got rid of the bad actors. We got rid of the people that wanted to make it a job, not a career.
Right.
And so I think that's one of the things that we're talking about is making sure that we can get you to that spot. Because I think some of the things that are just confusing, at least for me personally, on that side is you previously said that you pay cash for houses.
Sure.
Okay, so you technically pay cash for a house that doesn't get recorded. A mortgage doesn't get recorded. So there's no details of that transaction.
Well, there's a deed that states like the buyer, the sales price, like there's still a deed that is recorded that states the details on the transactions on the land records.
Okay, so then therefore then that puts you, I think, into a different kind of world where now you have a recorded transaction that's in place. So then you're going out and you're assigning, well, I mean, if you're recording a deed, then there's something on land records that shows that you paid X amount of dollars for that house.
Well, no matter if you assign the deal or you don't assign the deal, there's still a deed recorded that has the buyer's name with the purchase price, the property address, the Schedule A. So there, no matter if the deal's assigned or to, you know, just I buy A to B, it's still recorded it's still recorded the same. And there's a attorney that represents not only the seller, but the buyer side. So there's attorneys that manage both sides of the transaction.
Right. And then which is, I mean, obviously, I think that benefits everybody in the transaction so
Sure.
they'll know what's going on. And so, I mean, ultimately, at the end of all these conversations, and it should be a seat at the table. Everybody should have a seat at the table because everybody's involved in how this process works.
Right.
And some people may not know how your process works.
Right.
So I think it's important to get everybody at the table to sit down so that if legislation and regulations come about, they come about with all people that are involved in the transaction.
Right.
And I think just, you know, why I think this has been brought forth is because you're right. There are bad actors. There are people that are doing things out there that they are unscrupulous and taking advantage of sellers of properties. And I think the regulations would benefit you on how you handle things and what you do, and it will get rid of the people that don't belong in this industry. So
Sure.
I think it's a good conversation, and I think it's important to have everybody at the table.
Yeah,
So thank you for your
I agree.
testimony.
Thank you.
Great. Hearing no further questions, thank you very much for coming to testify before us today.
Thank you.
Next, Eric Knoll online. Oh, Eric's not there. Okay.
I'm here.
Oh, there he is. Okay. That's all right. All right, Eric, please proceed. Floor is yours.
Thank you. Thank you very much, Chairs Lamar and Maroney, and esteemed members of the General Law Committee, for the opportunity to speak to you today in support of SB 1356. My name is Eric Null. I am the co-director of the Privacy and Data Program at the Center for Democracy and Technology, which is a 30-year-old civil society organization based in Washington, D.C., focused on advancing civil rights and civil liberties in the digital age. And we've been active on privacy issues essentially since our founding. We greatly appreciate the effort that this committee, and particularly Senator Maroney, has put into updating the Connecticut Data Privacy Act, which I'll call the Act, with SB 1356. Since 2022, when the Act initially passed, much progress has been made around questions of how we can best protect consumers in the face of daunting and confusing online data practices. We support several aspects of SB 1356 as improvements over the initial act. The bill is a step in the right direction, and I hope that this committee continues on that trajectory. I'll make 3 quick points today, including, as Matt mentioned, the knowledge standard, and encourage you to look at my written testimony for more explanation. First, we support SB 1356 broadening the scope of the Act. The bill reduces the size threshold of companies that are subject to the Act and broadens the definition of sensitive data. Both of these are common sense updates to the Act. Privacy harms such as physical harm, economic harm, reputational harm, and others can come from misuse and abuse of data by any company, not just from larger companies. And these privacy harms are also more likely to occur from the breach or misuse of sensitive data, but the definition of sensitive data is obviously key. With the new definition, information like neural data, financial data, disability status, and status as non-binary or transgender all would explicitly gain protection. And there could be more types too, if you wanted to add more. Second, we support the included stronger data minimization requirements. The Act, as it stands now, relies primarily on consent, which we feel inappropriately places the privacy protecting burden on consumers who lack the time and understanding to fully protect themselves. It's the companies that decide what data they collect and why, and that ultimately benefit most from that processing. And so the burden to limit processing should be on those companies in the first instance. So the addition of the reasonably necessary requirement for collecting non-sensitive data and the strictly necessary requirement for collecting geolocation of minors are welcome additions to the Act. In future amendments, we hope that these minimization requirements are expanded, similar to the EPIC and Consumer Reports model bill referenced earlier by my colleagues Katrina and Matt. And last, as previewed before, we have historically been concerned with language around knowing the age of internet users because of the potential for that language to incentivize or even force companies to institute privacy-invasive age assurance and age verification techniques. The definition of know in the bill, which includes knowledge fairly implied under objective circumstances, is less problematic from that perspective. But the substantive provisions in the bill use a different standard. They say know or has reason to know or should know. Both of those standards are likely to reduce privacy and anonymity online. And we hope that the bill, we would urge that the bill rely on the new definition of know and remove those other standards. We're encouraged to see Connecticut making improvements to the Act, and we hope to continue working on these issues to provide the best privacy protections possible. Thank you again. I'm happy to answer any questions.
Eric, thank you very much. And excellent point. I need to do some cleanup on making sure we're using a consistent knowledge standard throughout the bill, as well as the fact that we had the children's bill, some of which was incorporated within our data privacy, some was kind of standalone. So we'll be spending time, and that was in 1295. This year, we're updating our children's privacy. So in the next week, I will be going through and making sure we have a consistent knowledge standard across bills. And understood, right, on not requiring collecting too much information for the age verification. What would your thoughts be of going to actual knowledge or knowledge fairly implied as the standard?
So we are open. We're okay with both standards. I think the actual knowledge probably presents the least issues regarding having to affirmatively collect more age-related data, like a driver's license or some other document that proves age. But the fairly implied under objective circumstances, I think, also sets a standard that doesn't necessarily put companies in a position of, either we have to know the user's age or we're going to get dinged by the Connecticut AG on whatever practice that they're trying to implement.
Yeah, and again, we added the willfully disregards initially because the concern is if it's just actual knowledge, we don't want to encourage people to turn a blind eye to the age of their users, right? And so I don't know if I think the knowledge fairly implied will help us get to a better place because I've heard from people, in Meta or, other social media, from people who work at the companies that, they can figure out the age of a user over time by the way they interact with the platform just through and it's not asking them to do anything extra. They're already doing that, right? So again, my concern is with age verification. It's pretty much been found to be unconstitutional, but we know we want to provide social media protection. So how can we do that without hindering the free speech of others? So that's why I'm trying to make sure we get this knowledge standard right. So
Sure.
I'd welcome the opportunity to work with you going forward.
Happy to.
Okay, great. Are there any further questions? Okay.
Thank you.
Hearing none. Thanks for your testimony, Eric. And next is Matthew Scherer, also from the Center for Democracy and Technology.
Chairs Maroney and Lamar, thank you. And in particular, thank you, Senator Maroney, for your hard work and leadership on these issues, both in Connecticut and across the country. I lead the Workers' Rights Project at CDT, and my testimony will focus on the sections of SB 2 dealing with AI-driven decisions. My kids are a big part of the reason why I'm here. You see, both of my kids are autistic. They're brilliant and talented, but they don't talk the way most people do. They often don't make eye contact. They move their bodies in unique ways. When I first noticed these differences, I was a management side employment lawyer advising companies incorporating AI into their decision-making. I started getting worried because many AI tools look for what's typical rather than what's good for a job. There are even video interview systems that evaluated workers on their eye movements, body language, and speech patterns, things that have no connection to job performance, but that could easily screen out anyone with autism. Worse, affected workers generally had no idea that AI was evaluating them like this. And it's not just jobs. AI-driven decisions are happening throughout the economy. Investigative journalists at ProPublica revealed that the healthcare giant Cigna secretly used an algorithm to mass reject claims and then threatened to fire a physician who pushed back. Cigna's patients thought that doctors were reviewing their claims when in reality those doctors were rubber stamps for an algorithm. Whistleblowers risk their careers to bring that story to light, but for each such glimpse that we get, untold numbers of other algorithms stay hidden. And without transparency, consumers and workers cannot protect themselves or vindicate their rights under existing civil rights, labor, and consumer protection laws when they're harmed by biased or error-prone systems. You can't file a complaint regarding an AI system you don't know exists or what role it played in a decision. We thus need strong transparency for algorithmic decisions, both to ensure existing laws function effectively and to address the dystopian situation where our lives are driven by algorithms we don't know about, much less understand. SB 2 contains provisions requiring companies that use algorithms to make consequential decisions give affected consumers basic information about those systems, including, crucially, an explanation when such an AI system makes an adverse decision. Unfortunately, the bill currently contains definitions and loopholes that risk making those protections ineffective, if not a dead letter, unless they're fixed. My written testimony goes into greater detail, but I'll just mention two concerns: the requirement that an AI system actually alter a consequential decision before it's covered, and the exemption for systems if there is human review. These provisions place an impossible burden on consumers and regulators who have no way of knowing whether an AI system is altering decisions or whether meaningful review is actually happening. And because companies would effectively get to decide for themselves whether their use of a system meets these definitions, these provisions effectively allow companies to opt themselves out of the law with no outside visibility or accountability. SB2 has the potential to join Colorado, where I serve on the AI Impact Task Force, in setting an example by empowering its consumers and workers. I urge you to amend the bill to ensure that happens. Thank you, and I'm happy to answer any questions.
Great, Matt. Thank you very much. And thank you for bringing up the example of your children. I think one of the areas where they've seen that AI or, a lot of institutions are investing in using algorithms for determining cheating, for helping to proctor exams. And because they're not, as you mentioned, they're trained for typical, sometimes they'll notice things and they'll flag people for cheating who weren't cheating, right? They may have a disability or something else. So bringing up those concerns that we need the representative data sets and the training is important. So I have a question, about the transparency requirements. I'm just wondering since there are some existing remedies, right, that people have through CHRO to file a complaint or other discrimination complaints, do you think that we should be including that type of information in notices? Maybe if it's maybe not the initial notice that AI is being used in a consequential decision, but if you're getting the adverse determination and explanation, that we should also, or perhaps on the AG's website, make clear the information for other people, for people's other means, I guess, of redress.
Thank you, Senator. That's a great question and a great idea, I think. As I said, I think that one of the biggest issues with these technologies is that even existing laws can't be enforced effectively because consumers and workers don't know about them. And kind of a corollary to that is, frankly, a lot of the time, even if consumers or workers suspect that something is up, they often don't know exactly who to call or what the process is for filing a complaint. So I think that including information in a notice about what regulator or what agency they can contact if they have a concern about a technology that's being used to make decisions about them, I think that that would be very helpful and it would further empower consumers and workers.
Great, thank you. You mentioned existing law, right? And there was, a law last year that was passed in Illinois that I'm not sure if you're familiar with it. Actually, I'm pretty sure you're familiar because you read everything, but just in case you're not, I want to give you the out. The Illinois law that says you can't use AI to discriminate, and then it leaves it to rulemaking on how they would determine that. I was wondering if you can comment on that approach versus there's another proposed bill in Connecticut that would say that AI is not a defense for discrimination, which in my mind would indemnify the developer since you couldn't use AI as a defense.
Yes, sir. I mean, I think that, to use a more humane phrase, there's more than one way to skin a potato. And so one way of attacking this problem is to modify existing laws, such as civil rights laws, which is the approach that Illinois took. And another is to pass standalone legislation. I think Illinois' approach, well, for one, I think that this is a great example of the laboratories of democracy at work. One of the main areas where AI is most impactful is in areas that are covered by civil rights laws, particularly those relating to employment. And so modifying those laws to require essentially, some level of accountability for companies that use AI in those contexts, that's one approach. My main concern about what exactly the Illinois law did is that it didn't kind of clearly create this is what has to be included in notices. And we know from what's happening at the federal level right now that you can't necessarily rely on from administration to administration having the same interpretation of a law or the same rules interpreting it. And when it comes to notice requirements, that's what kind of gives me a little bit of pause about the Illinois approach. I think that doing it that way, writing it into the civil rights laws is one way that you can provide those notice rights, but they kind of left it open to rulemaking for what exactly those notices would contain, which makes me a little bit nervous. And the other thing is obviously not everything where AI is being used in these key decisions are necessarily covered by the civil rights laws that were amended like that. As I understand it, for example, the use of AI in healthcare decisions probably wasn't covered. So, that's one reason that I like your approach, Senator, of kind of a comprehensive system that provides transparency when AI is used in any type of consequential decision affecting a consumer or worker.
Thank you. Now, to the transparency requirements, would you recommend, I know it's probably not the ideal approach to bifurcating, but if we were to come up, maybe use from the first version of TREGA, the definition of contributing factor, and if AI is a contributing factor to a decision, require disclosures, and then a higher bar for the other. Again, I know it's not ideal, but do you see ways that that could happen?
The way I'd put it is that would be a great start, Senator. I think that would allow existing laws to function more effectively with respect to these systems, which again is one of my main concerns. It doesn't, though, get to the kind of unique harms and the unique things that regulators and courts that are used to enforcing existing laws, those will kind of have to still be reinterpreted if there aren't protections that are specific and guardrails that are specific to AI-driven decisions. So yes, my ideal would be to have a broader definition that applies to everything. But certainly having at least those definitions apply to the notice and explanation requirements would be a very good start.
Right. Thank you. And I haven't reviewed the Nebraska law yet, but I understand that Nebraska does bifurcate the responsibilities. Have you reviewed it's not a proposed Nebraska law, I should say.
I did review it initially, and I don't recall that being in there. It's possible it's been amended since I looked at it, or maybe there's two different bills pending before the Unicam in Nebraska, and I missed one of them.
Yeah, well, I haven't read. If there's two, I haven't read either of them. So you're at least one ahead of me. So thank you. All right, I don't know if anyone else has questions. Okay, thank you very much for taking the time to come testify before us today.
Thank you, Senator.
Next, Thomas Mealy?
Yes, sir. Mealy.
Mealy. Okay, please go, Thomas. The floor is yours.
Good afternoon, everybody. I appreciate the opportunity to the committee, all my colleagues that are currently there in person. I apologize I couldn't make it. I'm here to speak on the wholesaling bill that has been addressed from Attorney Zillow, my two colleagues, Bob and Adam over at Perch Rock, Joe as well. Appreciate you guys shining light, as well as the members of the Realtor Committee that have kind of brought up their concerns on this particular topic. For me, I don't necessarily have an idea of what, the mainstream reason for everything that's going on. The two items that stick out to me, obviously the 70 days for closing date, the 10-day right of rescission, those two particular into this bill. I just want to touch on those first. A little bit about me. I don't consider myself a wholesaler. People ask me what I do. I tell them I'm in real estate. I'm a licensed agent in Connecticut, Mass, Rhode Island, soon to be Florida, Georgia. I own a rental portfolio. I've done some fix and flip. As far as probate, short sales, foreclosures, any type of real estate transaction you could possibly think of, I've been involved with over the last 5 years. I'm by no means an expert, but I do know a little bit about a lot of stuff, and I take pride in that. When I am talking to homeowners, when I'm talking to buyers, lenders, whoever it may be that I come across in my day-to-day, being in this industry of I guess, entrepreneurship, because I don't really have a boss. No one tells me where to be. I don't have a 401k. I don't have an IRA, no pension plan or anything like that. So it is survival of the fittest. So for me, I like to look at every opportunity that I come across in the day as having a conversation with a seller or a buyer and kind of giving them options. I think that's the biggest misconception, that uh, I'm not a wholesaler. Wholesaling is an exit strategy. It's not a business model. Okay. So when I look at a property, I look at it as an opportunity to have a conversation with that seller and then dictate what the best exit strategy is going to be for that particular situation. Is it speed? Is it convenience? Am I representing them as a seller? But
Mr. Mealy, can you hear us?
so
You froze on us for a second, so maybe if you could shut off your video.
It is an exit. Hello. Oh.
Okay, if Mr. Mealy comes back, we will give him his, probably had a minute left, I would guess. So, so we'll move on. Ellen Hengesbach?
Angus-Bach, yep, you got it close.
All right, please proceed. The floor is yours.
Thank you. Thank you, Chair Maroney, members of the committee. I appreciate the opportunity to testify today in support of SB 1356. My name is Ellen Hengesbach. I'm an associate with PIRG, the Public Interest Research Group. We're a nonprofit organization that advocates for the public around issues that affect our health, safety, and well-being. We support SB 1356 because it is a common sense update to the Connecticut Data Privacy Act that will provide meaningful protections consumers currently lack. Those updated protections include the data minimization provisions discussed earlier, which are critical because when we use our favorite apps, websites, or smart devices, companies on the other side are often gathering far more information about us than what's necessary to deliver the products or services we're expecting to get. For instance, a report from the Mozilla Foundation found that some major car companies can collect surprisingly intimate information about their customers, such as their religious affiliation or medical conditions, from cars' onboard computers and companion apps. These data collection practices do not match up with consumers' expectations for the products or services they're using, and are also dangerous for consumers' personal security. The more data that companies collect about you, and the more companies they sell it to or share it with, the more likely it is that your information will be exposed in a breach or a hack and just end up in the wrong hands. This was made all the more real last month when it was discovered that a major location data broker called Gravy Analytics was the target of a hack that has led to tens of millions of location data points being leaked. The best thing for consumers is to change how companies can collect and use personal data up front, and SB 1356 gets at this with its data minimization provisions. And finally, I'll just reemphasize the point you've heard before about how Maryland has passed a privacy law that limited unnecessary data collection, as well as banned the sale of sensitive data outright. Therefore, without SB 1356, the privacy and security protections Connecticut residents have will be materially weaker than those of Maryland consumers. Ultimately, passing these updates will continue to strengthen Connecticut's law in meaningful ways that will better protect consumers from harmful data collection practices while still allowing businesses to provide the products and services that consumers are looking for. PIRG urges you to continue the important work you've already done to protect consumers' data privacy by supporting this bill. Thank you.
Great. Thank you very much. And I think I'd be remiss if I didn't again thank the data privacy unit at the AG's office, Michelle Lucan, John, and Mike Martone. And I know they have expanded since over the last couple of years, but it was based on their report. They brought, like, I think a third of the complaints they received in the first 6 months of the bill fell under one of the exemptions or one of the issues that we're looking to address here. So I thank them for all of their work. Michelle is a national leader, really, in data privacy, so we're lucky to have her. Let me see, the question I had. So, yeah, and I think, let me see if any members of the committee have questions. No? Okay. So, Ellen, thank you very much for coming to testify today.
Absolutely. Thank you so much for all your work.
Thank you. Have a great day. Okay, is Thomas back on? Okay, Thomas Mealy, please.
Sorry about that, everyone. I had some technical difficulties here. Of course, my internet goes out the second I start my my testimony, so I apologize and appreciate the patience. What was the last? When did I get cut off? What was I last speaking about?
What was? Do you remember the last word? Yeah. Yeah, it was. Wait, hold on. Let me see. No, I don't have it in my notes. I'm sorry. I can't.
It's okay. And
I can't.
back, I'll just pick up where I left off. I think the last thing I was saying was that I do a little bit of everything in the industry as far as real estate goes. I am a buyer's agent. I'm a seller's agent. I do probate, short sales, foreclosures, fix and flip. I am a landlord. I have a portfolio of rental property that will eventually go to my children. That is my retirement for my wife and I. I think the notion of wholesaling gets a bad reputation. It actually makes me cringe. I don't like the word. I don't look at myself as a wholesaler. It's an exit strategy that I do use when it is appropriate. It's not something that defines what I do in the real estate industry, but sometimes it is necessary. Based on a particular certain situation. The two items in the bill, the 70 days for the closing and the 10-day right of rescission, I would like to see not even entertained and removed. The reason I say this is not because I don't like them. It's because typically when you're dealing with sellers, a lot of the times that they do want to work with us as an investor directly, as opposed to listing on the market with an agent, is that they get to pick the closing date. So if they don't want to close, for instance, I have some deals going on. Sellers don't want to close until the school year is up. So what does that mean for us as an investor? It's, if we're going to accommodate the seller and get them to work with us, how could we make it more accommodating for them to put them in the best situation possible? And that's delaying the closing and taking title to the property. A lot of times when we go into these agreements, I personally take a lot of pride in disclosing options to the seller. For instance, like I said before, with wholesaling being an exit and not an adjective to determine who somebody is, it sometimes could be that, like Joe said earlier, that maybe listing the property is the best option. But I don't know unless we have a conversation with the seller. Is it buying the property and doing a delayed closing? Is it maybe like other investors have said, that there are situations where sellers don't want people coming in the home. There's a situation and probably a week ago that we just had a recent closing in Milford that a seller interviewed maybe 3 or 4 agents to come into the property, and none of them would touch the listing unless the seller made significant repairs, spent a major amount of money. And at that point, the seller reached out to us and just decided to do a direct sale. The caveat of this story is actually, quite interesting, if I do say so, is that she needed the money from the sale in order to purchase another property. So part of the agreement that we put in place with the seller was that we make the sale contingent on finding suitable housing. So how do we find suitable housing? Yes, we do have off-market inventory that we're going to give to her. But is there a situation where we act as the buyer's agent and represent her on the buy side? Absolutely. Challenge you run into with that is when you go to listed properties, there is typically a bidding war. unless the property has been sitting for a while, and essentially there is room for negotiation with that price. All great, might make a strong offer on the property, but what's going to happen next when that property goes under contract? The listing agent for that property is going to expect some sort of earnest money deposit, whether it be 1%, $5,000, $10,000. What if the buyer doesn't have those funds available? Well, being an investor and getting creative, if we provide those funds so that seller can secure that property. You know, I don't see many real estate agents that are going to come out of pocket with their own personal funds to put down for a client. So in terms of
Summarize, I think your 3 minutes are.
perfect. And I'm not going to go too much off the cuff. If you guys have any questions pertaining to, you know, anything that I did speak about, I'm happy to answer.
Great, thank you. Are there any questions from the committee? Okay. I don't hear any questions, so thank you for hanging in there and for testifying.
Perfect. Thank you. Have a good day.
You as well. Next, Rachel Baird. It says in person. Okay. All right. Philip Recht.
Yeah. Thank you. Appreciate the opportunity to speak to you and your committee. Philip Recht is my name. I'm a partner in the Mayor Brown Law Firm. We represent a coalition of companies that provide people search services. Yesterday, I sent in written testimony that goes in significant detail to the issue I want to raise. Let me just summarize it here. First, to give you a sense of what our companies do. They collect data mostly from publicly available sources. They compile the data into profiles, and they offer them for sale to whoever wants to buy them. These profiles are widely bought, considered very valuable by any number of Connecticut entities, individuals. That includes government agencies that use them widely for law and benefits enforcement, the business community that uses them for fraud detection and to communicate with customers, and mostly though by individuals who use them for an array of sort of family and neighborhood and security and other purposes. Our companies have been supportive from day one of state privacy laws. And in fact, I don't know if you remember, but in 2022, we actually submitted testimony and supported the Connecticut privacy law. We continue to support it. I'm here to testify on Senate Bill 1356. Sorry, I didn't mention that earlier. But we only have one concern about that, which is the following. This bill would remove the exemption for publicly available data or publicly available information if the information is either compiled in a consumer profile, which is available on the internet, which is exactly what our companies and dozens of other, if not hundreds of other companies do, or if the information is otherwise made available for sale. In our view, despite the motivations behind this, which may be good, if this exemption were removed, it would violate the First Amendment protection of free speech, expression, and access to public information. And to be clear, these First Amendment rights do not simply belong to businesses like the companies we represent, but to the public, consumers, citizens alike. In the words of the Supreme Court, providing citizens access to information from many sources is, quote, the whole project of the First Amendment. In other words, this is the heart and soul of First Amendment rights and protections. And given the importance of these rights, the cases have made clear that states can restrict the use of public information only if they have what's called a compelling state interest, and only if the restriction on the use or provision of this data is narrowly tailored to meet that goal. That is an extremely high bar. It requires specific findings, and it can't be met by just a general interest in privacy. And to date, not a single one of the 20 states, including Connecticut, which have passed state privacy laws, have sought to do anything other than what Connecticut did, which is to exempt publicly available information from their laws. The same is true of a model state law, which was developed by the Uniform Law Commission. The same is true of the one and only federal privacy law that's actually been considered by the Congress back in 2022. The fact that publicly available information is compiled into a report or is made available for sale doesn't change the law. In fact, the U.S. Supreme Court just last year in 2024, in the Net Choice case, concluded that compiling and curating public data does not change the data's First Amendment protections. In fact, they went further to say that the compilation itself is a form of expressive activity that is entitled to First Amendment protections. Beyond these legal issues.
Your 3 minutes were up.
Oh, I'm sorry. We would just urge you to maintain the current exemption in the law. It will not only keep you consistent with the other states, but it will also avoid the risk that the entire law is invalidated as a result. Thank you.
All right, thank you. So now this issue came to us from the AG's report, and that some of the people who complained who had filed complaints through the AG's office, their complaints were about issues that were exempt because of the publicly available information exemption. I was at another conference where they brought up a website that you could go to, and based on publicly available information, and this was free, you would put in your name, and someone had said, not only did it come up with all the information about him, it was their family. It had a photo of his daughter, her address, and this was shared in the context of the right, we give the right to delete your data, right? The right to access to delete. In Europe, they established a right to be forgotten. We didn't, we just give a right to delete the data. But how do we obtain, so in some ways, if we're exempting all the publicly available information, people want it deleted. And I understand that, like, for a public official, there's a public interest, right? But for some people, they don't want that information out there. How do we balance those then? I mean, do you have suggestions on how we could?
Yeah, no, and I think that, right, I read the AG report. I'll note one thing, that the AG did make one recommendation about changing the word and to or, but it very conspicuously refrained from suggesting that your committee do anything with respect to the broader exemption. Again, I think it's because of this First Amendment protection. The one thing I'd say to consumers is they have certain powers. First of all, some data is made available often by consumers themselves if they have public Facebook profiles and the like, and they can certainly make those private. Otherwise, consumers can ask companies to opt out their data, in other words, to not sell or disclose the data. Again, under the law, the companies are not obligated to stop selling publicly available information given the First Amendment protections. But I will tell you that all the companies that we represent, and I think many, many others, will honor these opt-out requests with respect to all the data of an individual. So I think that's probably the best protection you can provide them.
Do you mind, Mr. Chairman? Just because would you be considered a data collector under this bill?
A data collector. Well, we certainly collect data. Yes.
It's called, it says a data broker part. Yeah.
Yes. Correct.
A data broker.
A data broker. Yes. Yes.
Data broker. Okay. And then it says in here that does it define any sensitive data? Is there a clear definition of what a sensitive data is?
Well, I think the Connecticut law already has one, but I think there in this bill, there's a proposal to enhance that definition in certain ways.
Right. I just didn't know if you could outline the differences in the two. You could. Yeah, go ahead. All right. That's all I had. I was reading through it and I thought a couple of questions just popped out at me. So thank you.
Yeah, and by the way, we support these enhancements of the sensitive data definition.
Great. Okay. Thank you very much for testifying.
Thank you. Appreciate the time.
Okay. Next, Dylan Coco. Says online. Okay, we'll go to the next. Next is Neil Marinon.
I'm up.
Oh, hello?
Yep, I don't know if it's working. Can you see me?
Yes, we could see you.
Thank you so much, Senator Maroney, Representative Lamar, Senator Torella, Representative Retigliano, and members of the General Law Committee. I'm Neil Marinan. I'm a licensed veterinarian in Old Lyme. I'm the vice president of the Connecticut Veterinary Medical Association. And we're here to thank you for the opportunity to testify in favor of Senate Bill 1355, an act concerning prescription drugs. Section 3 affects us. Licensed veterinarians are dispensers under the Connecticut general statutes. And the law currently states that only a licensed veterinarian is permitted to dispense medications. And then the regulations basically say dispensing is everything from putting the pills in the bottle, putting the label on it, putting the cap on, handing it to the client. In reality, the veterinary technicians and assistants are counting pills. And for safety, we have 2 people look at such things. So the CVMA is requesting the change in the statute to codify decades-long practice and bring it in line with the Federal Drug Administration regulations in other states where the licensed veterinarian's direct involvement and oversight is required, as always. This is from the FDA. As part of a team approach to veterinary medicine, a licensed veterinarian in the course of their professional practice may direct staff to dispense prescription animal drugs. Such directions to staff are consistent with the requirement that the prescription drug be dispensed by or on the lawful written or oral order of a licensed veterinarian in the course of the veterinarian's professional practice. And in another section of the FD&C Act, they say that without a lawful written or oral order of a licensed veterinarian, it would be unlawful for anyone other than that to dispense prescription animal drugs. So the CVMA, we take the dispensing of prescription drugs very seriously. Ultimately, we are the licensed person responsible for being sure that it's done properly, correctly, that it's not mislabeled. And the CVMA stands ready to work with the committee and the Department of Consumer Protection on this issue. We've submitted written testimony. If there are questions, I'd be glad to answer them.
Great. Thank you very much for bringing this issue to us and for your testimony. Does anyone on the committee have questions? Okay, hearing none. Thank you very much.
Thank you so much.
Next, Vahid Bezadon. Okay. We can come back. Is Dylan back available online? Okay. Next, Liana Keesing.
Hi there, I'm here.
Okay, great. Please proceed.
Great, thank you. Well, Chairs Lamar and Maroney, esteemed members of the Connecticut General Law Committee, thank you for the opportunity to testify today in strong support of SB 1356. My name is Liana Keesing, and I serve as a campaigns manager at Issue One, a bipartisan democracy reform nonprofit dedicated to strengthening our information ecosystem. Issue One runs the Council for Responsible Social Media, a coalition of over 70 bipartisan leaders advocating for responsible internet policies. Our members include over a dozen former members of Congress from both parties, including Chris Shays from Connecticut, dozens of national security experts, including 2 former secretaries of defense, and experts like psychologist Jonathan Haidt, author of The Anxious Generation. As a council, we have identified strong, comprehensive data privacy protections, specifically those that include data minimization standards, as the most effective step state legislators can take to improve the digital information ecosystem and make the internet safer for everyone. We commend this committee deeply for the work that they've already put into SB 1356, which is an essential step towards protecting Connecticut residents. However, we believe 2 key updates are necessary to align it with Maryland's model, both of which have already been mentioned at length by others. First, the strictly necessary standard for sensitive data collection. Maryland's law includes this safeguard, ensuring companies collect and process sensitive data only when it is absolutely essential for delivering a product or service requested by the consumer. The current bill standard is too broad, leaving room for companies to justify excessive data collection under vague definitions of necessity. And two, a complete prohibition on the sale of sensitive data. The consent loophole in the current draft undermines the regulation's strength. It is nearly impossible for consumers to provide informed consent when clicking a small checkbox, as they have no real understanding of who will buy their data or how it will be used. Open markets for sensitive data expose individuals to identity theft, financial fraud, stalking, and exploitation by foreign actors. Importantly, strong data minimization laws for sensitive data are both pro-innovation and pro-small business. As a technologist myself and a former startup founder, I understand the challenges of compliance firsthand. The changes we propose would only apply to sensitive data, while we support strongly maintaining a reasonably necessary standard for non-sensitive data. Responsible innovation does not require an unchecked data marketplace for sensitive information. A competitive, dynamic economy thrives when trust in the digital ecosystem is strong. By prohibiting the sale of sensitive data and enforcing strict limitations on its collection, Connecticut can lead the nation in fostering both responsible innovation and consumer protection. I'll be frank, given Issue 1's concerns about national security and innovation, we actually agree with industry on one point. We'd prefer a strong federal standard to a patchwork of state laws. But as you all know, Congress has been slow to act, and in my conversations with Republican and Democratic members of the House and Senate Commerce Committees, they consistently emphasize that state action across both red and blue states is the best way to push for a robust national framework. As others have emphasized, Connecticut has been a leader in this space, and strengthening this bill will not only protect its residents, but also contribute to the establishment of a national standard for responsible data governance. I urge you to pass SB 1356 with these critical improvements to ensure a safer, fair, and more trustworthy online information ecosystem for all. Thank you for your time and consideration, and I'm happy to answer any questions.
Great, thank you very much. I just wanted to go back over one of the points you raised. So with the data minimization, then, are you suggesting a bifurcated standard that the strictly necessary for collection of any sensitive data and then reasonably necessary for other non-sensitive data?
That's correct, yes.
Okay, great, thank you. And I think that was my main question for now. If we think of anything, I will reach out. But thank you for taking the time to testify to us today.
Thank you for the opportunity.
Okay, next, Andy Kingman.
Hi, good afternoon, Mr. Chair. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We are a New England-based multi-sector coalition. I also have a background as a privacy compliance attorney, helping companies work through various state privacy laws. And we were honored to be a member of the Connecticut Privacy Task Force. As with AI, we're here with great respect for Senator Maroney's nation-leading work here in this area. We look forward to working with you throughout this process. We do have several concerns with SB 1356 as currently drafted. The biometric data change to can be associated with, I think, is unnecessary and would be an outlier with the other states here. I think it would result in confusing consumers and scaring them unnecessarily when features like glasses try-ons that measure face geometry but do not attempt to identify individuals would be informing consumers that they're collecting sensitive data. I think you've heard a lot about data minimization today. We do not see a reason to depart from the current data minimization framework. This framework currently covers over 610 million consumers worldwide. It is the basis of the EU's data minimization framework. It is the basis for California's data minimization framework, and is the basis for all of the other state privacy laws other than Maryland. Moving to the current proposed language could restrict access to updates for current products, patches for security, It may result in more click-throughs for consumers. And there is already a bill in Maryland to correct this provision of the data minimization in that law. We're also concerned about the privacy policy disclosure additions. Adding the specific third-party language again would result in, because those lists can change frequently, it could result in many more emails to consumers and click-throughs about updated privacy policies. And while we don't see any reason to divert from the current knowledge standard of actual knowledge or willful disregard in the current law, we would just note that there are multiple knowledge standards that are proposed in here. And again, we support keeping the current knowledge standard as is, but believe that we should have obviously consistent knowledge standards throughout the bill. With that, I'm happy to take any questions.
Great, thank you very much. Understanding that we feel that the current publicly available information exemption is too broad. I believe Delaware had made some updates to their definition or to their exemption. Are there other states you can point to that may have narrowed that exemption, but you feel are more workable?
I think that that the states are very uniform on that, Senator. I don't believe that there are states that have really diverted from that. And I think, I would not hold myself out as a First Amendment expert, but I do believe that the First Amendment concerns expressed by the gentleman who spoke earlier or what's driving that concern there for changing the definition.
Okay. And then the knowledge standard, I guess, understood. Thank you for pointing it out. It needs to be consistent. We didn't change it in all of the places where it needs to be changed. And I think this is something we're going to have to work through, but I think that actual knowledge or knowledge fairly implied by reasonable is where I would like to go. So it's which again, it was in the federal COSA, understood that there is examples of that standard being used in other areas of law, which is why they picked it up. But I think that's something we'll have to get feedback going forward.
Yeah, and we're happy to give feedback as we obviously continue conversations here, and look forward to working together throughout the process here.
Okay. And then, yeah, and I think, right, this is the start of a session-long conversation, I feel. So I guess I could save some of my questions for later on. I'm fairly certain I will talk to you more than once between now and June 4th.
Look forward to it.
All right. Are there any other questions? Okay, hearing none. Thank you for coming to testify today. Okay. Are either Vahid or Rachel online? Okay, Mendel Deitch. Hey, Orion? No, okay.
Good afternoon, everyone, and members of the committee. I'm here to testify in support of House Bill, now a committee bill, 5425, an act concerning heritage railways and alcohol liquor. My name is Orion Newell. I'm a resident of Connecticut since 2011. Trains have always been a part of my life, as my mom volunteered at a railroad museum in Washington State and got to run their diesel locomotive. I was 5 years old then. After moving to Connecticut, I was able to continue my passion and start a career at the Naugatuck Railroad in Thomaston, Connecticut. I'm currently the passenger operations manager for the company. Each year, we put smiles on 50,000 people, and we bring millions of dollars to the local economy. 3 years ago, while renewing our liquor permit, fresh out of COVID, to sell alcoholic beverages on board the train, a liquor permit we've held since 1995, the price went up from $200 to $2,000 annually every June. This came as a complete shock, as at the time we did not have a lot of extra funds to go around to renew that permit because of the COVID-19 pandemic. We of course paid it, so we did not lose our license, but that cost was a burden and was of course passed on to our customers. Today, that same $2,000 fee still applies, and every year we have to pass it on to our customers and local vendors. 5% of our liquor comes from Connecticut companies, such as Sunset Meadow Wine of Goshen, Connecticut, Litchfield Distilleries of Litchfield, Bad Dog Brewing Company of Torrington, Clocktown Brewing Company of Thomaston, and a majority of it all delivered by Slocum & Sons Distributing in North Haven. A good portion of our liquor business is tasting from these local places, and we make sure to keep the trains affordable by keeping it under $100 per ticket. But with that increase, dividing the number of trains by the number of tastings, that is about $100 an excursion just to renew the liquor permit, which of course comes out of our pocket as a local business and the consumer. The intention may have been to increase that $200 permit to $2,000 to capitalize on the big railroads with multiple bar cars like Metro North or maybe Amtrak. But those bar cars between New York and New Haven haven't been around in years, and there's no sign of those coming back. So once again, that $2,000 is passed on to small little companies like the Naugatuck Railroad and our vendors. Please help us, our vendors, and our customers save money by passing HB 5425. We would love to continue to help promote the sale of Connecticut-made products at an affordable price while showcasing the amazing Connecticut history of local attractions and our railroad cars. Thank you.
Good to see you, Ryan.
Nice to see you as well.
We have a good history here, don't
Yeah, we
we?
do. I think we were over there last time.
Yeah. And prior role of transportation. I think you came up when you were like 17 years old or something.
Yeah, I don't even think I was a registered voter yet.
Yeah.
But now I am, so.
We were disagreed at that point in time, if I
We
recall
did.
correctly.
But that's democracy. So
That's democracy at work.
Yeah.
But I had a good chance to see you this summer out on the rails. It was good seeing you then. And good seeing you here today. I think you're right. I think you highlighted a great injustice in the structure of this fee. Glad to be on the same side with you again this time. And I think we can fix this, I think, egregious fee structure in place for Heritage Railroad. So thanks again for coming out here.
Yeah, I appreciate that. And like I said, our intention, there is consumer protection. We should have a liquor permit. We're not disagreeing with that. We're just disagreeing with the $1,800 additional cost it costs us to renew that.
Of course. I mean, I think we could have solved a lot of this if we had enacted a user-based fee on our highway system a number of years ago.
Oh boy, here we go.
But since we didn't quite get there, I think it's wrong for us to take this approach instead. It's good seeing you again.
It is.
Are there any further? Thank you for coming to testify today. We look forward to seeing you at the railroad.
Thank you. You're more than welcome, every one of us. Please pay us a visit this year.
Great. Thank you. Next, Paul Pescatello.
So good afternoon. Again, Paul Pescatello. I'm Executive Director of the Bioscience Growth Council at the CBIA, also Senior Counsel, and I'm also Chair of We Work for Health Connecticut. Both organizations are really committees of established biopharma companies, emerging biotech companies, and research institutions. Thank you so much for this opportunity to speak before you. I'm here today to speak in favor of SB 1355, an act concerning prescription drug costs, specifically Section 2D, which would remove a section of Public Act 23-171 that requires the prominent posting of the names of pharmaceutical representatives on the Department of Consumer Protection website. The removal of this section comports with the intent of Public Act 23-171 and will address significant safety concerns. The overarching public policy goal of Public Act 23-171 was to establish a registration of pharmaceutical representatives with the DCP. Registration, in turn, triggers a $150 per year fee per pharmaceutical representative and annual provision of certain information to the DCP by pharmaceutical representatives, including the number of contacts with prescribing practitioners and pharmacists, the specialty of each prescribing practitioner and pharmacist, whether product samples, materials, or gifts were provided to the prescribing practitioners, a practitioner's staff or pharmacist, and the aggregate number of free samples dispensed. In addition, each pharmaceutical representative is required to disclose to the prescribing practitioners and pharmacists the list price of legend drugs and the quote-unquote variation efficacy of the legend drug to different racial and ethnic groups. Public Act 23-171 is about two bilateral relationships: regulation by the pharmaceutical representatives with the DCP, and second, certain disclosures pharmaceutical representatives owe to prescribing practitioners and pharmacists. Other than Public Act 23-171, Section 4D's, its peculiar directive that the DCP post on the internet a list of pharmaceutical representatives, nothing in the law is about providing personally identifiable information to the public. It's unwise to make such information publicly available, and therefore removal of Section 4D is prudent for significant privacy and safety concerns. Unfortunately, we live in an age of significant animosity towards large institutions, organizations, and corporations. This can manifest itself in harassments and violence towards representatives of such institutions, organizations, and corporations. In my work with biopharma and biotech companies, I'm struck by the increasing number of occasions that members of the public take it upon themselves to harass company scientists, executives, and representatives. A significant security presence is now standard protocol on company property and at events and forums involving company representatives. It's also important to underscore that pharmaceutical representatives provide incredibly valuable services both to prescribing practitioners and pharmacists in the form of education about new medicines and medical advances, and to patients in the form of samples. To a few bad actors, knowledge of the availability of samples can be a powerful trigger for the theft from pharmaceutical representatives of the samples. So for the sake of privacy and safety, I hope you will see that it is counterproductive to post a public billboard on the DCP website with the identity of pharmaceutical representatives. I'd be happy to answer any questions you might have.
Great, thank you very much. Are there any questions? I think we're in broad agreement with you. So thank you for coming to testify today.
Okay, thank you.
Next, Josiah Schlee.
Good afternoon now, I guess, to the esteemed members of the General Law Committee. I really appreciate you having me here today. I've been coming to this building for 18 years. First time I was here, Senator Blumenthal taught me how to write a bill, how lobbying worked, and I think the room right over there a few years ago. And I grew up all my life trusting the state of Connecticut and these agencies to protect me. So in regards to SB 1357, this came from the commissioner's testimony. I may be interpreting it wrong, but sections 37 and 38 remove the cap on restitution under CUTPA and clarifies the process of ordering cease and desist orders. That was in his testimony. I looked through the bill. I couldn't find the exact sections referenced, but based off his testimony, I just wanted to share that I personally know individuals and spaces who are targeted individually with CUTPA violations. And if there's no cap on that, that is very dangerous. And I just am very much questioning the processes of the Department of Consumer Protection, as they just sent some stuff to the Attorney General before the comments were posted. They're not following the regulatory process, and it doesn't seem anything is happening. They posted all the comments from medical patients with all their emails and information, and then remove them and then put them back up, and blah, blah, blah. It's been back and forth, and it does not feel good. It does not feel open. It does not feel transparent. It feels intentional. the DCP has also hired agents to specifically investigate cannabis, can arrest people without a warrant. They can conduct observation, investigations. They can interview witnesses. Is the DCP the DEA? I'm very confused as to why these people are allowed to investigate, follow, arrest without a warrant. This is the Department of Consumer Protection, who my interaction with them growing up was, oh, your chicken's going bad. There's a salmonella warning. And I understand they oversee pharmacies, et cetera, and that cannabis is considered a pharmaceutical drug in Connecticut. And I'm very concerned, and I've been asking the Attorney General personally, state ethics, state auditors, et cetera, to investigate what the DCP did in 2020. I've never got an answer from anyone, including the Attorney General, over and over. When bodily harm was done to patients, how can we trust the DCP to be writing a single law? So I'm not upset with any of you guys. I really appreciate you so much. Frustration with this is with how people have been treated for the most vulnerable. And I just want to make sure that something was said in some way today.
Right. Josiah, thank you for coming to testify to us today. I don't know if Rep. Osborne has a comment or a question.
I mainly just want to say, hi, Josiah. Good to see you. Thanks for being here with us today. Thank you for your commitment to consumer safety for people who use cannabis. And I know how passionate you are about it. It's good to see you. Thanks.
Yes, good to see you, Don.
Great.
Thank you.
Thank you very much for coming to testify.
Yeah, I appreciate it. Have a good rest of the afternoon.
Thanks, you as well. Okay, next, Neil Chilson from the Abundance Institute.
Hello. Chairman Maroney and Lamar and members of the General Law Committee, thank you for the opportunity to share my opposition to SB2's regulatory components. I'm Neil Chilson, the head of AI policy at the Abundance Institute, which is a nonprofit focused on ensuring that life-changing technologies like AI foster widespread human flourishing. I'm a computer scientist and a lawyer, and I previously served as the chief technologist at the Federal Trade Commission. In the years since I last spoke on SB2's prior version to this committee, AI has advanced rapidly. There's been dozens of major new models that have launched, and usage has soared. Companies have deployed this. Hundreds of companies have deployed these technologies. In fact, I saw a stat today that OpenAI's ChatGPT now has 400 million weekly users. In the past year, the bill has also changed. Definitions of algorithmic discrimination and substantial factor have been improved quite a lot. On the other hand, there's a new automated decision-making opt-out, and the bill also now regulates general-purpose AI models that don't pose high risks. And I think the open source exception is significantly worse. I'll expand on these specific textual concerns in my written submission. But one thing that hasn't changed in the past year, despite an enormous surge in AI use, I haven't seen corresponding evidence of a growing pervasive discrimination that's being exacerbated by AI technology. I really enjoyed Chairman Lamar's asking whether this is the right time to regulate, pointing to the automobile. It's a really good example. In the early days of the automobile, England, which was the world leader in the technology, actually passed a law to provide transparency and to reduce risk to people from these new vehicles. The so-called red flag law required that every automobile on the road must have someone waving a big red flag walking in front of the car. You can imagine how that worked out. The red flag law killed England's auto industry. They regulated too early before anyone understood the actual uses and harms from the technology. That's where we are with AI. The general purpose nature of AI, far more general than the automobile, means we've only scratched the surface of the applications that are coming. No one wants to write the red flag laws of AI. One indication that we're not quite ready to regulate AI models is that SB2 offers no substantive requirements on how to prevent AI model discrimination. Instead, it requires a reasonable care standard. No one knows what AI software development practices actually meet that standard. If we did, presumably we would write it into statute like we do with seatbelt requirements. SB2 would be much improved by a focus on identifiable harm at the application layer. In other words, a focus exclusively on deployers, where AI-informed decisions are made. If discrimination is the concern, regulate deployers, the ones making consequential decisions and best informed about the trade-offs. That's where discrimination occurs and where it must be addressed. A straightforward major improvement of SB2 would be removing sections 2, 3, and 5. I'll stop there. I think I'm out of time, but thank you for the opportunity. I'd be happy to answer any questions.
Yeah, your time is up. Thank you. Let's see if there are any questions. Okay, Representative Osborne, I do have several after, so please go.
Thank you. I know that your time, first of all, thank you so much for being here today and helping us grapple with this very important issue. I know you were out of time and you had more to say, so I was wondering, can you tell us what more you had to say before you ran out of time?
I think I would add, there's lots of details we could get into essentially on sort of the definitions of algorithmic discrimination and the automated decision-making opt-out. I was a bit surprised to see the automated decision-making opt-out in the document. It's a big decision. It's a big change. It's a big new obligation. In fact, California is actively writing a whole set of rules around what it means to do opt-outs in automated decision-making. And to have it sort of casually put in there was a bit of a surprise. But my bigger point is that structurally, the bill in many ways could be improved by focusing exclusively on deployers, and that the requirements that you might put on deployers here would then be contractually entered with other people in the AI supply chain, which we don't fully know how that's going to all play out. It could be model developers. It could be, you've seen some of the challenge about naming the people that aren't exactly developers, but aren't exactly deployers. The chain is still really being worked out there. And so I think by focusing on deployers and the harms that happen when deployers make decisions, if they do happen, I think that we can let the rest of that work out through contractual requirements.
Okay, Representative Osborne, do you have any other questions or you? Okay. All right. Thank you. Okay, yeah. It's not exactly a page turner, but I'm glad someone is finding it enthralling. So, all right. Back to, again, the duty of care. I think we do lay out what it takes by saying that you have a rebuttable presumption that you've met the duty of care if you fulfill the obligations under the law. So I would argue that it is clear what you need to do. But back to the focus on deployers. So my concern is many of the deployers may be small businesses. And you're saying that they're going to be liable for doing, and I'm not sure if you reviewed the New Jersey Attorney General's opinion on how the laws against discrimination apply. And they say that if you're going to be deploying AI, you need to do initial and ongoing assessments to avoid discrimination. So how is a small business going to get the information they need to run those assessments, those impact assessments, if the larger businesses are not compelled to give them that information by law?
So I think you're basically making the same point that Commissioner O'Keefe made multiple times, which is that we have an incentive problem here. And when we put a bunch of red tape requirements on companies, and they're going to try to figure out how to comply with these, and that's going to cost money, right? And that's and to your point about whether or not compliance here is clear, my point was that it's not clear that checking all the boxes in the law right now are the sorts of things that under tort would be a reasonable standard. You're providing that as a safe harbor, essentially. But we don't actually know that the practices that are required under the law, which are largely procedural practices, are ones that are going to actually prevent AI discrimination. But back to the previous point, I do think that the challenge is that if you're going to impose regulatory costs on small businesses and then expect to ease that cost by imposing those costs on other businesses, that those, especially those developers, have lots of choices of states and lots of choices of customers, and they won't take that cost laying down either, just the same way that small businesses in Connecticut won't take that cost laying down.
And so the obligation I cited is an existing obligation under, it was the Attorney General of New Jersey's opinion that current laws against discrimination and the current Uniform Trade Practices Act require these things. So in Oregon, they said that their current Uniform Trade Practices Act and their current data privacy law require an affirmative duty of disclosure. So in both of those, the Uniform Trade Practices Act in Connecticut allows for a private right of action. And so, my concern is by just putting this on deployers and not telling them, we're not giving them a clear pathway with how to comply. It's implied that they have to do these things versus laying out a clear pathway. But by not giving them that clear pathway, we're leaving the decision to the courts. And I think, as you're aware, the only major data privacy law that was passed that had a private right of action was the Illinois Biometric Information Protection Act, which was passed in 2008. First court decision really didn't come down until 2019. Do we want to wait 11 years to have an idea of what constitutes harm and tie things up in the court when we can do it? And it's my understanding that there have been, the California, as you mentioned, California Privacy Protection Agency is in rulemaking. At one point, I believe the FTC also was going to engage in rulemaking around the automated decision making. I could be wrong on that. So this isn't new. We're trying to provide some certainty to businesses.
Yeah, I think that's a great goal. And I think there are ways to provide certainty to small, medium-sized and large companies in Connecticut that want to deploy AI. I think certainly some sort of safe harbor provisions on how people can deploy this technology without triggering, massive lawsuits makes some sense. But I don't think that the right way to do that is to have sort of duplicative reporting requirements all the way through the AI supply chain, rather than at the point of the company that actually has the most responsibility to the customer, which is the company that's serving the customer.
Do you believe that risk is inserted at different points of the supply chain?
Yeah, that's an excellent point. And over today, I've been listening to this hearing. It's been great. And we've sort of talked about this at a really abstract level, as if all models and uses are subject to the same risks and the same types of harm. And so that, to me, is a great argument for the fact that we should regulate. My ideal in this space would be to regulate by an industry specific application, say insurance or transportation. How does it use AI? And we obviously already have lots of regulation in that space, but supplementing that to address any unique issues that come up in AI. But if we're going to do a sort of broad-based approach and say that for people who deploy AI, we want to make sure it doesn't have discriminatory effects, rather than having to try to solve all the issues all the way up the supply chain in one big piece of legislation, if we focus on that intersection between the company and the consumer, where the harm happens, and the parties are most informed about both what the trade-offs are and who the people involved are, I think that we can then, the rest of it can kind of work out over time. I was looking back at the previous hearing, and one of the things that you said earlier in that hearing was talking about wanting to focus on the what's the smallest thing that we could do here in order to protect the people of Connecticut. I think what you actually said is we need to look at what's the smallest thing we can do to provide the safety and surety to our citizens so that people will adopt this technology. And I totally support that goal, both of encouraging the people of Connecticut to adopt this technology to make sure that they feel safe, and the recognition that the intervention here should be no more expansive than necessary to achieve that. And that's why I think the focus on the intersection between the company that's providing the service and the consumer that's getting that service is the right nexus for regulation about AI.
So I guess to put it a different way then to you, there are certain obligations we think, right? There are certain things that we feel need to be met. So would you say an approach then where you just said the deployers and developers need to figure that out contractually? If we laid out the things that we felt needed to be done, right, to ensure that there were no, we avoided the algorithmic bias or discrimination. So we laid out, impact assessments need to be done. There needs to be transparency. And then we leave it to the customer and the company they're purchasing from to decide who does what, knowing that it has to be done.
Yeah, I think that allows a lot more flexibility given that we honestly don't know what the specific uses are going to be here. And they're going to be much broader, no doubt. They're going to be much broader than the uses that we're sort of envisioning right now. Right now, mostly people think about chatbots and medical and maybe some transportation. But I think we don't really have a good idea about how deep this technology is going to be embedded into society. And so I think it's really important to preserve that flexibility so that those arrangements can be made in ways that make the most economic sense and that best match the risk profiles of the different types of uses, rather than sort of mashing everybody into the same regulatory box, even though their risk profiles could be really different. And my concern here isn't just over-regulation. Some of it's under-regulation. There are certain types of uses in which the framework here might not be enough, right? There might be something that's like much deeper that we might need to do. And I would want, if we focus on the nexus of where the harm can happen, I think we can allow the companies who have an interest in serving their customers to really figure out with their suppliers what the right restrictions are.
Can you give examples of areas where you think we may have under-regulated?
Well, I mean, I think there's lots of stuff in, it's a great question because the bill is not specific enough to areas to say whether or not, a set of impact assessments would be enough for, say, some sort of human enhancement through AI technology. But because it's not detailed enough, I don't know, and it's not sector specific. I don't have some great examples that this bill doesn't touch. But I do think that by saying, as you said earlier, that, hey, we've provided clarity by saying if you just follow all this procedural work, then you you're not in violation of this rule. I think there will inevitably be cases in which people check all the boxes and consumers are still harmed.
Agreed. And I think that the future, I don't think that the third-party audit industry is there yet. There has to be a way that we can incentivize, just like for financial, right? We had a CPA come before to testify. They can't find auditors. There really isn't an industry yet for auditing AI systems, which I think is the future. But, and I also agree that the future of AI regulation is industry specific. We are going to need domain specific knowledge. We're looking at broad guardrails, right? And we keep hearing that term in Connecticut. People want to preserve our financial, fiscal guardrails. We want some AI guardrails on there to protect in broad way and try to make them flexible. But again, recognizing we're not etching commandments in stone tablets. We're writing laws. We do an alcohol law every year in Connecticut. Alcohol is thousands of years old. So this isn't a one and done, right? We know we need to maintain an ongoing conversation. Other people, I guess, let me see if anyone else has a question for you. And I would say, again, my belief is that regulation, and I look at this as more guardrails than regulation, and is not the regulation and innovation can go hand in hand. I think if you give guardrails, people want to know what they can and can't do. And businesses want certainty. If you look back at, anyway, they'll always talk to us about predictability, right? Businesses want predictability and certainty. Boston Consulting Group last year, their survey of businesses, 62% said they were holding off on fully investing and embracing AI until there were clearer government regulations. So I think the longer we delay this, the more we're putting off yielding the full benefits. But I think our goal is to find something that is not stifling but provides protections. So
definitely share that goal.
Yeah. So with that, thank you for testifying today.
Thank you.
Next, Tim Phelan.
Good afternoon, Senator Maroney, Representative Lamar, Senator Ciccarello, and Representative Retigliano, and my other friends on the General Law Committee. I'm Tim Phelan, President of the Connecticut Retail Network. I'm here today to testify on two bills very briefly as heeding what Representative Retigliano said earlier. You have my testimony, so I'm not going to read the testimony. I won't even summarize the testimony. I will just say, first, with respect to Senate Bill 2, the AI bill, that we want to continue to work with you, Senator Maroney, and other interested members of the General Assembly on that issue. AI is used in retail operations, and we want to make sure that whatever efforts you're making on this issue, that we work closely with you as it moves along. With respect to Senate Bill 1356, I think my testimony outlines our concerns about this bill. Reasons why we question as to whether or not it needs to be amended, and then we outlined three key areas that are of interest to us. So I will conclude my testimony there and be happy to answer any questions you might have.
Okay, great. Thank you very much. I was just reviewing your written testimony.
I would think by now, Senator Maroney, you would have had that committed to memory.
Yeah.
That's quite all right.
I should have used Notebook LM, the Notebook LM, and listened to it on the way up. So you mentioned in there, we're not social media, right? When we talk about the knowledge standard.
Right.
So and this is something I hadn't contemplated before, so I'm thinking out loud. Should we be bifurcating the knowledge standard?
I mean, we don't think actual knowledge applies to what, how we do it. So that's your call, but I don't want to throw the social media companies under the bus, but I mean, we're concerned that, we're not social media companies because customers don't come to our websites for those purposes. So we believe that, in the iteration of the bill, when we first adopted a couple of years ago, we worked very hard around that language and thought we had come to a good place, and our membership is comfortable with that and would be comfortable if that did not change.
Yeah. And agree why we're changing. We were the fifth state. They're now 20, 21, depending on 19 to 21, depending on how you count. Some people count Florida, some people count Washington, some don't count either.
We were the model state, though, Senator. We were the state that really, as you recall, Virginia, we did it better than Virginia, and then everybody else wanted to follow our lead. So we're as part of the business coalition that worked with you on this bill, we were very proud of the end result of that. And, we think it just needs a little more time for folks to get adjusted to it.
Right. Well, and I would just point out the AG's report on their issues with being able to enforce. That's part of the impetus for the changes, as well as a lot of the other states have made. There's only one
But
change
just because the other
here.
states have made changes doesn't mean they've made the changes that are good changes.
It's a fair point.
So.
Another issue where I would just ask you talk about the data, unless it's proportionate to provide and maintain a product or service. So there was one person who testified that there should be a stricter standard for collecting the sensitive data versus the other data. Would a bifurcation like that satisfy some of your concerns? And obviously you need to get to your members.
Yeah, I think I'd have to look at that a little more differently, and bifurcation of that a little more differently. I would just say again, as we've always said in this debate, our relationship with customers is first and foremost. So we don't, data minimization is important for us in the sense that it's the way we communicate with you. And if you, are looking for coming to our website to look for one particular tie, and then we end up showing you a shirt that could match that tie, we don't think that that's a bad thing. We think that's you as a consumer can decide whether or not you want to continue to receive that by continuing to shop with us, or asking us not to do it, or opting out, or just shopping someplace else. We'll get that message. But that's our sort of That's the relationship that we have with you.
And I think Senator Ciccarella has a question.
Thank you. And you just mentioned a couple of years ago in 22, we did a data privacy bill, and we had some concerns from industry and maybe unintended consequences. I think we all agree up here certain data and personal information should be protected, and we need to do our part in protecting that information for uses that might not be to the benefit of the individuals that have their information out there. So, you know, I had concerns and heard concerns from industry, and we worked together in 22 and tried to address those concerns. And now we're looking at this. Where do you really see the changes from what we have right now in place, and with this legislation in front of us, the unintended consequences? You know, can you just speak to your concerns and your industry concerns implementing it, implementing this language compared to 22?
Well, I think I've outlined 3 of them in my testimony, and I would also just say in general, we feel like, as I said earlier to Senator Maroney, we worked very hard and closely with this committee and with Senator Maroney to craft a bill, and some things like actual knowledge versus willful knowledge. I mean, even around the compliance requirements for small businesses, that being lowered. I know, Senator Maroney, we've talked about this a lot. You know, compliance costs were a big factor in our opposition to it originally, until we all came around and decided that, not decided, we all worked and realized it was a time to you know, the time had come for the bill to pass. So I guess it's more broadly, we don't see the overwhelming need to make changes to what we thought was model legislation that was adopted a couple of years ago.
Sure. So the main concern is from the 22 legislation at 100,000 to this current legislation at 35,000.
35, that's a big jump. I mean, 35,000 for a small retailer is not a lot of hits on a website. So then you're going to have a lot of those independent mom and pop stores that are in restaurants and others are now going to have to make sure they comply with this. And, you know, there's going to be compliance costs.
And that was going to be my next question is any idea of what that would
I
be?
don't. I mean, I would assume they would reach out to a lawyer, and I know, Senator, you've talked in the past about working with the AG's office and maybe putting some stuff on the AG's website about easy ways to comply. But in any event, they're going to have to do something in order to make sure that they comply with that.
Sure. Thank you for answering those questions. And you know, I'm sure, and James does a great job of addressing people's concerns and trying to find strike that balance, being able to accomplish, you know, the intended goal without the unintended consequences. So I'm sure we'll continue our conversation here. But again, we don't want to hurt business. We talked about this a lot with a couple other bills that were before us. And we want to make sure, again, that the unintended consequences, not only to small businesses, but information that is utilized for daily business in certain industries, that there's protections for those that aren't, you know, going to be used for maybe marketing or other things. And hopefully we'll continue those conversations and address some of those concerns.
I hope so. I really do. And Senator Maroney, I know as the Senate co-chair of this committee, you take a big responsibility on this issue. And Senator Ciccarella, I appreciate your comments, but I hope we can continue to have a dialogue on this bill, because not all of our members are part of national groups that follow bills in states. Many of our members are not part of the State Privacy Coalition. They rely on me in Connecticut. So I hope we could keep the door open and keep having conversations about this and the AI bill.
Great. Are there any further questions? Okay, thank you. All right, next, Crystal Weiss.
Hi, good afternoon.
Hi, please proceed.
Good afternoon. I'm Crystal Wise. I'm the Innovation Policy and Program Manager for the AFL-CIO Technology Institute. We are affiliated with the AFL-CIO, a federation of 63 unions that represent more than 15 million workers across the country. We're looking to make sure that technology works for workers. We've heard today how the AI industry is rapidly transforming workplaces, and it's currently workers are unprotected from surveillance, from privacy invasions, from discrimination and the erosion of labor rights. And despite some claiming that We don't know yet. We are very aware because we hear about it from workers all over the country. And there are academic studies proving that the threats are very real right now in the lives of workers. So to combat those harms, we're really grateful to Senator Maroney for his work on SB 2 and his work across the country to try to protect consumers and workers from discrimination and bias. We appreciate that workers have been brought into that process. It's very important that they are included, and so we appreciate those inclusions. We do have a broad framework for how technology should be governed, and those will be in my written testimony. We do appreciate the working to protect against discrimination and bias, that there's a need for broad definitions that ensure covered systems, especially around consequential decisions. There's been some really bad metaphors today about driving or things like that. This bill is specific to consequential decisions. These are some of the biggest decisions of your life. Will you get a job? Will you keep your job? So these are not just willy-nilly, which tie will you buy? These are major decisions that absolutely need to be regulated. It's also really important for this bill, which has some great provisions, to be effective, that the loopholes be closed up. So there's a couple of definitions that need to be strengthened, including making sure that consumer explicitly includes workers. Has been discussed earlier, the definition of substantial factor provides like a loophole for human rubber stamping. It's also really important that for this bill to have meaning and to actually incentivize the technological ecosystem of development, that there's really strong enforcement. And it can't be just reliant on the AG's office. It needs to ensure a private right of action. It can't just be about deployers either, because oftentimes deployers don't really understand, or even if they do have insight into how these algorithmic decisions are made. So it needs to be both developers and deployers that are held accountable, both by the AG and by a private right of action. We appreciate all the work that you've done to protect consumers and workers, and are looking forward to continuing to work with you. Thank you for the opportunity to speak today, and I'm happy to answer any questions.
Great, thank you very much. I was hoping to ask you a question, and again, if you're not prepared, or if you need to think about it and get back to me, that would be fine. Someone earlier had testified that in our definition of consequential decision, we say a decision or judgment. And they said that adding that judgment makes it more vague. So I went back and I looked at our definition of decisions that have significant legal consequences in our data privacy law, and we just say a decision. What are your feelings on saying just the decision versus a decision or judgment?
That's something I'd want to get back to you on for sure, to give you an informed response.
Yeah, great. Thank you very much. Are there any other questions? Okay, seeing no other questions. Thank you for coming to testify today. Thank you for hanging in till near the end of the day. Next, Todd O'Boyle.
Hello. Good afternoon, co-chairs Maroney and Lamar, members of the committee. My name is Todd O'Boyle, and I serve as Vice President of Technology Policy for the Chamber of Progress, a trade association supporting public policies to build a more inclusive society. Our corporate partners include companies like Google and Pindrop, but they do not have a vote or a veto over our positions. My colleague, Brianna January, sends her regards. She's a regular before this committee, and today she's here in spirit. We urge your committee to oppose SB 2 and SB 1356, which would regulate data privacy and algorithms. Each of these bills, however well-intentioned, risk being a major step backward, and even harming the communities they seek to help. I'll start regarding SB 2. I want to start by noting that we support SB 2's workforce development initiatives in Section 12, including the Connecticut AI Academy, partnering with higher education institutions to develop targeted programs will ensure that Connecticut remains competitive in the fast-evolving tech industry. Senator Maroney, earlier I heard you say something about an AI training curriculum in K through 12. That sounds like a great idea. I'd be glad to learn more about your proposal and help in any way I can. I'll say we've previously shared our belief that a better approach would be to focus on enforcing existing civil rights laws and filling any algorithmic gaps. to the extent that they exist. Today, I wish to focus on other issues. First, Chamber of Progress has modeled the auditing cost for the developers community at $224 million. Of course, significant updates to covered software will cause these compliance costs to recur. Additionally, we call on you to focus on public sector use of AI. As others have noted, the definition of consequential decision is quite broad, covering everything from workplace issues and educational assessment to insurance. We repeat our call for you to start by considering whether and how to regulate AI use in the public sector. Particularly, a good place to start would be the criminal justice system. Turning to SB 1356, Chamber of Progress supports strong privacy protections. In fact, we value Connecticut's work to enact them, a framework that strikes a careful balance between thoughtful consumer safeguards that can be implemented without slowing innovation. And we regularly suggest other states follow your lead. And we note that some change is welcome. The disastrous Dobbs decision highlighted the need for strong privacy protection, and to that end, we applaud your inclusion of explicit reproductive health language in SB 1356. However, I am concerned with the new definition of no moves away from the time-tested actual knowledge standard and may open the door to age assurance or explicit age verification. Age assurance technology is still maturing and has notable shortcomings. Among them, it's been shown to suffer from skin tone bias, where fairer skinned people are interpreted as younger and darker skinned people are interpreted as older. And for its part, age verification creates unacceptable privacy, cybersecurity, and ransomware risks. We've repeatedly noted before the Joint Committee, parental consent can be weaponized by guardians in contentious custody disputes. We reiterate those concerns, but I want to highlight today something new, specifically how parental consent can be weaponized against their dependent minors, by parents against their dependent minors. For example, granting parents an uncontestable right to compel platforms to unpublish a dependent minor's social platform account creates unacceptable risks for LGBTQ teens who are living in unsupportive households. For many, the internet is one of their only reliable social supports, and as drafted, SB 1356 would allow parents to deny them those critical supports. With that, I'll conclude my remarks and say I appreciate your time today and look forward to answering any questions you might have.
All right, great. Let me start by saying that is actually existing law. What you're commenting on that went into effect in October 1 of 2024 in Connecticut with the unpublished, and it was basically an opt-out versus the opt-in requiring parental consent. The change would be that you wouldn't require the parents to have to create an account to exercise that, which is similar to in other places. We say if you have an account, we can require people to use it to exercise their rights, but you can't require people to create a new account to exercise.
I appreciate that clarification. Thank you.
The other thing is focusing on public sector use of AI, Senate Bill 1103, 2023. We did regulate public sector use in Connecticut. You may want to look like we focus on transparency and accountability. On our CT Open Data website, there have been 2 years of inventories of where we're using AI for making these consequential decisions. You can find that information on the Open Data website, as well as our policies regarding the use and the impact assessments that are required. So we have put those laws in effect on our state government. Going back, you said to focus on enforcing existing civil rights laws about discrimination. You frequently, I shouldn't say, I apologize, I shouldn't say you. In previous testimony, your colleague had referenced LGBTQ plus protections. So I think we want to ensure those protections are available in existing law. Have you seen the Illinois employment discrimination law? And I'm wondering what you think about that law, which is an existing law. It was modified to say you cannot use AI to discriminate.
I'm not familiar with that. I'm happy to review it and share my thoughts at a later date.
Okay, thank you. And then I know you did testify in favor of updating our CUPPA to say that AI is not a defense for discrimination, which did allow for a private right of action. So are you in general in support of a private right of action, or is it only in that one instance?
No, I may have. I think
And
there
I'm
may be
not
a
saying you, I mean
misunderstanding.
the Chamber of Progress. I apologize.
Yeah, I think there may been a misunderstanding. No, I would not characterize our position as in favor of a private right of action.
Okay, but you testified in favor of a bill that allowed for a private right of action.
I'd have to review our testimony on that bill as I didn't deliver it.
Okay, great. All right. Thank you very much. Are there any further questions? Okay, hearing none. Thank you for coming to testify and thank you for hanging in. We're near the end of a not as long day as I thought it would be. So. Next, Adam Thierer from R Street.
Thank you, Senator, and good afternoon, committee members. My name is Adam Thier, and I'm a senior fellow at the R Street Institute, where I cover emerging technology policy. SB2 is of particular interest to our organization because the bill represents a major effort to regulate artificial intelligence systems in a way that we believe is highly burdensome and which will undermine the successful policy model that gave the United States such a leading role in digital innovation globally. SB2 basically would import Europe's regulatory model to our shores. As with the European Union's new AI Act, SB2 is rooted in fears about hypothetical future harms associated with algorithmic systems that have not yet even been deployed or developed. As Commissioner O'Keefe correctly noted earlier this morning, quote, "We're trying to regulate fear of the unknown," end quote. And that, I believe, is a mistake. The paperwork hassles and regulatory requirements involved with the bill could have a profoundly deleterious effect on innovation, investment, and competition throughout Connecticut and the nation. The bill contains confusing open-ended provisions that would create formidable compliance headaches, especially for smaller digital developers and companies. Only the largest tech companies will have the money and lawyers to afford the significant compliance costs associated with the regulatory regime mandated by this bill. Connecticut should not be imposing many new layers of preemptive paperwork requirements on digital entrepreneurs based on the mistaken assumption that AI systems are inherently dangerous or discriminatory by design. Instead, there are many better ways for Connecticut to address concerns about AI systems, including the many civil rights laws and consumer protection regulations already in place, not just within Connecticut, but also at the federal level and in other states. Excessive and premature overregulation of AI could also undermine many life-enriching innovations, especially in the field of healthcare, as both the Connecticut Hospital Association and the Connecticut Children's Medical Center noted in their written testimony that they both submitted about the problems associated with SB2. Finally, excessive preemptive regulation for our still developing AI industry will also negatively affect America's ability to rise to the challenge posed by China as the Chinese Communist Party looks to move ahead of us in the race for supremacy in artificial intelligence and advanced computational capabilities. For these reasons, I encourage the committee to reject SB2 and work to find a more balanced and flexible AI model for Connecticut and the nation. Thank you.
All right, Adam, thank you for your testimony. Are there any questions? All right, I just want to push back on saying we're importing a European regulatory model. This is a bill. The regulatory pieces are approximately 30 pages. The European AI Act is about 300 pages. It allows for rulemaking. This does not allow for rulemaking. So what you see is what you get with this bill. It's based off of AB 2930. I think it was the year before, it was a different number. There was a Washington, D.C. algorithmic discrimination bill. I started talking with the Attorney General's office in Washington, D.C. in 2022. So this is not importing a European model. It's working on an American model. I would say it's not about the fears of the unknown. We are looking at actual harms that have happened. There is a 2018 lawsuit for a man in Connecticut who was denied his housing because it was based on the wrong data, right? Chris Peterson, there's an example of a man, I think it was before 2020, I can't remember the exact date, who was denied his housing in Washington. And it turned out it was based, again, on the wrong data. It was based on another Chris Peterson. In our data privacy law, we give you the right to access the data that has been collected about you and to correct it. We've added a section based off of the Fair Credit Reporting Act, passed in 1970s, early 1970s, as old as me, believe it or not, that says that you have a right in financial decisions to see what it was based on, if it's based on erroneous data, to correct that. That's all. We're looking to import that into areas where we have seen again and again, there are instances of discrimination. The Amazon hiring algorithm, 2014, it was based looking to hire a technologist. Since all the previous resumes, the majority were men. Again, the representative data, it determined they wanted to hire a man. And so any women who applied were not offered an interview, not recommended for the position. So I don't need to go on and on, but there are countless examples. So to say this is fear-based and on the unknown is just not accurate. So how do you recommend we address these known instances, and in which cases do you think we need to act?
Senator, I have no disagreement that algorithmic systems can create real-world harms, and some of the ones you've identified I have investigated and written about. And the reality is that we should go after bad actors, and we should throw the book at them. But the book should not be a preemptive sort of regulatory regime based on sort of having an algorithmic pre-crime unit that sits around and determines whether or not we can stare into a crystal ball and sort of predict the harms of the future. We actually have remedies when these harms come about. We need to allow those remedies to do their job. We can search for it and do a gap analysis to figure out where we need to improve them potentially or add additional penalties. But the reality is you don't want to have that crystal ball gazing exercise where we look around and treat everyone as guilty until proven innocent, or else we're going to end up just like Europe, and we will not get a more innovative economy that benefits consumers and our nation in the great AI race.
So you're recommending a reactive approach rather than looking forward?
That's the approach we've used for the internet and digital commerce, and of course, a whole host of other sectors. Unfair and deceptive practices, civil rights laws, contract law, a variety of other mechanisms. Yes, we can have targeted mechanisms and statutes for certain sectors, and we develop those. We have sectoral approaches, both federal, state, and even local, to address more serious concerns. We can have that conversation, but this is a broad-based effort to have general purpose regulation of a general purpose technology. And that's a surefire way to undermine that technology in a very nascent stage. And that would be incredibly dangerous if that vacuum then gets filled by other autocratic nations who rush in with better, more superior systems, as China has just done. Last month, we heard about the DeepSeek moment with all of their new technology flooding the market. They're not going to be following SB2. They're not going to be following American law. They're going to be doing their own things. So we've got to make sure that we can stay competitive in that race and not shoot ourselves in the foot as it gets started.
You reference social media and the internet. Do you feel we should have put regulations in place on social media?
I think we do put regulations in place on social media, and we should go after people who commit crimes in any sort of digital environment using any computerized technology, period, full stop. But should we have 1996? I was there present at the birth when the Telecommunications Act was signed into law, and I worked at it in the mid-90s. We should not have had a comprehensive licensing regime for all online speech or commerce. The Clinton-Gore administration made a very smart decision to make a very different approach than we had had for other previous technologies like broadcasting and others. We had a more reactive approach, it's true, and it wasn't perfect. It's not been all sunshine and roses. I would never say that. But the reality is, no, we should not have had a preemptive fear-based regime that basically licensed and locked down all online content or determinations or commerce online.
Do you think there should be a federal data privacy law?
Yes, we do need a federal data privacy law. For no other reason, we got to make sure we clean up the patchwork mess that's been created by all the states doing this. And I fear that that's exactly where we're going with AI law. I think you've probably read the recent Colorado task force report after they passed their AI law, Senator, which basically came to the conclusion we can't figure it out. We cannot figure out how to answer some of these problems that they said they were going to answer after the law was passed. And Governor Polis said, this is a real mess and we need a federal preemption framework for this. They said they'd try, but they've not come to any conclusion. We're going to have some sort of a federal baseline privacy approach and AI approach eventually.
Now, you mentioned to lean on existing laws. Have you reviewed any of the Attorney General's opinions that state that you do need to do testing on bias? The New Jersey Attorney General for the laws against discrimination, the Oregon Attorney General, the Massachusetts Attorney General.
Yes, indeed. And they're making a fair point. Look, there can be arguments made about the need for greater transparency and best practices to be developed to make sure that we can identify where some of these harms do come about. I just have to say, though, that there's a difference between doing that in a more flexible kind of best practice oriented way versus the kind of regimes that we're setting up, which are very technocratic, top down, preempted by design with all these algorithmic impact assessments and everything else. That the compliance burdens and the sort of regulatory approach that we're setting up there, we're setting ourselves up for real trouble. Again, we can talk about improving UDAP authority, unfair and deceptive practices authority, and civil rights approaches. This is a constant struggle as new technologies evolve very rapidly, but we shouldn't throw that model out. And we should understand the consequences and the costs associated with the new sort of regulatory regime that we're talking about.
Have you reviewed the NAICS model bulletin for insurance, which is, again, it's updating the Uniform Insurance Practices Act and making explicit what others have said is implied for the UDAP or the Uniform.
Yes, and of course, let's be clear that the insurance model is a sectoral model regulated differently than most of these other sectors and technologies, as is healthcare and many other sort of autonomous systems. We already have, for example, a separate body of essentially AI or autonomous regulatory law for drones, for driverless cars, for advanced medical devices, AI medical devices, and for insurance. And so we're going to continue to have those sectoral approaches. I'm not arguing against them. But this is very, very different than what we were discussing in SB2 and in all these other state laws. General purpose technology regulation. It would be to say, like in 30, 40 years ago, we're just going to have general purpose computational law and then have algorithmic impact assessments for everything that happens using a PC. We don't want that regime. That would not have given us the digital revolution and the PC revolution.
So you mentioned transparency before. Do you think there should be transparency requirements? Because how are you going to utilize existing laws? Two things. One, if you don't know that AI is being used to make an important decision, but two, because of the black box nature of the way the decisions are made, if you don't have any insight into how the decision was made.
Well, certain transparency requirements are understandable, and I understand certain types of requirements being necessary, especially as part of data security, data privacy law. It is a difficult line drawing exercise. We do not have perfect transparency for every so-called black box system in existence today. I mean, every time you get on a plane, Senator, we obviously are flying in a system that's very much driven by autopilot. And yes, it is regulated, but the reality is we don't have transparency requirements all over the place saying autopilot is on now, right? Do we need that sort of perfect level of transparency? We don't have perfect transparency for everything that happens within all of our digital systems. And so you do need it for certain sensitive matters. I understand that. But again, the reality is that we can address the actual real world outcomes. This is what Commissioner O'Rourke talked about this morning when he talked about don't regulate fears, he said, quote unquote, regulate outcomes. That's the single defining principle that we should regulate AI by. Looking at real world outcomes and harms, not inputs or hypothetical problems on the front end. Let's make it about the real world.
So you were advocating for remediation over regulation, letting people, let's see what harms come and then
Well, Senator, remediation involves regulation. And let's not forget, we're not even talking about legal action in our courts. We have the most overly litigious society in the whole world. We have many mechanisms to correct for harms and problems as they develop. We also have other bodies of regulation we never discuss. I'm a big fan of, for example, recall authority and the ability for regulators to pull back products off the market after they've been shown to actually have some problems. But the key part of that model is that regulation is ex post and it involves actually allow innovative products to get out there in the real world and see what happens. We don't bottle them up on hypothetical fears and say, oh, what might happen if we allow that into the wild? We allow it. And then we make sure we address it and hit them with the books if something goes wrong.
Great, thank you. Well, I'm just going to go back to your analogy to the plane. And I think that, again, I'm going to what I believe in is a risk-based approach, right? Planes are tested before they're flown. They're tested at a higher level than cars. Cars are tested before they're driven on the roads. They're tested at a higher level than bicycles, right? And so if you're making an important decision about someone's life, we don't say you need to regulate chatbots, although I think there are good arguments based on what happened in Texas and in other places where chatbots went off the rail for regulating them, but lower risk cases where you're using AI to make yourself more efficient, to improve tasks, we're not regulating. We're looking to put in guardrails when you're using AI to make an important, sometimes irreversible decision about someone's life. And again, I'm not saying not to use it. I personally want people to use it. I want to embrace AI. We're just saying stop and test it like you test a car, like you test an airplane, like you test, my grandparents made toggle switches, like we tested the toggle switches before we shipped them.
Yeah, and indeed, we have a sectoral approach for certain high-risk categories of technologies, but it's a very limited approach in terms of how aggressive we get with these things. Even with regards to AI, ML-related medical devices right now, our Food and Drug Administration at the federal level is trying to have a more relaxed approach to make sure that we have life-saving, life-enriching drugs. And we have to make sure we don't overregulate when we take those sectoral approaches. Why is it that the Chinese lead the entire world right now with DJI leading in drones and other types of robotic technologies? It's because overregulation of autonomous systems have made sure that we don't have an autonomous, flying systems market in the United States. We overregulated that. And I could go into many other examples of this where we got it wrong, where AI right now, or autonomous systems at least, are highly overregulated, and we need to relax those rules. So we have to have some balance here and understand it's got to be targeted, sectoral. Yes, I understand some precautionary rules here and there, but the reality is even those can go too far sometimes.
And I would argue that we do have some good automated flying technology, especially, being the home to Sikorsky and an electric boat. But I know the technology is employed by Sikorsky and in our defense industry. But thank you very much for taking the time to come here to testify.
Thank you.
Today. I don't know if I see any further questions. So thank you.
Thank you.
Next, Bethany Perriman. Okay. Next, Rock Vital. Okay.
Good afternoon.
Hi, Rock. Please proceed.
Okay. Chairpersons and esteemed members of the committee, thank you for the opportunity to testify in support of SB2, an act concerning artificial intelligence. My name is Rock Vitale, and I'm the founder of Easy, an AI implementation company that has been working in the field since 2018, long before ChatGPT and other AI tools were mainstream. Easy helps businesses implement AI systems for automated data extraction from documents to support compliance in regulated industries like insurance and finance. We also have supported major university research by using AI to extract data from historic primary source documents. I also serve as the chair of the Technology Council for the Greater New Haven Chamber of Commerce. SB2 is a critical step in ensuring AI is used responsibly while allowing businesses to continue to innovate. Some have suggested that the bill mirrors the EU's AI Act, imposing heavy-handed regulations. This is misleading, as SB2 is tailored for the U.S. business environment, and even major AI companies have called for greater transparency in AI governance. The idea that this bill stifles innovation appears to come from a misunderstanding of how AI systems are already used in practice, rather than specific provisions in the bill itself. As a small business doing engineering work in AI every day, I appreciate the thorough discussion today, which is critical to this process, and I want to highlight a few key points that have not been fully addressed. Number one, impact assessments for developers and deployers of high-risk AI systems are critical. AI influences hiring, lending, healthcare, housing, and many other key areas. Businesses using high-risk AI should evaluate risks, and many leading AI companies, including Microsoft, OpenAI, and Google, already conduct AI impact assessments and bias audits as best practices. The free market alone does not prevent AI from making discriminatory decisions, as seen in past cases of biased hiring, sentencing, and lending algorithms. Number two, minimizing algorithmic discrimination is essential. AI systems can reinforce biases if not properly tested. Today, not in the future or hypothetically, we've seen what happens when unfiltered AI systems generate racist and discriminatory content, such as the recent release of Grok 3 by xAI. Some argue existing anti-discrimination laws are enough, but those laws were not designed for AI-driven decision-making. AI bias can be hidden, which is why proactive assessments are necessary. Number three, transparency in AI interactions increases trust. Individuals should know when they're engaging with an AI system rather than a human. AI that operates in the shadows erodes public trust, slows adoption, and actually harms innovation. At the same time, I encourage the committee to consider deeper exemptions for small businesses. SB2 already includes education and phased implementation for small business, but compliance requirements should be truly proportional. AI should not become an area where only the largest corporations can afford to compete due to regulatory complexity. I'm also glad to see Charter Oak State College included in the bill. Its partnership with Google to launch the Connecticut Online AI Academy was a great first step, and SB2 further expands AI training to build an AI literate workforce in Connecticut. In closing, AI is one of the most transformative technologies of the century, and Connecticut has an opportunity to lead in responsible AI adoption while preparing its workforce for the future. This bill strikes the right balance between innovation and accountability, and I support its passage. Thank you, and I'm happy to answer any questions from the committee.
Great. Thank you very much. Senator Ciccarello.
Thank you. I just have a quick question for you. Easy, you're the CEO of Easy,
Yes.
and can you explain, like, what do you guys do? What kind of a service do you provide?
So we do implementation focused services for automated systems. So we're primarily right now working in AI implementation for extracting data automatically from documents. So we've been working in insurance and finance to help compliance teams extract data automatically to speed up processes. And we've also participated in research to help universities extract data from primary source documents to research topics like historical protest dynamics, for example. But long story short, we're implementing AI and automated systems for the private sector and the public sector.
Thank you. So almost like a Zapier, making like a shortcut and just basically be more efficient for companies. That's pretty much what you provide for a service.
Yeah, so we're generally service agnostic. We do have some of our own proprietary algorithms, but we do also implement third-party systems as well. It's pretty configured to the use case for the client. But Zapier at sort of higher volumes is not the most business friendly, but similar for sure.
Got it. And would your company provide this type of checks and balance for small business to make sure they're in compliance?
So we, as a service provider, would not be doing impact assessments. Rather, we would be participating in helping companies implement systems which may be subject to the requirements of the bill.
Got it. Because I was just trying to determine what the cost would be to companies to make sure they're gonna, be within the guidelines of this legislation. I'm just trying to determine what that cost would be for certain size businesses, small, medium, large. And I'm just trying to figure that out. I didn't know if you could answer that question.
Well, and that's where, when I'm looking at the existing exemptions for small businesses, I know that it does include some phased implementation and education for smaller businesses. And what I would say is just providing more sort of detail on what the exemptions could look like, or come up with more of a framework for compliance requirements for small business, maybe a revenue-based or employee-based exemption threshold, and just having more technical guidance and maybe even templates for compliance, because I know that's sort of a major issue that can hinder small businesses, but as some people have pointed out, not hinder larger businesses. So I know there have been some exemptions in the past iteration of this in the last legislative session. So, to comment on the cost or sort of the methodology, it's sort of hard to say.
Okay. Thank you very much for taking the time to testify and answer my questions.
Thank you. Rock, you discussed the impact assessment requirement. Do you use any algorithms, or have you also mentioned you had some proprietary algorithms? Are there any you use that you have run impact assessments for? And can you just walk us through that process if you have?
So generally, when we're using our systems that are in production right now, we do different types of testing on it. In terms of the sort of impact testing, generally we are relying on sort of the standing on the shoulders of giants phenomenon, where we are using, in some cases, systems like Google Gemini or OpenAI, or in some cases, the Anthropic suite, where, as a small business, we're largely leaning on sort of impact testing that they've done. In terms of the sort of testing that we do for models to try and come up with edge cases, we do try to, essentially break them in terms of how we're interacting with them. We try and get them to perform unexpected outputs. And to the extent that we can, we try and put sort of performance requirement or performance controls in place. But in terms of sort of formal impact assessments and what we're talking about that would be required in SB2, outside of this sort of destructive testing, it's, I would say, less sort of systematic than it could be if there was more of a framework in place. But largely we are relying on the sort of larger scale corporate impact testing that's done at this time.
Okay, great. And I like your idea of the templates. I think that especially if we're giving a rebuttable presumption that you've done what you need to do, if you've run an impact assessment, I think we probably should ask the AG to have samples of what that minimum impact assessment would look like, or creating other tools. Now, so I like your idea on the technical guidance and templates for compliance. Deeper exemptions for small businesses. I guess of two minds here. I'm going to be honest. Like, I think that when you look at TREGA, the Texas Responsible AI Act, and the Texas Data Privacy Act, they exempt anyone who's defined as a small business under the SBA. Actually, and the Texas Data Privacy Act points to an important thing. It's not always the strength of the law, it's the strength of the enforcement. Their AG has a lot of money to enforce, and even though our law may be seen as stronger, they're doing a lot of enforcement on their data privacy law down there. But anyways, I'm not sure about a blanket exemption because, again, if what we're looking at is trying to protect against disparate impacts and discrimination, I don't know if just because you're small, you should be allowed to discriminate, right? However, that's one concern. But the other concern is the recognizing that small businesses aren't going to be able to implement the full NIST risk management framework, or they may not be able to. So I'm wondering if, and you may not be able to tell me this now, what are the pieces that are the most onerous, right? That you would say that a small business may need to be exempted from. And then I would also just point to, we don't give a specific small business exemption this time, but instead we give what I call an off-the-shelf exemption, whereas if the developer contractually takes the liabilities. So if you're using you're screening tenants, and the company that has developed the software takes on the liability, then you're no longer liable as a deployer. And last time we set that at 50 employees. This time we just said as long as someone's liable, it doesn't really matter to us, right? If someone's taking on the liability. But I don't know if, and it may take you time to let me know, one, if that off-the-shelf exemption you think suffices, or two, if you could just look through and point to things that you feel would be particularly onerous for a small business.
Those are great points. And I think that there is a lot to be said about when we're talking about people using AI systems, large and small businesses, even businesses that have their own systems, many of them are actually using the frontier models that I mentioned. The majority of businesses that call themselves AI companies are actually using the OpenAI, Google, or Anthropic suite, and as well as some open source tools like the Meta products. And I would say, like, in terms of the sort of passing the burden from deployers to developers under certain conditions, that would definitely be helpful. I'd say one of the more onerous requirements is just understanding, like we kind of already touched on, exactly what the impact assessment requirement would look like and exactly what compliance would look like. So a compliance checklist, like we said, assessment tools that might even be available for free for people, things like that, where you can kind of generate these compliance documents and comply in a sort of lower cost way, I think would be really helpful. Just saying, here's exactly how you do it. And then sort of besides that, I think having as clear a possible definition for high risk AI use cases as possible. So, if a company's using AI internally for efficiency, rather than making these consequential decisions about people's lives, just making sure that's as clear as possible so that, someone doesn't necessarily have these requirements or think they're subject to these requirements when maybe they're actually not. Because I think the other key point is that we're talking about these high risk use cases rather than, say, someone using ChatGPT to write an email.
Right. And agreed. We have to get the definition of the high risk use cases. And I think there are some free tools. I think it's just we have to identify them and make sure that perhaps we have the AG put links to those on their website. I know CIO.gov has an impact assessment, or it used to. I haven't looked in a while. Canada, I found one, and one of the universities has some free impact assessment tools as well. So, but you're right. I think technical guidance and templates for compliance would be are something we definitely need to look into. All right. Are there any other questions? Okay, hearing none. Brock, thank you very much.
Thank you.
Next, Tanner, I believe. Okay, thank you.
Thank you, Chairman Maroney and Chairman Lamar, for the opportunity to testify before the General Law Committee today against Senate Bill 2. My name is Tanner Jones. I'm a policy analyst at the Cicero Institute. Cicero does not represent any private companies. I'm here because our think tank advocates for founders and innovators and hopes the people of Connecticut will reap the rewards of innovation in the form of greater productivity, more consumer choice, and lower prices. The thesis of my remarks today is that where this bill sometimes succeeds diagnostically, it fails prescriptively, and there's a better path forward for AI law in Connecticut. Once you create a new regulatory system, even with an implicit delegation, so I'm talking about the language of governance rules, rules of practice, issuing guidance to state agencies, and reporting requirements, those powers do not go away and only grow and metastasize over time. And there's reason to believe that this language will metastasize beyond its original intent in a particularly bad way in Connecticut. Recent scholarship from the University of Michigan Law School found that Connecticut's courts uphold one of the most expansive deference standards among the state courts in the country, meaning that even vague regulatory delegations or language like issuing guidance are bulwarked by a court system and de facto have the force of law, or at a minimum, deter investment and create market uncertainty. And the proof is in the pudding. It should be no surprise that indeed Connecticut currently endures nearly 100,000 instances of restrictive language in its administrative code, including so-called soft guidance documents, many of which lack express statutory delegations. One study found that over an 18-year period, overregulation in Connecticut contributed to 55,000 additional people living in poverty, a loss of 2,000 jobs per year, and 8% higher prices for the people of Connecticut. What I mean to say is that over time, even the best intended regulatory frameworks subvert the public will and interest and crush innovation. In the words of Nobel laureate American economist George Stigler, as a rule, regulation is acquired by industry and designed and adopted primarily for its benefit. This is for a couple of reasons. First is a simple question of access. While your constituents have access to you, it's only the most powerful and entrenched incumbent firms equipped to provide contributions and later job offers that have access to the regulators. And second is a simple fact of compliance. High risk and consequential decisions frameworks and reporting enable the largest players to bomb into states and find startups that are de facto non-compliant or even medium-sized firms that are challenging their market share and shut them down or entrench them in legal battles or force them into compliance, which crushes innovation. And the other point here is a simple one about uncertainty, which is that even if you were to resolve this set of issues, these expansive frameworks, the high risk and consequential decision-making frameworks, will simply trigger investor flight and an unclear path to investment and scale for firms within Connecticut. But fortunately, there is a better path forward, which is precise and tailored statutory interventions, not outsourcing to regulators, identifying gaps in the penal code and the product liability code to ensure that law enforcement and judges do not feel that there are ambiguities hamstringing them from going after AI crimes. Thank you for your time today, and I'm open to questions.
Great, thank you very much. Are there any questions? I think you mentioned the courts, the litigious nature. So I guess my concern is and you also mentioned it's better to be statutory than regulatory. So with having enforcement by the AG in Connecticut, everything has to be put in our statutes. A lot of the data privacy laws across the country leave a lot to rulemaking, so it's uncertain, right? And that's why a lot of people have pointed to the Connecticut model, because everything was in there. But my concern is if we leave it to the courts, right? I don't want to be mired in lawsuits and allow judges to decide how we should be can or can't use AI in Connecticut versus taking a proactive approach.
Yeah, I think that makes sense to me, and I may have not been as clear as I ought to have been. What I'm worried about is some of this language pertaining to issuing guidance to agencies, which will result rather in a set of de facto regulations as a consequence of the highly expansive deference standards in Connecticut today, meaning that, well, the bill might say one thing 5, 10, 20 years from now. What you find is that the new regulatory apparatus is actually only in service of the most entrenched incumbent firms.
Okay. Thank you. And I know, again, Connecticut, we are a little different than other states in that a lot of people have access to our legislators, where if we have people moving in from other states, when I call them or something, they're shocked they can actually talk to their legislators. So I think it's more than just the powerful and entrenched to have access to the process in Connecticut. I think I know you referenced the study on the regulations that says how many more people were put into poverty. I just would push back a little on that, in that I grew up in an area, I grew up the street from Long Island Sound, downwind from a power plant. you know, as a kid, Long Island Sound, you know, I couldn't see my feet when I was at my knees. My knees were a lot closer to my feet back then. And now the water is much clearer. I grew up in a neighborhood where, because we were downwind from the power plant, a lot of people died of cancer. I have family members who have obtained, you know, have different diseases that are triggered by the environment. So I think that we also, with regulation, need to look at, you don't want to be agreed, we don't want to be overly burdensome or too restrictive, but we have to recognize that there are regulations that have worked and have saved lives.
And Mr. Chairman, we're fully aligned on that. I agree with you 100%. The nature of this study was a synthetic control trial measured against a counterfactual scenario wherein a set of regulations had not been implemented. So it still would solve for the set of problems that you're addressing. But I think this is where the expansive bucket of high risk consequential decision making would constitute an overreach insofar as over time it enables these kind of capture moves to be made. Whereas if you went after a set of targeted interventions based on specific harms and gaps in the statutory code, I think that you could accomplish the noble goal of going after bad outcomes without inviting this set of rent-seeking behavior that we see basically every time a new regulatory apparatus is erected here and elsewhere.
So now it brought up another question. So the study you mentioned, did they use a digital twin? How did they simulate the outcomes?
I would have to pull back the methodology of the study, but typically the way these synthetic controls work is you would develop like a synthetic Connecticut based on a set of variables and then do robustness checks and this kind of thing. It's I would say a fairly common economic method in the literature.
Okay. Just part of the bill we do want to look at. And so in the EU or in Italy, the Emilia-Romagna region of Italy, they've developed a digital twin of their population so that they can actually test policy outcomes. And that's something that I think would be a valuable tool if, you know, you're referencing that study, but if as policymakers, we could test the outcome, potential outcomes. So they look at moving people out of poverty, but also at their concern there is landslides. Like we have a coastline, I have a coastline district. There's a lot of coastline in the state. So I think shoreline resiliency, it would be great if we could test before we invest money or put on additional regulations and know the probability, again, you never know definitively, right? But the probability that it's going to help and look ahead at the cost benefit. So that part of this is to look at creating that type of a tool. I would be interested in your thoughts on that.
That's really interesting. I'll have to dig in more to that case study in Italy.
Okay, yeah, it's University of Bologna. It's called the Amartya algorithm. They also have a supercomputer that they share out to local governments for using called Margarita. Again, and they're growing the not the margarita pizza, not the not the beverage that many people may be looking for after a long day of public hearings. So, but yeah, and again, that kind of points to, you know, for the AI businesses to flourish, you keep hearing it's three things. It's data, access to compute, so they offer that access to the computing power, and then workforce, right? And so we're trying to look at those issues to make us a leader in responsible AI. So with that, thank you very much for coming to testify to us today. And I believe that that's the last person on our list. Did anyone who wasn't Rachel Baird or Dylan or Chris or Herb? And is there anyone else who wants to testify? Hearing none, this public hearing is adjourned. Thank you. Oh, and our next, the date and, we don't have the date and time of our next meeting set yet. It'll likely be March 12th for our next public hearing. So thank you.